Cracking the Code, the third edition. Maintaining Fiscal Integrity, Functional Sovereignty. Caveat: this treatise constitutes neither the practice of law nor the giving of legal advice, and is for informational and educational purposes only. You are responsible for yourself and your own actions, and if you act on what you do not understand and cannot support through knowledge and ability, any adverse consequences you may experience are entirely a product of your own doing and omissions. The Preamble. For thousands of years, the legal masters of the world have been steadfastly constructing the system by which world commerce and law now operate. They have developed this system by drawing from and utilizing the timeless principles of human interaction that, over the millennia, have been discovered, distilled, and codified. These fundamental common sense principles of commercial law, expressed in the 10 maxims found below, underlie every other form of law in existence. There is no type of legal issue, controversy, dispute, etc., that is not covered and embraced by at least one of these 10 maxims of commercial law. The creators of the system have achieved preeminence by knowing these foundational principles of human interaction and encrypting them into codes for their own aggrandizement, while keeping the uninitiated ignorant of such knowledge and the means for accessing it. The pinnacle of these efforts is in the Uniform Commercial Code, UCC. All of world commerce now functions under and is thoroughly entrenched in the UCC. However, even though the UCC has been developed and formulated for accommodating mass exploitation and subjugation, it is but a particular codification of the universal underlying laws of commerce, and most importantly, can now be employed by the benefit of the layman now that the code has been substantially cracked. The 10 foundational maxims of commerce, from which all codes, law, and statutes are derived and based upon, are: 1. A workman is worthy of his hire. 2. All are equal under the law, both moral and natural law. 3. In commerce, truth is sovereign. 4. Truth is expressed by means of an affidavit. 5. An unrebuttal affidavit stands as the truth in commerce. Notes: fiscal, of or pertaining to financial matters generally. Caveat, Latin, let him be aware. In general, a warning or emphasis for caution. Commerce, any and all interchange between people, including but not limited by the activity normally associated with the term, i.e., the buying and selling, trading of goods and services, social intercourse, sexual intercourse, original meaning. All law is contract, and in every interchange between people, a contract is formed. All commerce is contract, a timeless and universal maxim of law. Contract makes the law. Law, the rules or body of rules defining who alleges possession of what right, authority for using deadly force, violence against another. For biblical origins, see Maxim of Commerce in glossary. 6. An unrebutted affidavit becomes the judgment in commerce. 7. A matter must be expressed to be resolved. 8. He who leaves the field of battle first loses by default. 9. Sacrifice is the measure of credibility. If one has neither been damaged nor incurred a risk, or is unwilling to swear an affidavit, i.e., true, correct, and incomplete, the commercial equivalent of the truth, the whole truth, and nothing but the truth, on his unlimited commercial liability for the veracity of his statements and the legitimacy of his actions. He has no credibility and therefore no basis for asserting claims, charges, or claiming authority. 10. A lien or claim can be satisfied only through rebuttal by counter affidavit, point for point, resolution by jury, or payment. The preface. The legal contractual status of virtually every man, woman, and child on the planet has become that of a slave, commercial chattel property, a hopelessly indentured servant in perpetuity. In commercial legal matters, there are only two kinds of people: debtors and creditors. It is an all or nothing affair with no middle ground. And if you want the power to exercise your innate sovereignty, you must access the agreed upon rules that provide for recognition as a sovereign creditor. The articles of the UCC. The program outlined herein is a system of simple contractual procedures providing the foundational steps for regaining control of one's commercial, legal, financial future, and brings forth the notion of functional, if not official, sovereignty. Fundamentals. Codified law is precise. It revolves around how words are defined. The rules of all forms of law are set forth in writing, words, syntax, grammar, etc. The way words are legally defined. Notes. This issue is profound. Not even known felons and perjurers are accorded instant credibility and take at their word if such will swear under oath against another. Career criminals, even suspected murderers, are taken at their word and put on the witness stand if it will serve the prosecution. When one swears under oath, one presumably invokes the wrath of God for bearing false witness, a dire transgression, from the reciprocal effects of which there is no escape, hence the credibility accorded anyone who so swears. For one group's formal attempt at cheating natural law and escaping any such wrath for bearing false witness, disavowing one's sworn oath. See Cole, Nadra, and Glossary. Slave, a person who is wholly subject to the will of another, one who has no freedom of action, but whose person and services are wholly under the control of another, one who is under the power of a master, and who belongs to him, so the master may sell and dispose of his person, of his industry, and of his labor, without his being able to do anything, have anything, or acquire anything, but what must belong to his master. Black's Law Dictionary, 4th edition, 1951. Chattel, personal and movable property, including slaves, i.e., permanently indentured servants. Commercial chattel property by virtue of contract, i.e., operation of commercial law. Commercial legal. Because the people of the earth have unwittingly bound themselves in unconscionable private contracts, and because contracts makes the law, the terms commercial and legal are essentially interchangeable. Courtrooms are private, commercial marketplaces enforcing private corporate policy and the administration of the court's business, separating its customers from the fruits of their labor, as well as dictating over customers' freedoms in action. The word debtor comes from the Latin debet, literally, he owes. The word creditor comes from the Latin credit, literally, he trusts. Sovereign, one who possesses supreme power of his own right, not under the power of another. Sovereignty, supreme dominion, authority, or rule. Black's Law 7C Sovereignty in Glossary. The way words are legally defined is the basis of the game. Words used in commercial legal matters have different meanings than the same words in everyday parlance. Deadly, destructive violence is attached with the words, and the meanings of said words, used in all legal documents and proceedings. In commercial legal matters, simply assuming that you know the meaning of a word can cost you dearly. It is vital that you know how the words being used are defined for any hope of knowing what is happening and why. Understand the meaning of the words, and you can go forward with confidence and certainty. Remain in the dark about the meanings of key terms, and you can lose the entire game in an instant. A glossary of pertinent terms with listings of key definitions. This process has been provided. The glossary can save you much time in your quest for understanding, and the value of its annotations cannot be underestimated, because contained therein are insights, code cracking not offered anywhere else. However, it is strongly recommended that you supplement your use of the glossary with one or more of the generally accepted law dictionaries, such as Black's, Bouvier's, and Ballantyne's. If you cannot afford it, get a copy of both the first and most recent edition, as well as others if possible. As you will soon learn, no law, code, statute, definition is actually ever repealed. There is an event peculiar with the UCC. In the case of a controversy between an existing law, code, statute, definition, one that has been repealed. The repealed law, code, statute, definition controls. See UCC Statute 1 104. Also, the difference between the first and latest editions reveals how the legal masters of the world attempt to guide the destiny of all by continuously redefining and confusing the meanings of commercial legal terms. In any event, find out the meaning of any term of which you are not certain. Do not take anything for granted. It is also recommended that you obtain a copy of the Uniform Commercial Code issued by your state, since the UCC reigns supreme throughout America and the world. All other codes and bodies of law are mere subsets of and encompassed by the UCC. See UCC 1 103. And since no part of the UCC, as well as all other bodies of law considered as supplementing the UCC, is never repealed, obtaining a copy of the earliest edition available would be a good idea as well. Universal commercial law is the functional common law of the planet and is ingrained in the articles and sections of the UCC. The entire civilized world, i.e., the cumulative mass of all governments, banks, courts, tax agencies, and corporations, now runs strictly in accordance with the rules of commerce as set forth in the UCC. Deal with the source, the UCC. Whereas the first two editions of this manual, of necessity, and because of the state of the art at the time of composition, dealt extensively with tactical measures for surviving the ever presented menace of the U.S. judicial and tax systems. This volume has rather simplified the entire matter and points the way for a more wholesome, uninterrupted style of living, free of the inherent guile, treachery, and larcenous practices of contemporary legal professionals, taxmen, and government actors, by thwarting meritless attacks from such would-be pirates before anything can get rolling. What you know can never hurt you. What you do not know, however, can kill you. A good source for a copy of your state's current UCC is West Group at 1-800-344-5009. The basis of the con. You've been deceived and betrayed, and ravaged of your own kindness and trust. However, by merely confronting the exact nature of the con, you can be free of it. Life no longer needs to be a dangerous and unpredictable affair. Without taking up historical and legal details in this juncture, which are thoroughly addressed and documented in the supplementing essays and treaties in this manual, and which are mandatory reading for a full understanding of what has happened in America, as well as in most other countries of the world, suffice it that you have been swindled out of nothing less valuable than your birthright, your sovereignty, by any insidious lexical artifice, corruption of your name. An ancient maxim of law states, in order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Whereas John Henry Doe would signify a true name written in accordance with the rules of English grammar and the prescriptions of law. John Henry Doe, in all capital letters, on the other hand, would not. A harmless variant of the original, you might say. A variant of the true name, yes. But the operative term is corruption, and it is anything but harmless. Names of men and women, and boys and girls appearing in all capital letters, and even abbreviated versions without initials, etc., of true names with initial letters, only capitalized, are corporately colored renditions of a true name and do not identify the being associated therewith. Such names represent property, specifically intellectual property, though this fact is overlooked by almost everyone in society, but the legal vampires whose existence is predicated on its exploitation. Corporate names. Checking your driver's license, credit cards, bank statements, IRS correspondence, traffic tickets, etc., you will discover that government agencies, banks, and other corporations, courts, and tax agencies deal with you exclusively through various corrupted versions of your true name. And these four types of organizations ruthlessly insist on dealing with you only via on in all caps other corruption of your true name in any and all key documents, contracts, accounts, and agreements with them. Their computers are generally geared, formatted for dealing with nothing else. It is interesting that the military, an aspect of government, also designates its personnel exclusively in all capital letters. As you have seen throughout your life, corporations spell their trade names in any format, in any assemblage of letters set in capitals, in lowercase only, intentionally misspelled with numerals, and even arbitrary non-lingual symbols that they wish. Sunoco, Citibank, U-Haul, Office Depot, Honda, Food for Less, Rite Aid Pharmacy, Kmart, Toys R Us, Hewlett Packard, Ford Day Tire Scouts, Visa, Yamaha, Sears, Compaq, Toys for Tots. Construction of these man-made corporate trade names is not restricted by the bounds of English grammar and the prescriptions of law because they are fanciful trade names, one-of-a-kind objects of intellectual property in themselves, and signify a unique artificial person, a legal entity distinct from all others. Even your personal computer spell checker acknowledges this fact. Type in any random set of upper and lowercase letters on your screen and verify spelling. Then change all letters into capitals and verify spelling again. No error will be indicated. Names constructed outside the bounds of English grammar and the prescriptions of law are corporately colored trade names. Legally speaking, there is a term that defines such entities: ens legis, defined as follows. Ens legis, L, Latin, a creature of the law, an artificial being, as contrasted with a natural person, applied to corporations considered as deriving their existence entirely from the law. Black's Law Dictionary, 4th edition, 1951. Notes: true name, one's given Christian name, plus the surname is the family name. A trade name can also be trademarked, service marked, and copyrighted by the owner for the purpose of restricting others from unauthorized use and unjust enrichment at the expense of the parties that invested in and built up the good name and reputation, goodwill of said trade name in the public mind. Statutory entities must follow statutory law in such matters. Living, breathing, flesh and blood men and women, on the other hand, need only claim, assert their copyright under the common law. Common law, as distinguished from law created by the enactment of legislators, the common law comprises the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity, and from the judgments and decrees of the courts recognizing, affirming, and enforcing these usages and customs, and in this sense, particularly the ancient unwritten law of England. Meet your alter ego. Everything has two inherent aspects: its physical, mental, spiritual manifestation, and the abstract label describing it. This situation is characterized in semantics as the difference between the territory and the map, i.e., the thing and its label, whereas water is tangible and can actually be experienced by the senses. The word water is only a symbol, an abstraction of the mind, and cannot be experienced, i.e., one cannot drink the word water. The mind is capable of imagining unlimited varieties and configurations of abstractions. These include non-tangible concepts and mental constructs such as the people, nation, corporation, limited liability, trust, and government, all entities, ens legis. Other legal terms describing fictitious entities are persons and artificial person. Such cannot be seen, nor touched, nor heard. Proper names set in all capital letters, such as the one appearing on your driver's license, are trade names and signify artificial persons. Your name, in all capital letters, is no different from that of any other corporate trade name and signifies a legal entity separate and distinct from you, the living, breathing man, woman, the corporate, banking, taxation, legal, governmental communities, collectively, the industrial community. Use this name exclusively when conducting business with you, via this name, and solely because of this special name. All manner of goods and services are conveyed, transmitted for your benefit by all artificial person entities, ens legis, in the industrial community. Such can interface with your straw man's all caps trade name, because all involved interested parties are artificial persons. Your role as a man or woman in this scheme will be revealed shortly, but at this point in this discussion, you are inextricably linked with your all caps strawman. Alter ego, a second self, an inseparable friend. In law, a person is not flesh and blood but artificial, a creature of law or contract, i.e., contractual aspect of an actual man, woman, such as a citizen, driver, an officer of a corporation. For a brief but thorough explanation of this phenomena, see transmitting utility and glossary. Your alter ego strawman is defined as a front, a third party put in name only for the purpose of taking part in transaction, i.e., a mere nominal party in a transaction. The legal term describing such an entity is stramanius homo, a Latin term defined as follows: a man of straw, one of no substance, put forward as bail or surety. Black's Law Dictionary, 1st edition, 1891. A nominal party straw man can be very useful because its creditor can then accomplish things in the name of the straw man that would not otherwise be permitted, e.g., secretly acquire property, do business with one's enemies, etc. A creator always puts forth a straw man for self-serving purposes, and is normally the only one that knows the true nature of the straw man. Outsider parties in a transaction usually believe that the straw man party is unaffiliated with other parties in the transaction, thereby giving the creator the advantage of an extra man on the field. When your true name, written in accordance with the rules of English grammar and the prescriptions of law, is corrupted into an all capitals letters format, a mutant straw man is created. The new all caps name is a legal entity, corporately colored, distinct from you, and is the only type of person with whom government, courts, taxmen, banks, and corporations will, in fact, can do business. If you do not believe this, just examine the documents you receive from these type of organizations, i.e. the Social Security card, court records, credit cards, tax bills, permits, driver's license, passport, bank statements, etc. All name entries are set in capitals exclusively, with the occasional exception of upper and lowercase abbreviations, i.e. initials, etc. And then usually only in correspondence when some corporate governmental entity is coming after you for payment, you will never see your true name listed as the account holder. Initial letters only capitalized. In the caption of their legal briefs, only the trade name of your strawman. Why? This is the only way they can do business. And that is exactly and only what it is: business. Many grammar books and legal publications identify permissible methods for displaying proper nouns, of one which is the U.S. Government Style Manual, a Manual of Style 2000, Chapter 17, Court Work, spells out with examples acceptable ways for presenting names, 52 variations in all, and never once recommends an all caps name format in court paperwork. Despite conspicuous absence of such mandate, the caption of every single federal and state, county, and city court brief, without exception, contains name of plaintiff and defendant, petitioner and respondent, etc. In all capital letter format exclusively, since there is no legal authority requiring that proper nouns, aka names, be set in capital letters. Why is this practice permitted, indeed enforced, excluding all others? The people of the world have been politically and financially ravaged because they do not know of their alter ego, public persona strawman. Bankrupt governments covertly create and use such strawmen, trade names, actually for the purpose of doing business with said trade names, without ever openly disclosing the practice, and siphoning wealth from otherwise sovereign men and women and conveying such proceeds into the coffers of their creditors, the masters of the Federal Reserve IMF syndicate. After redemption, i.e., after reclaiming your intellectual property, all caps strawman, trade name, you can use the strawman for your own benefit rather than endure its continued economic exploitation and the concomitant economic subjugation associated therewith. Notes: bail. One who becomes the surety, see footnote immediately below, for the appearance of the defendant in court. Surety, a person who is primarily liable for the payment of another's debt or the performance of another's obligation. Black's Law Dictionary, 7th edition, 1990. Likewise, any other upper and lowercase alternation abbreviation of the true name, e.g. John H. Doe, John Doe, J, H, Doe, etc., is also a straw man. Your true name is just that, your true name. Anything else, at least as regards the industrial community, is a straw man. For a comprehensive, unimpeachable treatment of this subject, see Memorandum of the Law of the Name and Appendix. Analyzing the obvious. A landmark Supreme Court case of 1795, Penhallow versus Deon's Administrators. 3 U.S. 54 1 L.E.D.57 3 Doll 54 defines government succinctly. Governments are corporations, inasmuch every government is an artificial person, an abstraction, and a creature of the mind only. A government can interfere only with other artificial persons, the imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., thereof, can concern itself with anything other than corporate artificial persons and the contracts between them. One might immediately dispute this statement by pointing out that people are acted upon by agents of government and are regulated, fined, imprisoned, plundered, brutalized, and killed by government officials every day. True, but let us step back from the fray and take in the whole macrocosm that we call modern civilization. It is fairly obvious that a thing created can never be greater than the creator that brought it into existence. Please follow along with this syllogism. 1. God created man and rules over man. Therefore, man can never be greater than and can never rule over God. 2. Man created government, an artificial entity as a service, facility, and or slave. Therefore, government can never be greater than and can never rule over man. 3. Government then created corporations and corporately colored entities. See also persons, aka slaves, for the purpose of ruling over them, collecting revenue. Therefore, a corporation, corporately colored entity, can never be greater than and can never rule over the government that brought it into existence. Therefore, a corporation, corporately colored entity, can never be greater than and or rule over government, can never be greater than and or rule over man, can never be greater than and or rule over God. Despite the logic of this example, and as pointed out above, anyone can look around and see that the above hierarchy of rule is certainly not the case in America today, and likewise almost everywhere else. Simple observation tells us that government rules over people, not the reverse. What is missing from the foregoing equation is the same thing that is missing in your awareness about your life: the existence of your straw man trade name, plus your obligations coupled therewith. In the above example, you, the man, woman, are described in categories 1 and 2. Your all caps ens legis straw man falls in category 3, but till now you were not even aware of its existence at any level. For purposes of ruling over flesh and blood people, such had to be somehow corralled into the artificial sphere, the only realm that government, being the slave of the sovereign men and women that created it, can dictate over. Here is the two-part governmental artifice that facilitated this transformation: government. 1. Corrupted the true names of sovereign men and women into corporately colored mirror image, all capital letter trade names at the time of falsely required registration of the biological property via the birth certificate, and omitted informing people of the creation of the newly created ens legis corporate franchise citizen of the United States trade name, and then 2. Deceive the flesh and blood men and women of the sovereign constituency of unwittingly, voluntarily contracting as surety for the trade name, concealing from the victims their new status, but also heartlessly enforcing the new obligations without benefit of explanation. Notes: surety, a person who is primarily liable for the payment of another's debt or performance of another's obligation. Black's Law Dictionary, 7th edition, 1990, herein, Black's Law 7th. End quote. The device and practice under 1 above committed via an officially authorized subterfuge known as a legal fiction opens the door so government actors can literally pretend a false reality into existence and then act on it without any obligation of notifying anyone about it. Under 2, actors in government have secretly created contracts of suretyship, but without informing prospective sureties, thereby establishing an ongoing Machiavellian scheme whereby a sovereign man or woman can be treated as the equivalent of his or her inert, inanimate, artificial, paper and ink, corporately colored counterpart straw man, once the mark, intended victim in a competence game, has been suckered into the contract. Notes: one of only 2 inhabited jurisdictions on the planet where this is not the case is Tiny Sark, a 1 square mile island nation in the English Channel, and the societal paradigm most closely approximating utopia on this, the third orb from the dwarf star Sol, population 550. Average Sarky net worth approximately 10 million USD. Types of taxes: alcohol and tobacco only. Number of tax collectors other than for alcohol and tobacco: 0. Curious taxmen are immediately arrested and placed in the dungeon, where they spend the night before being put on the first ferry off the island the next morning. Other sources of government revenue: voluntary donations only. In parentheses, the only governmental revenue raising project undertaken in the last 700 years was for 2 public toilets. All proceeds were voluntarily donated. End of parenthesis quote. Number of tax treaties with other countries: 0. Non-member of International Monetary Fund, non-member of United Nations, governmental leaders: 1 Sensashal and 1 Sinagera, members of parliament. 40 freehold in allodium. See allodium in glossary. Property holders: countries with visa-free travel for SARC passport holders: 80, in parentheses, most of all passports, end of parentheses. There are only 2 other such politically uncontaminated jurisdictions on Earth. One is burgeoning at this writing, and the other is uninhabited. Registration of anything is a voluntary act of surrender of custody of the property and the establishment of an account, in parentheses, that can be charged in the name given. The birth certificate is the official security instrument for the property, i.e., the name, which held in trust by the custodian, the state registrar. For specifics, see birth certificate in glossary. The all caps trade name is a 14th Amendment artificial person, corporate franchise, citizen of the United States, the only kind of U.S. citizen in existence as contrasted with an American citizen, a sovereign, flesh and blood man, woman, in parentheses, see the demise of the American Constitutional Republic in appendix, as well as an individual, i.e., the U.S. government employee, see individual in glossary. For an entertaining perspective on the heartless nature of commerce, see Wizard of Oz, the in glossary. Legal fiction, something assumed in law to be fact irrespective of the truth or accuracy of that assumption. Merriam Webster's Dictionary of Law, 1996. Suretyship. Suretyship is defined as the legal relation that arises when one party assumes liability for a debt, default, or other failing of a second party, and the liability of both parties begins simultaneously. In other words, under a contract of suretyship, a surety becomes a party to the principal obligation. Black's Law, 7th edition. Suretyship is further clarified as follows. The contract of suretyship may be entered into by all persons who are sui juris. That's SUIJURIS. And capable of entering into other contracts. Bouvier's Law Dictionary, 6th edition, 1856, hereinafter Bouvier's 6th. Sui juris, Latin, of his own right, possessing full social and civil right, not under any legal disability or the power of another, or guardianship. Black's 4th. A surety is equally liable for the obligations of the principal he is bonded with. However, as you can see in the Bouvier's definition above, only a sui juris man or woman is capable of becoming a surety. Examining the definition of sui juris more closely, you can discover that this is an artfully watered down camouflage term for the legally or legal equivalent of a sovereign of his own right, not under the power of another. Suretyship. What this means is that, in the eyes of the law, only a sui juris, sovereign, self-governing, responsible man, woman possesses and can exercise full right and power and is legally qualified and eligible for being hoodwinked, conned, deceived, bamboozled, swindled, shafted, cheated, hornswoggled, defrauded, scammed, duped, tricked, trapped, and suckered into becoming a surety for his or her intangible, artificial, mirror image, paper and ink, straw man trade name. Hence, the following inescapable conclusion. Were you not such a sovereign, self-governing sui juris, responsible party in the first place, you could never have become a surety for anyone, anything else, straw man, any time thereafter. Thus, we have uncovered the answer for the apparent conundrum cited above, re-government ruling over man. A sovereign man, woman, has the sovereign right and power for contracting away his or her sovereign rights and power if he or she, in his or her sovereign capacity, so chooses, otherwise legally known as an unconscionable bargain. But business as usual for the legal masters of the world, and your self-appointed rulers need only the minutest justification for inflicting the full fury of their wrath upon you. Until recently, all such contracts were secret, invisible, and unknown for everyone but the man-haters that devised them and the hellhounds that enforce them. In your particular circumstance, the artificial all-cap straw man is the principal, and you, the living, breathing flesh and blood, man and or woman, the unwitting surety. Notes. For a comprehensive examination of this most significant of subjects concerning all citizens of the United States, see the curse of co-suretyship in this section. Unconscionable bargain. A contract which no man in his senses not under delusion would make, on the one hand, and which no fair and honest man would accept, on the other. Black's 1st edition. The underlying con beneath the con. Likely, you are following this essay and have a good grasp of the concepts set forth so far and are interested in carrying forward and gaining more understanding about how these things apply in your life and what you can do about it. But let us digress for a moment. A great number of Americans have figured out that the all caps corruption of their true name is somehow being used against them, and we shall thoroughly address that issue momentarily. However, there is an even subtler con underway concerning the name. It has been so well designed and orchestrated that almost no one has even conceived of the possibility of its existence. Although knowledge of this particular stratagem is not necessary for application of the practical remedies contained herein, there is no surety in existence that cannot benefit from its revelation. No matter the degree of understanding, it reflects the very essence, basis, and nature of your position in American society. Let us take two entities, one actual, the man and or woman known as the king and or queen of the state of Great Britain, and one artificial, the state of United States, a sub-jurisdiction under aegis of the crown. That's AEGIS, a front for the legal masters of the world, and examine a peculiar right claimed by each. The sovereign in Great Britain must consent before he or she can be sued in the royal courts. United States, the proclaimed sovereign on this side of the Atlantic, must also consent before it can become the subject of a lawsuit in its own courts. The sovereign, whether the term be used with respect to a state or to the chief ruler of one, is accorded an immunity from suit in courts of justice. This doctrine obtains both in England and in this country. It is a general rule that the sovereign cannot be sued in his own court without his consent. From the definition of sovereign, Bouvier's 8th edition. How is it that any such claim of right can be made by these parties? Why must we obtain permission before suing either of them? The answer for these questions reveals a tactical source point of the current physical, mental, and spiritual dilemma facing mankind. The appellation, or appellation. Appellation, a rather obscure word in the English language, is defined as follows. A. Fr. French. Appellation, 13th C. AD. L. Appellation, appellationum, of action. F. Appeller, to accost, address, call upon. Appealing, appeal, the action of appealing to a higher court or authority against the decision of an inferior one, the appeal so made. B. Ground of appeal, title, claim. OBS, rare. 2. Gen. The action of appealing or calling on entreaty or earnest address. 2. Calling designation, from Latin fr. appeller, or L. appellare. The action of calling by a name, nomenclator. 4. A designation, name, or title given. A. To a particular person or thing. B. To a class, a descriptive or connotative name. 1. A name or a title. 2. The act of naming or calling. Funk and Wagnall's Standard Dictionary of the English Language, International Edition, 1958. Act of calling by a name or designation. Webster's Collegiate Dictionary, 5th edition, 1947. Appellation is spelled identically in both French and English. In French, the word means appealing, calling, naming, appellation. Cassell's French, English, and English-French Dictionary. Though this word has come our way through French, its ultimate origin is Latin. Appellat, o onus, f. accosting, appeal, calling by name, name, title, pronunciation. Burt's Latin English Dictionary, 1926. The word accost appears prominently in the Latin origin of appellation and is defined as to speak to first, address, greet, manner or act of addressing, greeting. Funk and Wagnall's Standard Dictionary of the English Language, International Edition, 1958. This and other French words made their way into the English-speaking world courtesy of the Norman French attorneys accompanying William of Normandy, aka Duke of Normandy, and William the Conqueror, following the inglorious Battle of Hastings (England) in the year 1066 AD. The corrupted French dialect of the Normans was then immediately installed in the legal system, and Englishmen unlearned in the new language, i.e., nearly all, were thereby effectively foreclosed from any adequate legal defense of themselves and their property against the tyrant king's esquires in the courts, and so experienced economic annihilation. As with many other impediments in the language of the legal system, Norman French attorneys are at the bottom of the obscurity of the word appellation as well. Of the first four definitions of appellation in the Oxford English Dictionary, hereinafter OED, the world's most respected lexical authority, we are told that three of them are obsolete. OBS. The only valid one being one, i.e., the action of appealing to a higher court or authority against the decision of an inferior one. The appeal so made, even though the so-called obsolete usages are in complete harmony with the only modern definition, the reason proper usage of this word is labeled obsolete by the king's esquires on staff at OED, the reason of this word is not defined in law dictionaries. The reason most people believe that an appellation is nothing but an archaic synonym for a name, e.g., Christian appellation. The reason people generally have a reverse conceptual understanding of the meaning of this obscure term is the same reason that Big Brother calls himself a sovereign and you a subject, and why you must first obtain permission from the Crown or United States before using political subjugation and compelled allegiance, another word with Norman French origins. Can be seen from the etymologies and definitions above. Appellato is the Latin root for an appealing to, a calling out to, a pronouncing of a name title, an accosting, a speaking to, addressing, greeting of another. The idea of a name is a secondary derivative aspect. Consulting the original Latin meaning and later French usage, the essence of an appellation is the action of making an appeal, calling out, addressing another, and i.e., an act for getting another's attention. One makes contract with another by emitting an appellation. Even when considering or considered as a name, an appellation is not a crippling ball and chain claim on your existence. As a sovereign, your appellation is merely your cue, signal that someone is reaching out and desires communication from or with you. This is why the so-called sovereigns, the Crown and United States, require that their approval be obtained before suit is initiated. Evaluate the appellation and decide if they want it. Sadly, Most people have identified with their name and believe when it is called, they are obligated in responding as requested, ordered, as though use of the name somehow exerted control over their freedom of locomotion and the disposition of their personal property. This is wrong-headed, but those who control the publishing of textbooks and newspapers and dictate over government, the media, and the legal system have nevertheless successfully inculcated this affirmity into our collective consciousness. A name is a piece of property and can never be copyrighted. You are not your property and or not your name. An appellation differs from a name in that it is something that originates with another. It is an earnest plea for communication. The so-called obsolete definition, too, in the OED, is the true modern meaning of the term. The action of appealing or calling on, entreaty, or earnest address. Others use an appellation for addressing you, accosting you, calling out for you, making an appeal of you, and getting your attention. And what you do following such appeal is entirely your own choosing. This is as true as your neighbor down the street as it is for an IRS agent. When someone makes an appellation for the purpose and issues a decision, any sovereign must agree that he is sued and that he is liable before another can proceed against him. And this is true for any sovereign, including you, irrespective of any lack of awareness on your part of your own omnipotence. People in America have lost sight of the fact that they are sovereigns and that nothing can be foisted upon them without their agreement. This is a fact of life, not an invented truth of this text. No one can be legally victimized without his or her consent. However, we have been beaten down by the legal system with such vehemence, taxed, robbed with such righteous fervor, and brutalized and even killed by officers of our own government with such callous indifference for so long that people have lost sight of who the boss is and who the servant is and who they really are. Notes. Stratagem. A maneuver designed to deceive or outwit an enemy in war. A deceptive scheme for obtaining an advantage. United States is a singular proper noun and represents a city-state domiciled in Washington, D.C., District of Columbia. This is a hoax perpetrated via the doctrine of legal fiction, i.e., pretending a false reality into existence. No artificial person can be sovereign and or self-determined over anything. The sovereign in America is the sovereign constituency, i.e., the people, the American citizens. Esquire is an attorney. United States Incorporated has long since waived immunity virtually across the boards based on corporate status and activity. Inculcate means to impress upon the mind by frequent and emphatic repetition, instill, maintaining fiscal integrity. A name is a piece of property. It is not the living, breathing flesh and blood man associated therewith. When someone asks for your name and you give it to him, you voluntarily surrender your property and consensually agree with whatever he wants to do with it. In the case of a judge, this can be extremely dangerous. All the different names you have gone by throughout your life are simply means of addressing you, ways of calling you, and have no more importance than you accord them. If you choose to respond when someone uses your property, your common law copyrighted name, to get your attention, and then go into contract, that is your sovereign, self determined choice. Take a look at the following exchange. In parentheses, judge could just as easily be replaced with officer, detective, agent, etc. Judge, what is your name? Sovereign, no, it is not. Judge, what do you mean? Sovereign, I mean, what is not my name? Judge, I am asking for your name. Sovereign, well, I have lots of names. Which one are you talking about? Judge, I am talking about your real name. What is it? Sovereign, my parents call me son. My friends call me Lefty. And my dog calls me Woof. These are all real to me, and I usually respond to each. What name are you interested in? Judge, I'm not interested in playing word games with you, and you will show respect for this court. Are you John Henry Doe? Sovereign, the name you just mentioned is common law copyrighted property, and I am the owner of that particular property. In fact, I have given public notice of my ownership of that property by publishing it in the newspaper. And if you want to use that piece of property again, I need to inform you that there is a fee for its use set forth in the copyright notice, and it's a fairly steep fee. But I will waive the charge you just incurred if you elect to not use it again. What would you like to do? Judge, I don't know what you think you're doing, mister, but you're about to get into deep trouble. Sovereign, mister is not a name of mine. Judge, look, whatever your name is, I'm commanding you to identify yourself or be held in contempt of court. Bailiff, sovereign, I apologize for any misunderstanding, because it is certainly not my intention to show contempt for this court. I am only interested in protecting my property rights. Are you commanding me to surrender my private property for use without compensating me? Judge, I most certainly am not. I am merely asking for your name. Sovereign, well, my name is my property, and I do not give away any of my names for the use of others without being compensated in accordance with the use fees as published in my copyright notice. As far as I can tell, the only reason why you want the name is to use it so the court can make money. Is that correct? Judge, that is not correct. I need to know who you are so we can proceed with the business of the court. Sovereign, you bring up a good point. If you do not know who I am, then why do you want to do business with me? And why are we here? Judge, you are testing the limits of my patience, sir. Give me your name. Sovereign, you want to know what to call me? Judge, that would do fine. Sovereign, you can call me secured party. Judge, this is not going to go on much longer, my friend. Very well, Mr. Secured Party. Where do you live? Sovereign, I live within the confines of my skin. Judge, dropping his head into his hands, slapping his forehead with both palms, then looking up. What is your address? Sovereign, I don't have an address. See for yourself. Slowly does a 360 spin, arms held away from body. Judge, where do you sleep at night? Sovereign, in a bed usually, sometimes in a sleeping bag. Judge, I mean, which building do you sleep in at night? Sovereign, like I said, I don't sleep in a building. I sleep in a bed. Judge, sir, secured party, whoever you are, you can have a seat over there, and we will take this up further after lunch. Nothing got started, and nothing ever got started, even after lunch. The sovereign was truthful and respectful the whole time, and he never gave away his property for the use of the court, in parentheses, who would open an account and lodge pecuniary charges in it. The sovereign kept his cool because he knew that the only thing the judge wanted him to do was voluntarily surrender his private property for the use of the court without compensation. The judge knew that the sovereign understood what was happening, and so gave up. Once you understand that this is all that is going on in the courtroom and elsewhere, then you will be able to think on your feet and make the right moves too. The world runs on the initiative of about 5% of the world. The target audience of this manual, the rest need orders. The consensus of the 95% of the subject of one's relationship with government, banks, tax agencies, courts, and corporations, all separate realms, is defective, and that such inherent abstractions have been accorded superiority over living beings. Governments are transitory mental contrivances set up by the clever few for the purposes of living off the efforts of the trusting many. A generalization, yes, but also the truth. Notes: pecuniary, of or relating to money. End quote. The world runs on the initiative of about 5% of the people. The rest needs orders. The consensus of the other 95% on the subject of one's relationship with government, banks, tax agencies, courts, and corporations, all separate realms, is defective, and that such inherent abstractions have been accorded superiority over living beings. Governments are transitory mental contrivances set up by the clever few for the purposes of living off the efforts of the trusting many. A generalization, yes, but also the truth. That you may have at some point lost sight of the fact that you are sovereign is not a denigration of who you are. The entire population of this country, this planet, has been systematically shafted through inconceivably complex mechanisms in the field of commerce, law, and finance by the small tribe of brilliant sociopathic madmen hell bent on its subjugation. You cannot disparage yourself because you fell prey, along with others, and were betrayed by those in whom you place trust. But you can begin dealing with the situation from the proper viewpoint, and that is as a self governing, fully accountable, responsible man or woman who can control and is in control of his or her own political, economic destiny, despite the apparently overwhelming odds stacked against you, knowing that you are not your name, that you, the sovereign, can take legal possession of your name in all its forms, and that the option of accepting and or rejecting any appellation from any part that comes your way is strictly yours in your sovereign capacity, will speed your course. The real life proven practical solutions contained in this handbook are humbly tendered for assisting you in accomplishing these aims, actualizing your true nature, and enjoying the realization of your dreams. Unrevealed obligations. There are 60 plus million statutes on the books and over 3 million different law books on file in the Library of Congress. Your straw man, and you by default, as surety, is responsible for knowing and complying flawlessly with the letter of the law. Every single statute in existence, because everyone is presumed to know the law, and ignorance of the law is no excuse. If the word manipulators, who claim the legal title of the straw man with which you are presumed contractually unified, decide that they will tax, fine, regulate, rob, incarcerate, and possibly even kill the abstract straw man, then you, the physical and or biological being, go along with the statutory ride and experience the consequences in reality. In such legal status, you are devoid of capacity for asserting and or enforcing any rights. You have no standing in law, i.e., a slave cannot sue his master and or owner. Through other such governmental legal fictions, with penalties for things as innocent as paying your strawman's Social Security payroll taxes, accepting free delivery of mail from the United States Postal Service, and taking out licenses issued in the strawman's trade name. Otherwise, sovereign men and women are unwittingly set up to have their lives utterly destroyed by Big Brother for voluntarily contracting as a surety for the strawman. As it turns out, the strawman is also responsible jointly and severely with other strawman debtor Social Security account holders for payment of the national debt, thereby making any man forward slash woman with a Social Security card in his or forward slash her possession equally liable as a co-surety for payment of the national debt. The Social Security account is the strawman's account and is listed in your strawman's trade name, not your true name. In Halvering vs. Davis, 301 U.S. 619 57 S.CT.81, capital letter L .ed .1307 apostrophe 904, the U.S. Supreme Court ruled that Social Security is neither an insurance nor a retirement program, but a welfare program. Because of this fact, application for and use of a Social Security account number, SSAN, for one thing, is a tactic confession that one is so incompetent in managing his forward slash her own affairs that he forward slash she must appoint the U.S. government as his forward slash her guardian and seek eligibility for welfare payments. Such defective status is also known by other names such as child of the state and ward of the court, and is legally known as the doctrine of parens patriage, wherein the state is considered the legal parent guardian and those under disability and unable to care for themselves. When you paid the first penny of the strawman Social Security payroll taxes, you executed the contract and confirmed that the strawman and you by default as surety was a child of the state, incapable of managing its own affairs and needful of guardianship. Also, in Fleming vs. Nestor, 363 U.S. 603 4, capital L dot ed dot 2d 1435 80 S dot ct dot 1367 in the year 1960. The U.S. Supreme Court ruled that those who have paid in Social Security taxes over their lifetime have no vested interest in Social Security. No vested interest means that payment of Social Security benefits from the Social Security system is optional forward slash discretionary and not obligatory. Thus, by law and by contract, when a Social Security taxpayer retires, FICA, Social Security system, has no obligation for compensating the retiree forward slash taxpayer. This is another reason why Social Security is an unconscionable bargain forward slash contract. All of your accounts, certificates, securities, licenses, permits, etc., are in the name of your ens legis, strawman trade name. All accounts are the strawman's accounts, not yours. You are the surety attached thereto, and the party that everyone goes after for every payment and specific performance because between you and the straw man, you are the only one with the warm breath capable of fogging a mirror. You are a sitting duck waiting to be blasted until you rectify the situation. And this is where the concept of redemption enters in. Notes: denigrate, to slander, cast aspersions on, solely, defame. 3 million average size law books take up approximately 80 linear miles of library bookshelf space. At the inception of this country, a man faced a total of 3 possible crimes: treason, counterfeiting, piracy. Origin of this saying, hanging of the witches, 1655. Capacity, ability, qualification, legal power of right, see capacity in glossary. Jointly and severally, or severely, in a fashion both common shared as well as distinct, separate, meaning that while there are many, or there may be multiple debtors who are mutually liable for the same obligation, the entire obligation may be obtained from any single debtor. The so-called national debt is the financial obligation of the U.S. government claimed by the Federal Reserve Bank based on use of the Fed's private property, in parentheses, valueless, unredeemable Federal Reserve notes as currency. Co-surety, a surety who shares the cost of performing suretyship obligations with another. Doing business under your trade name. Corporate names, corporately colored names, trade names, marks, trademarks, and service marks are private property of someone, and all can be claimed as such. Government accepted custody of the named property when the newborn was registered via the original birth record document. The straw man was born. And on the first document emitted by government that referenced the name, if not on the original record document itself, sometimes the initial document is the Social Security card. Sometimes it is a certificate of live birth. There are literally dozens of variations of the birth certificate. As harmless as hospital birth certificate and as profound as Department of Commerce and even Federal Security Agency birth certificates. However, because everything about you is notated, registered, assigned, listed, vested in the name of, and accessed via the straw man's trade name, all property is considered the straw man's property for purposes of acting out the charade that any other than the state owns anything. However superficial this policy may be in terms of what actually transpires when a citizen finds himself in one of Big Brother's shakedowns, it is nonetheless as essential public relations tool for maintaining order within the flock as individual sheep are cornered and shorn. In terms of finance, commerce, and law, the entire planet actually functions in a mirror image world of reality, anchored by private money that represents liability, not substance, i.e., Federal Reserve notes. FRNs, we all live in a corporate bubble. Literally, the Federal Reserve, IMF plantation, government, a bankrupt front, and sham entity for for the Federal Reserve / IMF creditors, has no other way of doing business with you and managing the accounting ledgers other than by using the name of the artificial person contrived from your true name set in capital letters / abbreviated. The true name, initial letters only capitalized, equals a de jure, DEJURE / solvent, sovereign, flesh and blood, American citizen, or creditor. All caps, abbreviated trade name equals a de facto, DEFACTO means bankrupt, subject, ink on paper, citizen of the United States, debtor. Under the current paradigm, there is no other way the industrial community can do business with you. And that is all it is, business and commerce. Your trade name is the name by which all of your products and services are identified and known in commerce. Trademarks. Trademark is defined as a word, phrase, logo, or other graphic symbol used by a manufacturer or seller to distinguish its products or products from those of others. The main purpose of a trademark is to guarantee a product's genuineness. In effect, the trademark is the commercial substitute for one's signature. In its broadest sense, the term trademark includes a service mark, often shortened to mark. Black's Law Dictionary, 7th edition. Your true name cannot be classified as a word, phrase, logo, or other graphic symbol because it is constructed in accordance with the rules of English grammar. Your true name, corrupted into all capital letters format, however, eminently qualifies as a word, phrase, logo, or other graphic symbol, and also a commercial substitute for one's signature. Because such an assemblage / concoction of letters cannot be defined / classified in any other way. The all caps realm is a corporate realm and none other. Common law trademark is defined as one appropriated under common law rules regardless of statutes. Black's Law Dictionary, 4th edition. Notes. The Curse of Co-Suretyship, Section 3 for details. Wards of Court, infants and persons of unsound mind. Parens, paratre, Latin, parent of his or her country. The state regarded as a sovereign. The state in its capacity as provider of protection to those unable to care for themselves. The curse of co-suretyship. For a comprehensive treatment of the Social Security, confidence gain, and the enormous liabilities of co-suretyship, see the curse of co-suretyship in Section 3. Must reading for anyone with a Social Security card. The legal definition of the word birth in Black's Law, 1st edition, accommodates both the animated life of the newborn baby and the statutory creation of the straw man trade name. Birth, the act of being born or wholly brought into separate existence. Notes continued. The ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law amounting to mere user, and must be in accordance with law and subordinate to the necessities of the state. See Senate Document 43, 73rd Congress, First session and glossary. De jure, of right, legitimate, lawful, by right, and just title. In this sense, it is the opposite of de facto. De facto. This phrase is used to characterize an officer, a government, a past action, or a state of affairs which must be accepted for all practical purposes, but is illegal or illegitimate. Paradigm. Any pattern or example, model. For documentary proof of this fact from the Federal Reserve, see How to Sign Your Signature Without Liability on page 315 in section 10, Handling Presentments. Again, your true name cannot be classified as a word, phrase, logo, or other graphic symbol because it is constructed in accordance with the rules of English grammar. Your true name corrupted into all capital letters format, however, eminently qualifies as a word, phrase, logo, or other graphic symbol, and also a commercial substitute for one's signature, because such an assemblage or concoction of letters cannot be defined and or classified in any other way. The all caps realm is a corporate realm and none other. This is why you need to consult statutory law and secure approval from any governmental agency in appropriating, claiming, and enforcing a common law copyright on your trademark, i.e. your trade name. Your services and or labor are delivered, billed, and paid for via this trademark service mark, which encompasses everything about you in the world of commerce because it is via that entity that commercial interface is achieved. When we lost the gold-backed currency, we lost personal accountability and took on corporate limited liability. We lost the capability for extinguishing, in parentheses, terminating, a debt with substance, in parentheses, gold, and took on the mechanism for merely discharging a debt, in parentheses, placing the debt in limbo, / suspension, with privately owned liability instruments, in parentheses, Federal Reserve notes. Your trade name / trademark is your ticket for doing business with the modern, bankrupt industrial community and uniquely identifies all products and services brought into existence by your hand. Your only real shortcoming was that you were unaware that your trade name / trademark was just that. You have been conducting your whole life as though you were dealing with other true name sovereign men and women, when in actuality, both you and the people you have been dealing with have been operating via a camouflaged, corporately colored, artificial person trade name, trafficking in privately owned, valueless Federal Reserve notes. The reason that all industrial community computers have only all caps capability for displaying the names of customers should now be clear. Sovereignty. The Federal Reserve is not an agency of government. It is a private banking monopoly. The policies of the monarch are always those of his creditors. Quoted by Congressman John R. Rarick, Congressional Record, February 1st, 1971. The dilemma of operating in today's political environment pans out like this. Almost every government in existence has been bankrupt by the same small tribe of Luciferian shysters, and the notion of a trustworthy, principled, and self-determined politico is a subject reserved for the history books. As Congressman Rarick so astutely pointed out 30 years ago, the actual sovereigns are the creditors in finance / commerce, not the national puppets promoted on TV and in the newspapers. The disinformation circus run by the media, in parentheses, also a controlled monopoly of the money power, is an indispensable component of the global con because the Federal Reserve creditors are so few in number they could easily be exterminated. So they believe, if identified by even a small segment of the population, people must be made to believe that governmental leaders are acting autonomously with the best interests of the people at heart. If the scam has any chance of enduring, when a sovereign borrows accepts credit, he she takes on a creditor, and the creditor inherits supreme claim over the sovereign's realm. The laws of the U.S. government are the policies of the Federal Reserve IMF creditors, officially, corporately, legally, and otherwise. Politicians are now even called policy makers. Instead of just their original spurious moniker, lawmakers, public policy is the watchword and credo of all U.S. political and judicial, in parentheses, legal undertakings. The creditors dictate over the full spectrum of the governmental activity in America with an iron fist, from the highest office in the land all the way down into governmental activity as apparently mundane as parking tickets. In parentheses, leading source of revenue for all major and many smaller American municipalities. A sovereign is the author and source of all law in his own realm, a subject of no one. If the creditor is the one who sets the policy, in parentheses, makes the law of the monarch, it is easily discernible that the real sovereign is the creditor of the U.S. government, not the smiling politician chirping sound bites and performing for the camera. How does one get established as a creditor sovereign and become the author and source of all law with which one is associated? Answer: by becoming the sole source and arbiter of all terms and conditions of every private, consensual contract under which one does business with Big Brother and all others as well. This is an apparently tall order at first glance, but realistically attainable if equipped with the right knowledge. Notes: the use of trademark is as old as commerce itself. The conventional trademark is a part of what is called the symbolism of commerce. Brown on Trademarks, 2nd edition, sections 1, 26. Roostrat versus the People of the State of Illinois, 185, Illinois, 133, 57, N.E. 41. The proclaimed value of Federal Reserve notes, FRNs, is their so-called purchasing power, which amounts to nothing more than the people's collective lack of awareness of the con. For a very brief period in history, FRNs could be redeemed for lawful money, but that facility vanished with the lawful money. FRNs can no longer be redeemed for anything of value, in parentheses, including the debased token metallic coins in circulation. People have confidence that FRNs will continue being accepted in exchange for items of substance, so people keep accepting FRNs in exchange for the goods and services they offer. The only value of a Federal Reserve note is its prospect for being accepted by the next guy in exchange for the goods and services he is selling. Federal Reserve notes are fiat, in parentheses, by decree, money issued by the holders of the monopoly on the medium of exchange, and penalties for their use are enforced via military and quasi-military measures. See Secretary and Glossary. Sovereignty, supreme dominion, authority, or rule. Black's Law Dictionary, 7th edition. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yick Wo vs. Hopkins, 118 U.S. 356 6 S.CT 1064 1886. Although others may exist, Congressman Ron Paul from Texas is the only contemporary D.C. politician that your authors are aware of who is an exception this characterization. Consensual contracts. A member of the sovereign constituency is guaranteed many rights under the Constitution of the United States of America, 1787. Possibly the most significant paramount right is that of contracting with whomever one desires, and, in such event, that any obligations associated therewith shall not be impaired by any outside (in parentheses third party). The most widespread, debilitating malady currently afflicting nearly all sovereigns in America is the proclivity for capitulating when pressured by one of Big Brother's operatives, e.g., attorneys, judges, traffic cops, IRS agents, etc., and consenting in doing business under whatever terms said operative dictates. This affliction is contracted in a number of ways, one of which is through ignorance of the true nature of modern government, i.e., a for-profit, insolvent, commercial undertaking having left the realm of a de jure political operation of, by, and for the people. Upon incorporation in 1871, all governmental business in America today is strictly private, confirmed in Clearfield Trust Company versus United States, 318 U.S. 363 63 S.CT 573 1943. Governments descend to the level of a mere corporation and take on the character of a private citizen, in parentheses, as an issuer of private, corporate, commercial paper, i.e., securities, for purposes of suit. Such corporations and entities are regarded as an entity entirely separate from government. Notes. All U.S. law is copyrighted property of the following British corporations: the Thomson Group, LLC, Ltd., with offices located in Montreal, Quebec. Canada owns Inter alia, West Publishing Company, Barclays, West Group, Bancroft Whitney, Clark Boardman, Callaghan, Legal Solutions, Rutter Group, Warren, Gorham and Lamont, Lawyers Coop, Reed, Elsevier owns Inter alia, Lexis, Deering's Codes. It has also been confirmed that Black's Law Dictionary is copyrighted British law. The U.S. government incorporated as a for-profit commercial enterprise in the Legislative Act of February 21st, 1871, 41st Congress, Session 3, Chapter 62, page 419, and chartered a federal company entitled United States, i.e., United States, 1871, aka U.S. Inc., a commercial agency originally designated as Washington. When an American sovereign is approached by any of the numerous kinds of government revenue agents acting on behalf of the Federal Reserve creditors, the contact is for the purpose of collecting debt. in parentheses, Federal Reserve notes equals debt, not lawful money, in parentheses, gold and silver coin, and not for anything as far fetched as securing the noble ideals espoused in the Declaration of Independence and the Constitution, and otherwise generally associated with the American way of life. When Big Brother's henchmen come calling, they grant you full importance and respect for the sovereign that you are, i.e., for knowing that all your actions are self determined, and for knowing exactly what you are doing with whom you are doing it. You see, all government and quasi governmental actors are just out there beating the bushes, scaring up business, and it is fully expected that you, the sovereign, are aware of this fact, giving you an education on civics and current events, in parentheses, national bankruptcy, non substance commercial script for currency, sham government, occupation by foreign military officers, unconscionable co suretyship obligations for the debt of the U.S. government, etc., is not part of their job description. Therefore, whenever you enter into an exchange with a government revenue officer, you provide tacit consent and execute the contract established thereby. In parentheses, government's paramount objective, above all others, is acquisition of your wealth forward slash money forward slash property forward slash assets. This phenomenon is no different than walking into a restaurant, examining the menu, and then placing an order when approached by the waitress. It is expected that you know what you are doing, and that you know you are fully liable for the meal you order and consume, and that you will pay the bill when it arrives. The contract so formed is called an implied contract, and is based solely on consensual conduct rather than express, in parentheses, written agreement, i.e., if you place an order for food, you also tacitly consent and accept full responsibility to pay for it. Government type waiters forward slash waitresses, in parentheses, code enforcing revenue officers, do nothing but work the shop, in parentheses, patrol corporate U.S. turf, looking for customers, in parentheses, unwary, trusting, sovereign American men and women who wander in parentheses, are not aware of the difference between de facto U.S. statutory law and de jure American common law jurisdictions, and write up orders, in parentheses, cite, assess code infractions, which are eventually paid for by the customer, in parentheses, extorted from the sovereign American on his way out the door, in parentheses, in exchange for the sovereign American's freedom of locomotion. Before any contractual encounter commences, i.e., before a code enforcement operative invokes your unwitting execution of a contract, you are considered a sovereign being who can claim all protections afforded by the Constitution from the de jure government, one of which is contracting with whomever you wish. That the code enforcer does not represent the de jure government is of no consequence. You are also accorded, as a sovereign, respect for having full understanding of what you are getting into and with whom you are dealing, and for contracting as you best see fit. You decide on doing business with a municipal corporation in Chapter 11 reorganization is a bona fide, self determined commercial discretion that any businessman can reasonably make, and which is warmly welcomed by those soliciting the business. The major discrepancy in the transaction is that there is no meeting of the minds, a necessary component in any valid contract. But since you are a sovereign, you are nevertheless respected for any bargains you enter into, however unconscionable they may be. This all takes place, of course, in the straw man's trade name. But that is a rather moot point when one is faced with such finalities as garnishment of wages, eviction, and the business end of a loaded 38 caliber police special. When system justifies abuse of the American sovereign, indeed thrives on it, because the sovereign was duped, fair and square, into becoming a surety for the trade name. D.C. In accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases Dyett versus Turner. That's Dyett versus Turner. 1968, 439, P2D, 266, apostrophe 267. State versus Phillips. 1975, 540, P2D 936, as well as Coleman vs. Miller 307, U.S. 448, 59, capital S, period, capital C, lowercase t, period, 972, 28. Tulane, that's Tulane, Law Review, 22, 11, South Carolina Law Quarterly, 484, Congressional Record, June 13th, 1967, pp. 15641-15646. Every single type of attempt at collecting money, including income tax liens, levies, and garnishments, and even parking ticket fines, is legally classified as debt collection, and all falls under the Fair Debt Collection Practices Act, because the object of the collection of parentheses currency / money consists strictly of debt instruments in parentheses Federal Reserve notes. Collection of Federal Reserve notes equals collection of debt. The land of the free and the home of the brave has the highest per capita incarceration / imprisonment rate of any country in the world. Is an astonishing fact. Scrip, SCRIP, paper money issued for temporary use in an emergency. For details about foreign military occupation, see Section 2, The Truth About Esquires. See Section 3, The Curse of Co-Suretyship, for a complete explanation. End of notes. The cure for volunteeritis. If you are not absolutely certain that you are a sovereign, guess what? You are not a sovereign. True sovereignty begins between your ears and is actualized when Big Brother's operatives determine that you are certain of exactly who you are and what you are doing. How does sovereignty manifest in today's world? As of March 9th, 1933, life is no longer the same in America. Currently, sovereignty is evidenced when the everyday contracts one enters into cease being one-sided, unconscionable bargains with government agents, courts, taxmen, banks, and corporations, and uniformly begin being self-determined, consensual, clean hands, full disclosure type relationships where each party is fully informed of the actual terms of the contract going into the contract, rather than discovering after the fact that one has been shanghaied. How does one seize being a victim of government force into complying with the terms of endless unconscionable contracts? By not consenting. Not consenting means just that. declining participation in the communication, not approving of that which is proposed, not taking part in the dialogue, opting out from the very beginning, first instant, before anything can be construed as having contractually begun, refusing discussion of the merits of the situation, informing the code enforcing revenue agent that you do not wish to do any business with him or her, etc. The Supreme Court has consistently ruled that no one has any compulsion to enter into any contract with anyone else, including de facto municipal corporations like United States Incorporated, and its myriad de facto political subdivisions such as the state of Florida, rather than the Florida Republic, and county of Dallas rather than Dallas County. There is no requirement that any consent with anything. The word itself means mutual approval. And if you don't approve, no contract commences. There are probably many reasons why otherwise strong willed Americans, in parentheses, shadow sovereigns, routinely submit and go along with what is forced upon them. Fear, misplaced trust, anticipated harm, feelings of guilt, etc. What is missed is that the revenue agent's first objective in demanding the money is forming a contract that can be justifiably enforced at a later time, if necessary. The judge forward slash cop forward slash attorney forward slash taxman, etc., is raising revenue on behalf of his forward slash her corporate employer. And more times than not sharing in the take, it's just business. And anyone can refuse to do business with anyone else, even with government. Granted, this can be a terrifying experience if you are the object of something as life-threatening as a routine traffic stop, but you can still prevail despite the odds. Script for encountering a police officer during a traffic stop. Motorist. Window rolled down about 1 inch, both hands on steering wheel. What seems to be the problem, officer? Policyman. Would you please roll down your window a little further? Motorist. How can I help you, officer? Policeman. License and registration, please. Motorist. I do not consent to this conversation. Policeman. I said license and registration now. Motorist. I do not consent to this conversation. Policeman, placing his hand on his service revolver. If you don't hand over your license and registration right now, I'm gonna drag you out of that car and take you to jail. Motorist, rolling down window, smiling. Oh, well, in that case, that's an entirely different matter. Since you are using color, in parentheses, pretense of law, and threatening me with bodily harm and forcing me into doing business with you against my will, I am happy to cooperate under duress. Here is my license and registration. May I have one of your business cards, please? Policeman hands over a business card. And here is a copy of the published copyright notice setting the terms of the consensual contract for unauthorized use of my common law copyrighted property. My name is copyrighted under common law, and the fee for its use is a fairly steep $500,000 per occurrence. So you might want to look over the terms of the consensual contract that you would be entering into by writing my copyrighted property on any piece of paper. Policeman. What the hell are you talking about? Motorist. I do not wish to do business with you, officer. But if you insist on it, then I have an obligation to inform you of the fees associated with the use of my name, which is copyrighted. Should you decide that you would like to do business with me and accept the obligation for payment of the fees for unauthorized use of my copyrighted property, then I will send you the bill, which is payable in full within 10 days of the date I send it. The terms of the contract stipulate that you pledge all your tangible and intangible property and interest in property as security for payment of the debt you incur for the unauthorized use of my name. If you do not pay within the 10-day period, then legal title for all your property transfers to me, and I am free to take possession of it and dispose of it as I see fit, in order to recover the costs you incurred through the unauthorized use of my name, my copyrighted property. If you will give me your home address, I will bill you at home rather than at the station house. Policeman. I've never heard of this one before. Is this some kind of joke? Motorist. No, sir. This is extremely serious. My published copyright notice is also filed with the county recorder. That contract you have in your hands is official public record. Here is a certified copy of the filing. What I am saying is no secret and no joke. I do not wish to do business with you, but if you insist and force me into it, I will cooperate, but you will be liable for the unauthorized use fees for the use of my copyrighted property. Since you have threatened me with bodily harm, I am very willing to cooperate under duress, and at this point the choice is entirely yours. What would you like to do? Policeman. Have a nice day. So long. Wow, what just happened? The revenue agent, in parentheses officer, for the insolvent municipal corporation, in parentheses government, put on a show of force and attempted to coerce the sovereign, in parentheses motorist, into voluntarily entering and thereby accepting financial responsibility for a commercial contract, in parentheses traffic ticket, that the officer intended on generating. The con never got off the ground because the motorist never accepted any communication from the officer until the issue of duress was established, in parentheses, thereby voiding any contract formed thereupon. Adroitly establishing on the motorist terms the parameters of the non-violent consensual contract for the officer's unauthorized use of the common law copyrighted trade name. The cop then decided against doing business with the motorist. This is an example, however visceral, of what eliminating one-sided, unconscionable bargains with the government actors means. Please note, however, this example has not been included here as a tactic recommendation that the reader undertake this strategy if confronted by a policeman in a traffic stop, though the above is an entirely plausible exchange. When the reader fully absorbs the knowledge available in this volume, he/she will be fully capable of making his/her own decisions about what should be said and how it should be said. If confronted by code enforcement type actors, revenue agents, both in person and in writing. When someone realizes his/her creditor/sovereign standing, all confusion evaporates, and he/she has knowingness and certainty of what should be said and done in any circumstance. The above sample dialogue has been provided only because it is a vivid, easily understood illustration of how people can avoid being coerced into doing business with Big Brother at any level of confrontation. The issue of copyright infringement. There is really no problem with people using copyrighted property unless they use it for commercial gain, i.e., making money through the use of the private property without the copyright holder's authorization. As addressed elsewhere in this manual, all demands for payment constitute an issue of public currency. Remember, there is no substance money in circulation. Until 1933, Federal Reserve notes could be redeemed in lawful money in the United States, meaning that Federal Reserve notes never were and are still not lawful money. Having left the gold standard, we are now on the promise to pay standard. A promise to pay now creates money and is what funds your mortgage, auto loan, credit card purchases, and every other kind of loan you take out, in parentheses, including traffic tickets. A promise to pay is a negotiable instrument, in parentheses, money, and is defined at UCC 3 104. The traffic cop in the above example intended on taking out a loan, and the name of the motorist straw man's trade name by extracting the motorist promised to appear and then pay, thus saddling him with the bill as surety for the trade name. The copyright notice short circuits anyone from using your trade name for unauthorized commercial gain, the primary objective of virtually every single government on the face of the earth. Notes from page 21 and 22. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in the world history, the U.S. government. Representatives James A. Traficant, Jr., Congressional Records, March 17, 1993, Volume 33, see Chapter 11, Reorganization and Glossary. All's fair in love and war, and the U.S. government officially and legally declared war on the American people on March 9, 1933, and the Amendatory Act of March 9, 1933, to the Trading with the Enemy Act of October 6, 1917. For a detailed explanation of your official enemy status, see Trading with the Enemy Act of October 6, 1917. The term booty is legally defined as the capture of personal property by a public enemy on land and contradistinction to prize, which is a capture of such property at sea. The right to booty belongs to the sovereign, but sometimes the right of the sovereign or of the public is transferred to the soldiers to encourage them. Bouvier's Law Dictionary, 8th edition, 1914. Legally speaking, at least in accordance with the Amendatory Act of March 9, 1933, to the Trading with the Enemy Act of October 6, 1917, judges and IRS agents are public enemies of the American sovereign constituency, soldiers in service of foreign masters, and appropriately share handsomely in the booty plunder they capture in the course of their duties. Judges administer and enforce copyrighted law of British corporations exclusively, and IRS, officially disclaimed as an agency of the United States government by the United States Attorney, is domiciled in Puerto Rico under the Secretary of Treasury of Puerto Rico. Notes on page 23. For the four other factors sufficient for voiding any contract, see contract and glossary. Visceral, pertaining to the visceria, the internal organs of the body, as the stomach, lungs, heart, instinctive or emotional. End notes. Consent equals contract. Had the motorist even rolled down the window upon the officer's opening statement, he would have had formed a damning contract with the officer. Two timeless and universal maxims of law are: contract makes the law, and offer plus acceptance equals contract. The motorist's acceptance of / compliance with any offer / order from the officer before establishing the fact of duress finalizes a consensual in parentheses mutually approved contract between the two, whereby the motorist has decided that he will do business with the officer on the officer's terms. thereby providing the officer with justification for the use of any necessary violence in carrying out any duties associated with the contract. In parentheses, expropriating revenue. When one party, anyone, approaches another party seeking cooperation, information, etc., and the approached party cooperates provides information, the approaching party is automatically in the driver's seat and is calling the shots, i.e., his offers of communication are being accepted and acted upon. Police and other such professional provocateurs, especially judges, are experts in including cooperation and participation both through the threat of violence incarceration and the use of deceitful communication techniques by the prey is tricked into entering the contract before becoming aware that any contract has been formed. The pretext used by Big Brother's henchmen for slyly establishing contracts with unwitting customers are many. The object of all such cons, however, is always the same: the victim citizen's wealth (money, property, assets). Code enforcement type actors are seeking the slightest measure of justification for carrying out their agenda. Nearly all of them know that consent is required every step of the way, though many will arrogantly storm ahead without it, thinking they are above the law. They may be above statutory law /code, but no one is above the articles of the Uniform Commercial Code governing private, consensual contracts. A unique aspect of consensual contracts is that the agreed upon terms may be privately enforced, in parentheses, true commercial law, because there is no controversy /dispute needful of resolution by a third party, in parentheses, a judge /court. The UCC is prejudicial and non-judicial. That is why the creditor /motorist in the above example begins seizing certain property registered in the officer's trade name following the officer's default on payment of the obligation after having been given the opportunity to back out of the contract, and after being properly invoiced because it is so stated in the consensual contract, in parentheses, both the copyright notice and subsequent formal contract that the creditor /motorist could send the officer if he were issued a citation. The officer would have consensually entered the contract if, after having been fully noticed of its terms, he did not fully, formally, and officially withdraw and delete /erase or /destroy all traces of the motorist's copyrighted property brought into existence by him, in parentheses, and possibly even surrender all original documents, written, electronic, and taped, and all copies thereof, containing both the policeman's signature and the motorist's trade name, depending on the severity of the terms of the contract set by the motorist. Notes, page 24. Title 17, United States Code, Chapter 1, Section 107, Statutory Law, lists fair uses of copyrighted material do not constitute copyright infringement. None of the fair uses includes commercial gain. See copyrights and glossary. What is not scared off with the copyright notice can be crushed with either a couple of new documents revealed in the practical portion of this manual that identify the transgressing party by name and set the terms of the consensual contract. And notes. Creditor equals sovereign. In modern global society, there are few truly sovereign jurisdictions where outside creditors, in parentheses, Federal Reserve /IMF, do not have final say-so over that domain and anything in it. When anyone can dictate the terms of a contract with any government's code enforcement personnel, That party is the creditor in the matter and a sovereign by definition. This is an escapable fact because, based on the negative value / liability aspect of the currency, all such purported valuable consideration, e.g., FRNs, all FRNs are borrowed into existence and represent debt / liability only. There is, for all intents and purposes, no other way of actualizing political sovereignty on this planet at this time. The sole possible exception might be using overwhelming military force, but any such undertaking is rare and short lived because the same small group behind the Federal Reserve / IMF consortium dictates over the armed forces of all major powers of the world, including United Nations. From the top, these fiends own / control all official media of exchange, currencies, and foreclosed on all governments of any stature and installed their own talking heads decades / centuries ago. Therefore, the fullness of your own political power / autonomy / sovereignty is determined solely by your personal abilities in dealing with government frontmen who attempt to engage you in contract at the behest of their masters. The currency / government owners, creditors, for the purpose of expropriating your wealth, assets, and resources without exchanging anything of value. Sovereign political power is wielded when a would be commercial invader / marauder withdraws and abandons his / her assault on your property / freedom based on the liabilities involved in doing business with you. When you can enforce a private consensual contract against members of the corporate government of the country you live in, despite the fact of being their declared enemy in war, you have indeed demonstrated sovereignty as well as it can be demonstrated. The real game is not being legally detached from all commercial intercourse in society. The real game is being actively engaged in any and all desirable social / commercial exchanges in life, just not being penalized / punished solely because one is a participant. The unfortunate status quo for most folks in America at this time. Notes at page 25. This phenomenon is evidenced nowhere more clearly than in contemporary American courtrooms when a judge threatens a patriot type with contempt if he continues bringing up the issue of constitutional rights. Technically speaking, a traffic citation recipient / shadow sovereign, for example, abandons the Constitution in favor of the vehicle code the instant he forks over his driver's license and begins doing business with a traffic cop long before entering the courtroom. End note. Taking control of the trade name. Whereas the copyright notice officially establishes legal title, the trade name under common law, and sets forth the terms of the consensual contract for its unauthorized use, the UCC is what is used for enforcing the terms of the contract. Even though the copyright notice does not depend on the UCC for its validity and enforceability, its provisions are written in strict accordance with UCC guidelines for facilitating easy and thorough non-judicial foreclosure proceedings on any who would attempt commercial gain at your expense through unauthorized use of your trade name. However, the paperwork aspect of dealing with assaults / attacks on your freedom / property will not be taken up here, but rather under handling presentments and the practical portion of this manual. What's good for the goose is good for the gander. If government agents, prosecutors, judges, attorneys, police, taxmen, etc., can freely engage your ens legis, artificial person, straw man, trade name, and business, then so can you. That their computers are rigged for listing account names in all capital letters only, a practice falling outside both the bounds of English grammar and the prescriptions of law, when such could just as easily be programmed for writing in English, is conclusive evidence that a different game is being played than the one advertised. Every conceivable roadblock for deflecting general comprehension of this most ingenious of subterfuges has been meticulously installed down through the centuries, with unimaginably complex safeguards for keeping even lower level operatives in the dark, pleading innocence and claiming helplessness based on feigned, archaic computer programming limitations, however, will no longer wash as an excuse from Big Brother's frontmen. Besides copyrighting the trade name under common law, the most important objective is establishing an equivalent claim under the aegis of the UCC. Since you are a different party than the ens legis trade name, you may do business with it if you desire. You can also obtain official acknowledgement of the contract from a government agency, the UCC filing office. The following series of documents has been painstakingly developed and formulated for maximal protection of this contractual relationship, thereby preventing any third party from intervening and impairing the private contract. Notes of page 26. The National Security Agency's modern Echelon computerized global electronic surveillance system with installations in Yakima, Washington, USA, Wallahopia, New Zealand, Geraldton, Australia, Hong Kong, and Morgenstow, UK, employing Cray supercomputers capable of executing 1 billion transactions a second, taps into the system of the Intelsat satellites and currently tracks in real time all fax, telex, internet, email, and long distance telephone traffic worldwide using verbal electronic word recognition technology, key trigger words, and intercepting monitoring all such traffic. Governments fronts for their masters, the Federal Reserve / IMF cabal, are in business strictly for extorting money from the constituency, and no expense is spared in ensuring that the flock is properly fleeced. If the accounting and computer systems are set up in a certain way, then that is what guarantees maximum profit. The lame. That's just the way our computers are set up. All caps mode is a hackneyed ruse that will only work on those who still believe that the government is here for the purpose of helping people. End note. The private agreement, contractual basis of the relationship. The document that establishes the contractual relationship between you, the living, breathing man / woman, as the creditor, and the trade name, the corporately colored ens legis, artificial person, straw man, as the debtor, is called the quote unquote private agreement. As a redemptor, the only requirement for forming this contract is the personal certainty that you are not the trade name and that the trade name is a bona fide legal entity, separate and distinct from you. The private agreement is a bargain of the parties in fact and qualifies as an quote unquote agreement. under the code at UCC 1 102 parentheses 3. A sample two-paged private agreement for the fictitious character John Henry Doe and his straw man, in all capital letters, John Henry Doe, is provided in the practical section and should be studied for full understanding of the nature of this particular type of creditor-debtor relationship and why such an agreement / contract is entirely legitimate. Your private agreement is just that, private, and should never be filed in the UCC filing office nor shared with any adversary. This document is strictly between you and your straw man and forms the lawful basis of your contractual relationship with each other. As a member of the sovereign constituency, the Constitution provides that no state shall pass any law impairing the obligation of contracts. Your contract with this particular person, in parentheses, ens legis, is inviolate and shall remain so, unimpaired by any third party. The hold harmless and indemnity agreement, a most vital component. Despite all other incredibly positive aspects and elements of this process, if the following single point is not firmly and legally addressed and established, the whole effort can be nullified. As mentioned earlier in this essay, Big Brother's entrapment scheme consists of 1. Corrupting a sovereign's true name into all capital letter, citizen of the United States, trade name, and then 2. Conning the sovereign into unwittingly, voluntarily contracting as surety for the trade name, concealing from the victim his / her new status, but also ruthlessly enforcing the new suretyship obligations without explanation. The hold harmless and indemnity agreement is a commercial / legal document wherein the trade name debtor expressly covenants that 1. The creditor is neither a surety nor an accommodation party. See UCC 3 419 for the debtor. And 2. The debtor holds harmless and indemnifies the creditor, you, from and against any and all claims, legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summonses, lawsuits, costs, fines, liens, levies, penalties, damages, interests, and expenses both issued in and associated with the debtor's trade name. This issue is extremely profound when one realizes that a man / woman in jail awaiting arraignment, in parentheses, legal event where the defendant enters a plea before the magistrate, is not the actual defendant, but the surety for the defendant. Through more legal trickery, the unwary and unwitting surety is duped into unconscionably identifying himself / herself as the defendant when addressed by the magistrate as such, and thereby voluntarily and magically becomes the defendant from that point forward. And this type of exchange, the trade name, in parentheses, actual defendant, is legally and technically a dummy and serves as the legal object, at least on paper, until the surety associated therewith can be suckered into taking its place. The hold harmless and indemnity agreement is attached with the security agreement and made fully part thereof by inclusion in the filing process. A certified copy of a filed UCC financing statement referencing a security agreement and holding harmless and indemnity agreement as set forth in this manual constitutes documentary evidence that the all caps party named in any indictment, warrant, etc., is not the flesh and blood man / woman being held in captivity, but rather the artificial trade name. A fact of enormous legal significance considering the techniques used by the judicial system in attracting new customers, generating repeat business, and marketing their services. The security agreement. Creation of a security interest. Importance of the common law. A security agreement is a consensual agreement whereby a debtor transfers a security interest in collateral in exchange for valuable consideration, and is defined as an agreement that creates or provides for a security interest. Found reference in UCC 9-102, Section A, 73. A security interest is an interest in property that secures payment / performance of an obligation, found in UCC 1-102, Section 37, and is the UCC equivalent of a statutory lien, i.e., a security interest is prejudicial and non-judicial, whereas the private agreement lays out the terms of the commercial agreement between the two parties and is authenticated, meaning signed. See UCC 1-102, Section 39. By each, the security agreement concerns only the debtor's pledge of property, the collateral, and, accordingly, need only be authenticated by the debtor. There is nothing preventing the secured party from signing as well as is recommended herein. Following execution of the security agreement, the creditor is known as the secured party because he has the benefit of a security interest in the property of the debtor, i.e., he is secured. In the event the debtor does not make payment / perform as agreed, a secured party is a party in whose favor a security interest is created / provided for under a security agreement. See UCC 9-102, Section A, Section 72. When the security interest is said to attach, generally, the security interest attaches and becomes enforceable against the collateral the moment the following three requirements are satisfied. 1. There is an adequate security agreement between the parties describing the collateral. 2. The secured party, creditor, gives value of some kind. And 3. The debtor has rights, ownership in the collateral / power to transfer rights in the collateral. See UCC 9-203, Section B. There are, however, certain types of property for which attachment of the security interest can occur only in a certain way, other than filing, meaning that mere description of the collateral in the security agreement is not adequate. Notes. Redemptor, Latin, one who buys back or reclaims. For purposes of this manual, a redemptor is one who legally establishes the supreme claim, recovers legal title over his or her straw man's trade name. Revalue. Because of the contemporary de facto monetary system, which functions in a mirror image of reality via debt instruments, Federal Reserve notes, that carry an inherent liability, in interest and income tax, rather than lawful money, gold and silver coin, that carries no such liability, the UCC definition of value, a most significant term in the UCC, is 180 degrees out from the one found in conventional dictionaries. The bearing of this term on UCC matters is addressed in the practical portion of this manual. Types of personal property / collateral. There are two broad types of personal property classifications: tangible and intangible. Tangible property is categorized as goods, which means all things that are movable when security interest attaches and includes fixtures, goods that are attached with real property, some standing timber, unborn animals, crops, manufactured homes, and computer programs embedded in goods so that the software is considered part of the goods. See UCC 9 102, Section A, Section 44. All goods are subcategorized at UCC 9 102, Section A, based on their use in the hands of the debtor, into one of the following types: 1. Consumer goods, 2. Farm products, 3. Inventory, and 4. Equipment. Intangible personal property, on the other hand, is classified by its characteristics rather than how the debtor uses it, and consists of the following subcategories: 1. Money, 2. Investment property, 3. Commercial tort claims, 4. Letters of credit, 5. Letter of credit rights, 6. Chattel paper, 7. Instruments, 8. Deposit accounts, 9. Accounts, 10. Documents, and 11. General intangibles. There are many more subclassifications of personal property, but all fall within one of the above 15 categories of tangible and intangible property. Fortunately, the intricate distinctions of and between all the different kinds of personal property are less significant for our needs than they are for those of Big Brother's henchmen. We are merely bolstering our own position for maintaining commercial integrity. Big Brother's operatives are out there playing the game of swindling people's wealth while attempting to avoid general detection as being engaged in such activity. Remember, the substitute money, Federal Reserve notes, system is designed expressly for generating defaults and bankruptcies, and channeling all private wealth into the hands of the owners of the governments. That is why it is so important that the money power have encrypted codes for keeping people in the dark about the law remedy and recourse, and blackmail politicians in their pocket for passing draconian totalitarian legislation to crush dissenters, thwart popular movements, and establish a global plantation. Legally establishing, perfecting the security interest. Perfection of the security interest after the security interest has attached is usually accomplished by the filing of a record known as a UCC financing statement. In the UCC filing office, in parentheses, located in each state, District of Columbia, and most of the territories of the jurisdiction where the debtor is located, in parentheses, considered a resident. Perfection of the security interest by filing is available for most types of collateral and is discussed further below. However, a few types of collateral require that the security interest be perfected by a method other than filing in the UCC filing office, where a means other than filing is required for perfection. A secured party can perfect a security interest in deposit accounts, parentheses, demand, time, savings, and passbook accounts maintained with the bank, electronic chattel paper, investment property, and letter of credit rights only by control, see UCC 9 314. A security interest in certificated securities in registered form can be perfected only by delivery into the possession of the secured party. See UCC 8 301. In the two foregoing methods of perfection, the security interest both attaches and is considered perfected upon control and delivery, respectively, with no filing requirement. UCC 9-203, Section B, Section 2. Also, the filing of a financing statement against property covered under any certificate of title statute, as well as any other non UCC central filing statute, is neither necessary nor effective perfection of the security interest directly on the face of the certificate, where secured party is called lien holder, and covers such things as automobiles, trailers, mobile homes, boats, farm tractors, and the like. Other federal statutes cover items such as aircrafts, ships, trademarks, copyrights, and patents. In parentheses, common law trademarks and copyrights are not governed by statute. And the filing of a financing statement is likewise ineffective for perfecting the security interest. The redemptor is in a unique position to establish legal control of these types of property and that he can form another contract with the debtor, e.g., storage contract, that must be satisfied before any lien holder can legally take possession of / sell the property, in parentheses discussed in the practical portion of this manual, end of parentheses. Though the filing of a financing statement will perfect the security interest in all other subcategories of collateral, the code also allows for perfection of the security interest by simple possession of the following types of collateral: negotiable documents, goods, instruments, money, tangible chattel paper, and certificated securities. See UCC 9-313. For this reason, the sample security agreement contained in this volume contains a statement therein the debtor, in parentheses trade name, and parentheses acknowledges having delivered all such property into the possession of the secured party, thus covering these particular types of collateral by both filing and possession. The power of the common law. Perfection by possession is a species of common law lien, i.e., non statutory, and is effected with a simple statement at the top of the security agreement whereby the debtor acknowledges delivery of all such property, in which a security interest can be perfected by possession into the hands of the secured party. A common law lien is a species of lien defined as one known to or granted by the common law as distinguished from statutory, equitable, and maritime liens. It is a right extended to a person to retain that which is in his possession belonging to another until the demand or charge of the person in possession is paid or satisfied. Black's Law Dictionary, 4th edition. Thus, you have the non statutory, non judicial, common law origin of your claim of right of possession of the negotiable documents, goods, instruments, money, tangible chattel paper, and certificated securities associated with your straw man debtor's trade name. You have a common law right for retaining possession of all such property until the obligation is satisfied, in parentheses paid off, end of parentheses, by the debtor, parentheses your straw man, end parentheses, unless and until the obligation is satisfied in full. Neither the straw man nor anyone else may lawfully remove a single piece of any of his property, i.e., the collateral, that has been delivered into the secured party's possession. The common law is ancient and immutable. established by usage and custom since before recorded history. As strange as it may seem, the common law is still in full force in effect today. People just don't know it because they have been conned into believing it doesn't exist. In parentheses, courtesy of the Federal Reserve no currency monopoly scheme cabal, end parentheses, and unwittingly consent, parentheses, surrender privacy, granted jurisdiction, end parentheses, with virtually every single advance made against them by government and legal forward slash commercial predators. In fact, our impossibly complex legal forward slash judicial system and its billions of pages of codified law, including the UCC, has been developed over the last millennia by the creditors, in parentheses, money changers, in parentheses, for the express purpose of circumventing the protections afforded debtors by the common law, parentheses, through lexical trickery, deceit, obfuscation, end parentheses. The UCC is the culmination of these efforts. However, despite the universal power of the UCC, it is still junior in the face of the common law, as attested by this excerpt from one of the world's most respected authorities on the UCC, Anderson on the Uniform Commercial Code 1981. Statute 1 1036. Common law. The code is complementary to the common law which remains in force except where displaced by the code. In attempting to codify a large body of law, it is almost impossible to anticipate all the factual situations that may arise. And it is for this reason that courts have adopted the principle of statutory construction, that a statute will not be construed so as to overrule a principle of established common law, unless it is made plain by the act that such a change in the established law is intended. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. Courts should be hesitant to improvise new remedies outside the already intricate scheme of Articles 3 and 4. However, this new cause of action would not interfere with that scheme but extend its principles to a situation not specifically foreseen by the drafters. The code cannot be read to preclude a common law action. Whereas any item of property that is registered in a public registration scheme, i.e., with a government agency, should be specifically identified in the security agreement. A description of all other personal forward slash real property is sufficient whether or not it is specific if it reasonably identifies what is described, with a few minor exceptions. See UCC 9-108. A properly done security agreement is vital for maintaining fiscal integrity, i.e., maintaining control of every single piece of property under the sun, moon, and stars that is considered private property of the trade name. Remember, the entire artificial person and solvent industry community, functioning as it does solely on debt, liability instruments, Federal Reserve notes, is incapable of establishing accounts and doing business with insolvent sovereign creditors. Only bankrupt subject debtors, such as your all caps trade name, and of course the surety, parentheses, the shadow sovereign in his inferior degraded status, end parentheses, associated therewith. The sample security agreement provided in the practical portion of this manual between John Henry Doe and John Henry Doe is certainly many hundreds, if not thousands, of man hours in the making. Big Brother's legal experts will not be pleased with the soundness of this document. Full realization of its integrity and value will come only with earnest study, unless, of course, one simply begins using it as needed and observes the response from the legal professionals that are confronted with it. Notes. For a comprehensive list of every kind of personal property in existence, see collateral, section and security agreement in the practical portion of this manual. Draconian, pertaining to Draco, an archon, magistrate of Athens, about 621 BC, reputed author of the first Athenian written code of laws, or his laws, hence inflexible, severe. North Carolina, Nat Bank vs. McCarley and Company, 1977, 34 NC, App 689, second edition, or SE2D, 58323, UCCRS 455. Starsky Construction Incorporated vs. Eklon Incorporated, 1970. 248 ARC 958, 978A 457, SW2D 509, 7 UCC RS 923. United Bank vs. Moss and O'Neilson Company, 1979. 121 Arizona 438, 590, P2D 1384, 25 UCC RS 1113. Gerard Bank vs. Mountain Hawley State Bank, or Mount Hawley State Bank, 1979. DC, New Jersey, NJ 474 F SUPP 1225, 26 UCC RS 1210. The UCC financing statement, perfecting the security interest by filing, legally establishing. Besides perfecting by control, delivery, and possession as described above, the secured party can perfect the security interest in most types of collateral by filing. The UCC filing office is a public venue for the registration of notice of private contracts. Since the only legal tender currency in America is the private scrip of the Federal Reserve, all exchange of the so-called money has private implications. Hence the advent of the prejudicial and non-judicial, i.e. private, UCC in 1954, and the Uniform Commercial Code Filing Office, which keeps track of the ever-increasing stream of private contracts, in parentheses, registered therein by those in the know, end parenthesis, wherein Federal Reserve notes comprise the valuable consideration between the contracting parties. UCC filing offices provide a central forum where a creditor / secured party can receive official governmental acknowledgement of the private contract between himself and a debtor, as well as establish seniority over other creditors based on date and time of filing. The foundational filing document is a simple form known as a UCC financing statement, formerly called a UCC-1 financing statement, before July 1st, 2001, containing 1. The name of the debtor, 2. The name of the secured party, and 3. A sufficient indication of the property pledged by the debtor as collateral in the transaction. See UCC 9-502, Section A. The financing statement only puts third parties on notice of the secured party's perfected security interest in the debtor's collateral. The security agreement is what creates the security interest and must reasonably identify the collateral described, whereas The financing statement can be general in its description of the collateral. See UCC 9-504, Section 2. The security agreement must meet certain requirements. See UCC 9-108. But the collateral indicated in the financing statement must jibe, meaning match up, with the collateral described in the security agreement for the effectiveness of either in securing the collateral, i.e. the financing statement, and security agreement are complementary components. Neither is effective without the other. There is no requirement that a copy of the security agreement be included with the filing of the UCC financing statement, only a sufficient indication of the collateral covered. See UCC 9-502, Section A, Section 3. The only requirement is that the security agreement be authenticated, i.e. signed by the debtor. See UCC 9-203, Section B, Section 3, Section A. Public filing versus privacy. When a secured party voluntarily makes public the intimate details of the private security agreement, in parentheses, between secured party and debtor, end parenthesis, by including it in the filing of the financing statement in the Uniform Commercial Code filing office, where anyone can easily obtain the information simply by paying for it. He/she foregoes any privacy protections afforded under common law and the fourth article of Amendment of the Constitution. There is no compulsion for making public the private contractual relationship between secured party and debtor. Therefore, it is recommended that the security agreement be only accurately identified in the Uniform Commercial Code financing statement and not filed along with it. Here is a real-life example from a December 31st, 2001 article in the obituary section of the Los Angeles Times, page B11, on the late Ian Hamilton, revealing the liabilities that come with voluntarily placing private information in the public record. Hamilton had created notoriety for himself by writing an unauthorized biography on J.D. Salinger, called the J.D. Salinger A Writing Life. Salinger opposed publication of the book for several reasons, but the only line of attack available was in suing for Hamilton's use of Salinger's common law copyrighted material for commercial gain, i.e., insertion of about 70 of Salinger's private letters written to publishers, editors, and friends between 1939 and 1962. In the book, here is a portion of the article. The biographer and publisher won the first round when a New York federal judge ruled Hamilton's book cannot be dismissed as an act of commercial voyeurism or snooping into a private being's private life for commercial gain. It is a serious, well-researched history of a man who, through his own literary accomplishments, has become a figure of enormous public interest. Hamilton's suing of Salinger's copyrighted material is minimal and insubstantial. The judge continued in his 33-page decision, which was seen as a victory for the First Amendment, and does not exploit or appropriate the literary value of Salinger's letters. But in early 1987, a federal appellate judge overturned that decision and banned publication of the letters. The U.S. Supreme Court upheld the ban. Biography revised after court feud. Both writers, as it turned out, won some and lost some. Salinger won his goal to keep his letters out of the biography, but thanks to this civil suit, the letters became part of the public record, more accessible than ever. Hamilton recouped, excising the letters, but revising the biography to include insights gleaned from the bitter court feud. He published In Search of J.D. Salinger in 1988. Salinger's private common law copyrighted material was just that. Until that is, Salinger voluntarily made it part of public record by entering it into the lawsuit. Salinger successfully stopped publication of Hamilton's original book, in parentheses, because it contained the letters, Salinger's common law copyrighted material, end parentheses, but officially placed it into the public domain, the very information he wished kept confidential. Though the actual letters themselves were not used in Hamilton's second book, all the information contained within the letters was now in public realm, fully accessible and available for anyone's use, including Hamilton's. Noteworthy points. 1. A common law copyright is a supreme claim. And 2. Voluntary surrender of information is a waiver of privacy and security protections afforded by Article 4 of the Constitution. However, there are many more ways of surrendering one's privacy / sovereignty than anything as extreme as a court case, and like J.D. Salinger, nearly every sovereign American man and woman repeatedly and inadvertently does this throughout his or / her life on a regular basis. The sample security agreement in this handbook is designed for keeping private as much information as possible and need not be publicly filed along with the financing statement, merely authenticated, signed by the debtor. This security agreement is also believed legally impregnable by third parties, and a redemptor who understands and knows the proper use of this document can begin to enjoy the profound benefits associated with its use. Financing statement is defined as a record or records composed of an initial financing statement and any filed record relating to the initial financing statement. UCC 9-102, Section A, Section 39. Modifications, changes, and adjustments of the original financing statement are implemented with what is called a UCC financing statement amendment, formerly called a UCC 3, before July 1st, 2001, in most jurisdictions, and a UCC 2 in others, as revealed in the definition of financing statement above. Any subsequent relating UCC financing statement amendment filed qualifies as any filed record relating to the initial financing statement, i.e., any amendment is absorbed by and automatically becomes part of the original financing statement. Recap. Publishing a notice of common law copyright Ray the straw man's trade name / trademark establishes common law control of the trade name, i.e., the debtor in the relationship. Filing at the county records office further solidifies the ownership of the common law copyright. The foundational contractual document between debtor and creditor is called the private agreement and evidences the commercial agreement and the rights and duties by and between the parties in the mutually beneficial, in parentheses, consensual, commercial transaction. The debtor indemnifies the creditor in the hold harmless and indemnity agreement, and the legal distinction between the two is made clear. The creditor establishes a bona fide claim called a security interest, equivalent of a lien, and the property pledged by the debtor as collateral by giving valuable consideration. The security agreement is a document authenticated, in parentheses, minimally, end parenthesis, by the debtor and contains a description of the collateral that secures the indebtedness in a favor of the creditor, who is now called the secured party. When the debtor authenticates the security agreement, the security interest attaches and becomes enforceable, except for a few types of collateral. When the secured party files a UCC financing statement and references an existing authenticated security agreement therein, the secured party's security interest in the collateral is considered perfected, meaning legally established. Generally, the earlier date and time of filing determines priority in the debtor's collateral between competing creditors. Any desired changes in a financing statement are effected using a UCC financing statement amendment, which becomes part of the original financing statement upon filing. Notes: over the telephone, you are putting yourself into the line of fire. How important is it that you prove what a nice, cooperative guy you are? Any information about you collected by government and code enforcement personnel can and will be used against you at the first possible instant. The sole purpose for collecting information in the first place is the extraction of wealth and the infliction of control. Never unnecessarily, voluntarily, publicly reveal anything about yourself with Big Brother. I revised Article 9. As near as discernible, the primary aim of the new Article 9, which deals with secured transactions, is the establishment of wholesale methods for foreclosing on a defaulting debtor's property, in parentheses, the collateral, without using the courts, i.e., the high-speed transfer of wealth, in parentheses, yours, into the hands of the money power and its minions. Even the UCC itself, it appears, has been formulated as an entirely new system for circumventing the ancient protections in a debtor's property, in parentheses, collateral in a transaction, afforded by possession under the common law. The UCC and now revised Article 9 have introduced sophisticated methods for obtaining the debtor's consent and agreement concerning disposition of the collateral in event of default at the time the contract is formed. This means fewer headaches for your friendly credit lender, in parentheses, bank, in seizing the property of victim debtors as the defaults roll in, an inexorable eventuality under the current financial scheme, in parentheses, non-substance debt currency. In accordance with revised Article 9, contemporary commercial contracts, mortgages, loan agreements, credit applications, etc., have also been cleverly formulated for obtaining the borrower's consent for converting all the debtors after acquired, in parentheses, after execution of the contract, property into collateral, but without the borrower's awareness of the fact, and then foreclosing on / seizing such property upon default without any need for a court order. People who enter into such contracts without a security agreement, in parentheses, against their trade name, firmly in place, have no protection over property acquired after entering into a loan agreement should they default. And remember, the monetary system is expressly designed to create defaults in loan transactions so the owners of the system can legally expropriate the victim's property without arousing suspicion of foul play. A major character flaw of modern Americans in general, in parentheses, that the entire UCC is designed to prey upon, is their propensity for accepting loans of credit, in parentheses, something for nothing, and living beyond their means. The take on the credit lending vampires would be significantly diminished if people stopped asking for handouts, in parentheses, borrowing, using credit, and began surviving strictly through their own efforts and living within their means. This might mean a temporary reduction in standard of living, but at least one would be on solid ground financially, living within reality, and free of the inherent fear of default foreclosure and financial ruin that is a part of a parcel with keeping up with the Joneses. The system cannot easily dominate those who do not borrow. Some wise words from William Shakespeare's Hamlet appearing in the front of this book are requoted here. Neither a borrower nor a lender be, for loan oft loses both itself and friend, and borrowing dulls the edge of husbandry. Notes: possession is 9/10 of the law, except revisions in Article 3, negotiable instruments, and Article 4, bank deposits and collections before 2010. Defaults and bankruptcies are a mathematical certainty in a credit money system. When money is loaned into circulation, only the principal amount is created. Any payments of interest must come from an amount loaned out, the principal. It is easily seen that paying off both principal and interest is a mathematical impossibility because the total money in circulation consists only of the principal amount loaned. E.g., a loan of 10 credit units with an annual interest rate of 10% requires a payoff after 1 year of 11 credit units, but there are only 10 credit units in existence. If interest payments were made before 10 consecutive years, in parentheses, payments totaling 10 credit units, the money supply would vanish, but the principal amount would still be owed. The only way of satisfying the requirement of making interest payments yet maintaining an adequate supply of currency in circulation is through borrowing. An ever worsening debt scenario, in parentheses, the national debt is owed to the Federal Reserve Bank, husbandry, in parentheses, capital O-E, hus, H-U-S, house, plus banda equals freeholder, and parenthesis, economy, thrift, Shakespeare Lexicon and Quotation Dictionary. Benefiting from the UCC and revised Article 9. The complexity of today's multifaceted judicial, taxation, financial, and political systems, and the breadth and depth of collusion and complicity within and amongst their ranks cannot be exaggerated. Management personnel in each, beginning at the bottom and going all the way up, know that continued financial gain is predicated solely on the establishment of commercial accounts and people's mirror image, artificial person, all capital letters trade name, and the execution of billing, collection, and foreclosure procedures against said name. Experience with actors at all levels in each of the above sectors has revealed that all are familiar with the nature of the game, and the higher the level, the more knowledgeable about ensuring its perpetuation. Operatives within the system, each an integral cog in the revenue extortion conveyor belt, are generally afforded virtual, if not complete, immunity by the powers that be for crimes committed in the line of duty. In parentheses, judges could not operate without immunity, In case you do not know it already, the only time an out of control bureaucrat will reform and change his/her ways is when faced with the possibility of personal liability/loss/damage/etc. Heretofore, there have been few solutions for bringing about such results. The essential difference between those who quote unquote work in the modern government and those who work in the private sector is that the latter must, for the sake of survival, produce a valuable product/deliver a valuable service that someone will voluntarily exchange money/something of value for. Generally, government and other code enforcement types, in parentheses IRS, for one is not part of the government, are insulated/exempted from this otherwise most basic requirement for survival in today's society, living instead off wealth extorted from others who actually do the work and produce articles/services of value. Modern governments using valueless Federal Reserve/IMF scrip as the exclusive medium of exchange are sanctimonious, self-protecting, self-aggrandizing, parasitic, bankrupt, commercial front operations for their shyster creditor masters. Offered herein are simple procedures for using the same techniques against those who would deceitfully subjugate you and enrich themselves courtesy of your labor and misplaced trust. The self-preservation process depends on your awareness of 1. Your true name and trade name as legal entities, in parentheses artificial persons, separate and distinct from you, and 2. Your common law right to be compensated for the use of your private property, and the methods afforded by the UCC for enforcing this right, a reminder of how things can actually be if enough people stop consenting with tyranny in any form. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Declaration of Independence, 1776. Notes. Property may not be taken by government, even for public advantage or welfare, without just compensation. Louisville Bank vs. Radford, 295 U.S. 555, 601, 602. United States vs. Butler, 297 U.S. 1. Railroad Retirement Board vs. Alton R. Company, 295 U.S. 330. Section 2. The Truth About Esquires, Addressing the U.S. Judicial System. The Truth About Esquires, Addressing the U.S. Judicial System. Probably the most fundamental, foundational datum that must be confronted by today's student of the law. Such student has any hope of achieving ongoing success in the application of knowledge of law is that all law, and this statement includes every genre of codified law in existence, capped off by the Uniform Commercial Code, has been stealthily and artfully converted into private, corporate policy, and that the administrators of this corporate policy are none other than actors within and without the insolvent, in parentheses bankrupt, commercial enterprise known as, quote unquote, United States, and its creditors. The Federal Reserve / International Monetary Fund Syndicate. Governments use laws. Corporations use policy. This is one reason why the term public policy has replaced its predecessor, public law, and common legal parlance, the news media, and elsewhere. You may have wondered why the term quote unquote United States in the previous paragraph is not preceded by the word the United States, is a solecism institutionalized by constant use over a long period of time. There is nothing plural about the contemporary use of the term United States. United States is a singular proper noun. Correct usage does not include the antecedent definite article. The United States is a corporate trade name, like General Motors, and identifies a corporation, albeit federal and municipal, but a corporation nevertheless. Just as General Motors does not imply a plural number of motors that are somewhat general in nature, United States does not imply a plural number of states that are somehow united. Just as proper English does not include the Canada, the Finland, the Egypt, and the like in common parlance, it likewise does not include the United States. And the implication of a plural number of states slyly and injuriously implants an erroneous notion in the mind of readers / listeners, just as the state of Great Britain appears in the Declaration of Independence 1776, and the state of Israel is mentioned daily in the news media. The state of United States is far more accurate an identifier for what is erroneously conveyed by use of the solecism. The United States, the proper recital of the name, identifies the for-profit bankrupt commercial enterprise incorporated on February 21st, 1871 in Washington, D.C., presently managed by the receiver in bankruptcy, Secretary of Treasury of Puerto Rico, aka Secretary of the Treasury. Notes: solecism, an ungrammatical combination of words in a sentence. From 1776 to 1789, the United States were a confederation. After 1789, it was a federal nation. Excerpted from the definition of federal in a Standard Dictionary of the English Language. Funk and Wagnalls Company, 1903. The U.S. government incorporated as a for-profit commercial enterprise in the Legislative Act of February 21st, 1871, 41st Congress, Session 3, Chapter 62, page 419, and chartered a federal company entitled United States, i.e., United States 1871, aka U.S. Inc., a commercial agency originally designated as Washington, D.C., in accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases Diet v. Turner, 1968, 439, P.2, lowercase d, 266, 267. State v. Phillips, 1975, 540, P.2, lowercase d, 936, as well as Coleman v. Miller, 307 U.S., 448, 59, capital S, period, capital C, lowercase t, period, 972, 28, Toll Lane Law Review, 22, 11, South Carolina Law Quarterly, 484, Congressional Record, June 13th, 1967, lowercase pp, dot 15,641 15,646. The United States government is a foreign corporation with respect to a state. 19 Corpus Juris Secundum 541. Location of United States. The United States is located in the District of Columbia. Uniform Commercial Code UCC Section 9-307, Section H. Secretary of the Treasury of Puerto Rico was appointed receiver over bankrupt United States and Reorganization Plan Number 26 in 1950, Title 5, United States Code, Section 903, Public Law 94-564, parentheses, Legislative History, page 5967. Secretary. The Secretary of the Treasury of Puerto Rico, Title 27, Code of Federal Regulations, Section 250, 11. The title, Secretary of the Treasury, is a euphemistic abbreviation of the actual title, Secretary of the Treasury of Puerto Rico, also known simply as Secretary. A most insidious jurisdiction. The following legal precept, however simple, reveals the source of more personal and international grief, misery, suffering, despair, chaos, and loss of life than can presently be imagined by nearly anyone outside the inner circle, and that is payment. In parentheses, consideration sets the form of law, i.e., the mode of payment in any particular transaction sets the applicable jurisdiction for resolution of any dispute / controversy arising out of any matter concerning that transaction. This unassuming little aphorism points the way for the serious student of history, politics, and economics, past all the highfalutin authorities, and through the looking glass, and into the sprawling spectacle of the most pervasive and all-consuming confidence game in the history of the world. It transcends all national boundaries and establishes venue for the unqualified commercial conquest of mankind, the artificial, private, corporate, quote-unquote jurisdiction of the Federal Reserve notes. All courtrooms in America today are commercial marketplaces dealing in matters bearing exclusively upon the private commercial scrip known as Federal Reserve notes. The notion of the halls of justice is an ancient fable. Today's courtrooms are impersonal businesses under the jurisdiction of a foreign, occupying military power that are managed from the bench. Parentheses from the Italian banca, bank, and parenthesis, by merchant bankers called judges and magistrates, who enforce private, copyrighted, corporate policy, in parentheses known as code, wholly owned by British corporations. The business of the court consists of admitting attorneys wishing to conduct business and adjusting and balancing accounts between debtors and creditors transacting in Federal Reserve notes. FRNs who come before it and consent to have disputes resolved in this, America's modern judicial forum. Esquires. Esquire, from Middle French esquire. Esquire, shield bearer. From Lower Latin, scuterius. From the Latin, scutum, shield. Arius, Ari, is defined as, originally, a shield bearer or armor bearer, an attendant on a knight, in modern times, a title of dignity. Next in degree below knight and above gentleman. Webster's Revised Unabridged College Dictionary notes, aphorism, a short saying stating a general truth. Highfalutin, slang, pompous, bombastic. Numerous Caribbean, Central American, and even South American countries have adopted the US dollar as their national currency. Foreign banks that keep Federal Reserve notes on deposit are subject to all Federal Reserve regulations, examination, and disclosure requirements. Scrip, paper money issued for temporary use in an emergency. The Merriam-Webster Dictionary. America is currently under military occupation by the conquering foreign creditors of the Federal Reserve /IMF and its garrison troops, the British Esquires of the Bench, and the bar associations. The term mission statement is strictly a military designator, and any organization with a mission statement is a military unit. All 15 bureaus of the Puerto Rico-based Department of the Treasury, including Internal Revenue Service, Securities and Exchange Commission, and Bureau of Alcohol, Tobacco, and Firearms, all state tax agencies, and all bar associations operate under a mission statement. Esquires, in parentheses, judges and attorneys, are military officers of the Crown, in parentheses, another front for Federal Reserve /IMF, carrying out the overall mission of the bar. It is ironic that the various branches of the United States military, the U.S. Army, Navy, Marine Corps, Air Force, and Coast Guard, do not tout a mission statement. The Thompson Group LLC, Ltd., with offices located in Montreal, Quebec, Canada, owns, among other things, West Publishing Company, Barclays, West Group, Bancroft Whitney, Clark Boardman, Callahan, Legal Solutions. Black's Law Dictionary is copyrighted British law and, like all the rest, private, non-public domain property. Attorney, strictly one who is designated to transact business for another. Black's Law Dictionary, 7th edition. The truth about esquires. In English law, a title of dignity, next above gentleman and below knight. Black's Law Dictionary, 1st edition, 1891. A man belonging to a higher order of English gentry, ranking immediately below a knight, applied to various officers in the service of a king, as a title accompanying a man's name. In the U.S., the title belongs officially to lawyers. The Oxford English Dictionary, 1971. Dignity and nobility are synonymous, interchangeable terms, and the word manipulators use each to deflect attention from the other whenever needed. Nobility, the persons collectively who enjoy rank above commoners. The peerage, as English nobility, the qualities which constitute distinction from rank in civil society, according to the customs or laws of the country, that eminence or dignity which a man derives from birth or title conferred, and which places him in an order above common men. Webster's 1828 Dictionary, hereinafter Webster's 1828. Dignity. In English law, an honor, a title, station, or distinction of honor. Black's Law Dictionary, 1st edition. The state of being noble, an elevated title or position, a person holding an elevated title, a right to hold a title of nobility, which may be hereditary or for life. Black's Law, 7th edition. Elevation, honorable place of rank or elevation, the rank of title or a nobleman. Webster's 1828. As can be seen above, an esquire is a title of nobility, holding shield bearer for the king / queen of England, and takes the lead against any with whom the crown desires to engage in battle. Officially, all bench officers, in parentheses, bar member, judge, and magistrates, and attorneys in America are esquires, officers in service of the crown. In legal / commercial terms, they are foreign-based merchants in commerce. See UCC 2-104. Enforcing private corporate policy of their British liege lords and employers against unruly colonial belligerents, in parentheses, American customers, who are deceived and coerced into using the commercial scrip currency of the private foreign-owned Federal Reserve Bank Federal Reserve notes, and who also, out of ignorance, bewilderment, and the instinctive urge for survival, continually attempt avoidance and sometimes even unlawful evasion of the corporate policy, in parentheses, e.g., Internal Revenue Code, governing the privilege and benefit, albeit compelled, of using such. Today, all crimes, including murder, are classified, categorized, and addressed strictly as commercial pecuniary charges by the militaristic merchants who own and operate the legal system, issue the codes, and dictate over government. This fact is officially acknowledged at Title 27 of the Code of Federal Regulations, Section 72.11. This single section of Title 27 alone confirms the undeniable supremacy and applicability of the UCC in all legal matters in every American courtroom, as well as others throughout the world. Notes: UCC Uniform Commercial Code. Statutory Instrument 1997, number 1778. Social Security. The Social Security, abbreviations United States of America, Order 1997, made 22nd July 1997, coming into force 1st September 1997, at the courtroom at Buckingham Palace, the 22nd day of July 1997. Present, the Queen's Most Excellent Majesty in Council, or the Government of the United Kingdom of Great Britain and Northern Ireland. William Marsden, parentheses, America's Director, FCO, for the Government of the United States of America. Timothy E. Deal, parentheses, Minister, Embassy of the United States of America. For complete text, visit http://www.hmso.gov.uk/legis.htm. Pecuniary, of or pertaining to money. See Crime is Commerce in Appendix. Start looking more closely at the articles in the newspaper, especially the business section. It is increasingly common for hearing about criminal charges being resolved out of court, i.e., via payment. Debunking the mythical license to practice. Newspapers and television media chant incessantly about so-called license to practice law. Bar Association attorneys do not possess any such license to practice law, but they are nevertheless accused of it in the California Business and Professions Code, in what can only be hailed as lexical legerdemain, in parentheses, brilliance in the devious use of words, of the highest order. The code encrypting esquires in government have successfully bamboozled even their own kind in convincing all of the existence of the almighty license to practice law. The following analysis should thoroughly disabuse anyone of any such misconception. Whereas the notion of a license to practice law is scarcely mentioned in state and federal codes, the requirements and parameters surrounding every other kind of license in existence are spelled out in mind-numbing detail. In parentheses, vehicle code, internal revenue code, etc. The sacred license to practice law, however, is as undefined and elusive as the wind. Where it comes from, which agency of government issues it, whose signature is on the certification, how it is conferred, where one goes so he can see one of these things and examine it, what the tenor, in parentheses duration effective period, of the license is, what the cost of the license is. These and other intensely pertinent questions remain unanswered by the codes that foist the implication of its existence upon us. Here is a front row seat for observing the word manipulating esquires, both in and out of government, in action. California Business and Professions Code, Cal B&P, the 6000 series of which is also known as the State Bar Act. At section 6002 is the solitary code section in all of California code that proclaims that any such license was never issued, but it does not tell us which government agency issued it. And likewise, where one can go to see one of these things. Section 6125 of the same code discusses the practice of law and bar membership. Section 6125 reads, necessity of active membership in state bar. Definition: no person shall practice law in California unless the person is an active member of the state bar. Section 6002, members. The member of the state bar are all persons admitted and licensed to practice law in this state. These two cites appear innocent enough, but a glaring outpoint is that they reference entirely different jurisdictions. And Statute 6125 is applicable only in California, and Statute 6125 pertains only in this state. California means the original de jure California Republic as described in the 1849 California Constitution. In this state, however, per California Revenue and Taxation Code, means the de facto federal territory under control of District of Columbia, aka United States, Inc., and expressly excludes the de jure California Republic. Whereas California has a sovereign constituency, i.e., flesh and blood men and women living on the land under the common law. In the state signifies the federal state of California, with its subject citizen of the United States, persons existing under statute in an artificial realm. There is no other plausible, coherent explanation for not using the identical term in each section. For this reason, and this reason alone, Statute 6125 and 6002 bear no meaningful relation with each other. Both sections cited only persons. The only persons in California are corporations and other corporately colored entities, in parentheses, trade names. Since the de jure California essentially disappeared from the legal scene with the arrival of the U.S. bankruptcy in 1933, statutes 6125 proclamation makes as much sense as the vehicle code asserting no person shall drive an 18-wheeler on Route 66 unless that person is a member of the Teamster Union. Notes: disabuse, to free from error, fallacy, or misconception. Per California Revenue and Taxation Code Statute 6017, 11,205, 17,018, and 23,034. The terms in this state, and state are defined for tax jurisdiction purposes as District of Columbia, aka United States. What is the State Bar of California? A potentially fatal discrepancy in both sections cited above is that the entirely named, i.e., the State Bar, aka the State Bar of California, does not legally exist. The California State Constitution, Article 6, Section 9, and the California State Bar Act, codified at California B and P 6001, respectively, make the following proclamations. Section 9. The State Bar of California is a public corporation. 6001. The State Bar of California is a public corporation. All bona fide corporations, public and otherwise, must be registered with the Secretary of State. The corporate seal promoted on the letterhead of the State Bar of California indeed bears an incorporation date of July 29th, 1927. But the Secretary of State's office informs this author that, per their records, State Bar of California as a public corporation does not exist. In parentheses, State Bar, not a registered public corporation, in appendix for a printout of State Bar's missing listing as a public corporation in the California Secretary of State's online records of corporations. Speaking with 12 different personnel at the headquarters of the State Bar in San Francisco, as high up as the executive director's office, no one can answer the following questions. What type, in parentheses, legal classification of organization is the State Bar of California? What is the significance of the alleged date of incorporation, July 29th, 1927, on the corporate seal touted by the State Bar of California on their stationery? Why does the State Bar of California advertise a corporate seal if the alleged corporation attached thereto is non-existent / defunct and unregistered? Why is there no record of the State Bar of California as a public corporation at the Secretary of State's office when both the State Bar Act, in parentheses, at California B and P 6001, and the California State Constitution by amendment, in parentheses, November 8th, 1966, at Article 6, Section 6, specify that the State Bar of California is a public corporation? As of this writing, February 2002, the Office of the Executive Director of the State Bar of California is circulating a memo within State Bar offices that describe the nature of the organization for all employees, as quoted over the phone by a very helpful senior administrative assistant at the offices of the State Bar, who shall remain unnamed. The State Bar of California is a constitutional agency in the judicial branch of the state government, and the purpose of the State Bar is to act as the administrative arm of the California Supreme Court in matters relating to the regulation of the legal profession. The only problem with the above advisory memo is that the constitutional agency is not how the Constitution and the State Bar Act, in parentheses Cal B and P 6001, legislative acts that created the State Bar, identify State Bar of California. Both specified that it is a public corporation, not a constitutional agency. Complicating matters, California Secretary of State refuses to issue a certificate of non-filing, in parentheses $5 fee, a standard form for any unregistered, non-filing public corporation. For State Bar of California, claiming that the State Bar Public Corporation was formed by statute in parentheses legislative act and therefore not formed in accordance with the California Corporations Code. Hence, lack of statutory authority for Secretary of State to issue the certificate. State Bar of California is broadly and openly touted as a public corporation, but has cleverly exempted itself from registration, in parentheses, to conceal its books and records, resolving the paradox and revealing the utter deceit and criminal intent of the State Bar and the dissemblers that created it. Is the following obscure cite from 7 Corpus Juris Secundum 9. In view of decision that creation of public corporations by special acts is prohibited by state constitution, the State Bar Act, creating State Bar Corporation as public corporation, has no viability, and designation of State Bar as public corporation has no legal efficacy. Case law, Bridegroom v. State Bar, 550, page 2D, 1089. 27 Arizona, APP 47. The State Bar Act creating the State Bar as a public corporation has no viability, and the public corporation formed thereby has no legal efficacy. The State Bar enjoys the best of both worlds anyway, an apparent agency of government, enjoying the power and protection of the state, including exemption from taxation, but in actuality a pirate institution without legal basis. A conglomerate of sycophantic flunkies, in parentheses attorneys, at the beck and call of the judicial system, in parentheses that enforces copyrighted law of British corporations, operating outside the bounds of law that the rest of us must contend with every day just to survive. How could we expect anything less from the profession whose very existence is predicated upon the ongoing ignorance of its victim customers, its practices and policies? Notes: Route 66, former undivided highway running between Chicago, Illinois, and Santa Monica, California, officially decommissioned in 1985. Bar membership. Section 6002 tells us members of the State Bar are admitted and licensed to practice law. Admitted into what? Licensed by whom? The word mastery of this simple proclamation in both satisfying the reader's perfunctory inquisitiveness, yet firmly establishing ambiguity, boggles the mind. Reading these two Cal B and P sections, one might get the idea that State Bar members are the only ones who can ever obtain a license to practice law. However, because of the way Section 6002 is worded, non-members of the State Bar are not excluded from being admitted and licensed to practice law in this state. Similarly, as shown below, bar membership is a result of, i.e., follows being admitted and licensed to practice law in the state, whereupon the admitted party is then granted membership in the State Bar and a bar card, not the other way around. Case note precludes. Generally, membership in a bar association is optional with the individual attorney. But where a unified or integrated state bar organization is established, membership and payment of dues may be required as conditions of practicing law in the state. 7 Corpus Juris Secundum 8. In re Gibson 4P 2D 643-35. NM 550. Cal B and P Statute 6125 and 6002 are the only two code sections that bring bar association attorneys into the realm of legitimacy. A recap of significant discrepancies. Only state bar members can practice law in de jure California, which was, for all practical purposes, disposed of on March 6, 1933, i.e., Statute 6125 is pure camouflage. Though the media and courts would have us believe otherwise, non-state bar members are not excluded from being licensed to practice law in the state. State bar members have been licensed to practice law, but when and where and how and by whom we are not told. And California Business and Professions Code requires membership in a non-existent / defunct public corporation. The State Bar of California does not issue licenses, cannot issue licenses, because it is nothing more than a freewheeling private trade union posing as an agency of government. Quoting from a statement issued by Governor Pete Wilson's office in a May 30th, 1998 article from the LA Times entitled, "Wilson Suggests Change to the Let Bar Survive." Quote, "The bar now acts as a trade organization promoting the legal profession while continuing to regulate and discipline attorneys, a dual responsibility that may of its own member attorneys call a conflict of interest," said a statement issued by Wilson's office. If the state bar were indeed the source of the mysterious license to practice law, then it would be an absolutely indispensable component of the California state government, in parentheses, an impossibility, without which no attorney could be licensed, proving the importance of the State Bar of California and the falsity of the licensing myth associated with it, is the following article from the April 14th, 1998 edition of the LA Times. Quote, "Beleaguered State Bar faces uncertain fate. Agencies, it will begin going out of business as a result of Wilson veto unless legislator acts quickly. Critics 2 years ago launched a referendum on whether to abolish the bar, but with just over half the state's lawyers voting, the bar survived. About 65% of the respondents opposed dismantling it." Another quote, "The bar has escaped other brushes with death. In 1985, the legislature refused for several months to allow the Bar Association to collect dues because of its abysmal record in disciplining lawyers." If the existence of the Bar Association hinges on an internal vote of its disgruntled critics, i.e., Bar Association attorneys complaining about paying dues and disciplining themselves, and could have easily been abolished in 1985 and 1996. The state bar can be dismissed as irrelevant as the source of any so-called license to practice law. However, apparent intent is to bring about the idea in the mind of the public that an attorney's bar card is his license to practice law. Regarding the conduct and professional standards of esquires, there is no state or federal regulatory agency in America governing such matters. Quoting Oceanside, California Republican Assemblyman Bill Morrow, who sponsored a bill for overhauling and shrinking the bar in 1998, the same LA Times article immediately above. Morrow said, and quote, that he is not worried that lawyer discipline will lapse. If no legislative breakthrough is reached by summer, the legislator will simply transfer lawyer discipline to the State Department of Consumer Affairs, the lawmaker said. End quote. Bar associations function merely as labor unions, like the Teamsters. Just as membership in the Teamsters Union does not confer the privilege of driving, membership in the Bar Association likewise does not confer the privilege of practicing law. Rather, membership in the Bar Association is a result of being admitted and licensed to practice law. The notion that a bar association has any obligation to discipline its members is fantasy, and whatever occurs is gratuitous. The American Bar Association, in parentheses, a voluntary membership association of attorneys per their website, each is one substantially nothing more than a union of local mercenaries, military personnel for hire, carrying a foreign title of nobility and operating under the aegis of the judicial system, which has vested pecuniary interest in the proliferation of its members. Attorneys at Law. Cal B&P 6067 specifies that it is merely a person, not a member of the state bar, that must have a certificate of his oath of office endorsed upon his/her license. Quote, every person on his administration shall take an oath to support the Constitution of the United States and the Constitution of the State of California, and faithfully to discharge the duties of an attorney at law to the best of his knowledge and ability. A certificate of the oath shall be endorsed upon his license. End quote. We are not told what is meant by admission in this code section, but if the bar card were the so-called license to practice law, then the above referenced oath would be inscribed upon it in certificate form and endorsed. No bar card, a credit card sized piece of plastic, has any such endorsed certificate of oath of office upon it. The only text appearing on the bar card of the State Bar of California concerns annual union dues. Quote, this certifies that the person whose name appears on this card has paid the annual fee required by statute. End quote. Punctuating this whole matter, your authors are personally acquainted with more than one practicing attorney at law who is not a member of the bar. If such attorneys at law are admitted and licensed to practice law in this state, in parentheses Cal B&P 6002, and do so, yet are not members of the Bar Association, upon exactly which license is their oath to support the Constitution of the United States endorsed. Notes. Paradox, a statement that seems contrary to common sense and yet is perhaps true. Dissemble, to conceal or disguise one's true nature, intentions, so as to deceive. Perfunctory, done merely for the sake of getting through, mechanical and without interest. The actual so-called license to practice law. The reason British esquires can practice law without a state-issued license in American courtrooms is that the courtrooms are no longer de jure government instrumentalities/operations, but rather private, monopolized commercial venues/marketplaces for enforcing the private, copyrighted, corporate policy in parentheses statutory law/code of the owners of the codes and the Federal Reserve notes, as mentioned earlier. Possession of a bar membership card, as in any labor union, means only that a particular esquire has attained at least some degree of expertise and that his/her union dues are current. Nothing else. The answer for the above uncertainty apparently lies in California Business and Professions Code Section 6064. Admission on examiner's certification, admission certificate. Quote, upon certification by the examining committee that the applicant has fulfilled the requirements for admission to practice law, the Supreme Court may admit such applicant as an attorney at law in all the courts of this state and may direct an order to be entered upon its records to that effect. A certificate of admission thereupon shall be given to the applicant by the clerk of the court. End quote. First of all, the fact that a separate body, the examining committee, must certify that an applicant has fulfilled the requirements for admission to practice law is further evidence that simple bar membership does not confer a license to practice law. Otherwise, Section 6002 would be sufficient in itself, with no further requirement for being licensed. Regarding the true importance of the so-called, quote, examining committee, referenced above in Section 6064, the Chief Justice of the Supreme Court unilaterally overrule its decision and admit any applicant that has been rejected as unfit/unqualified. Admission to practice law is controlled ultimately by the Chief Justice of the Supreme Court of the jurisdiction. Founding case law. Supreme Court has inherent power and authority to admit an applicant to practice law in this state, despite unfavorable report upon such applicant by Board of Governors of State Bar. Lacey and Ray, 1936, 11 CA 2D 699 81 P2D 935. The authority of the Committee of Bar Examiners is limited to investigating and recommending for admission those applicants found by it to be of the prescribed standards. Only the Supreme Court has the plenary power to admit applicants who, in the opinion of the court, meet the prescribed test, whether or not the committee agrees with the conclusion of the court. Case law, Green v. Zank, 1984, 2nd District, Cal, APP 3D, 497, 204, Cal, RP2R 770. End quote. Other sections of the code reveal that the license to practice law follows admission to practice law, not membership in the Bar Association. Found in 6060.5. Neither the board nor any committee authorized by it shall require that applicants for admission to practice law in California pass different final bar examinations depending upon the manner or school in which they acquired their legal education. 6060. To be certified to the Supreme Court for admission and a license to practice law, a person who has not been admitted to practice law in a sister state shall 6064.1. No person who advocates the overthrow of the government of the United States or of this state by force, violence, or other unconstitutional means shall be certified to the Supreme Court for admission and a license to practice law. A real-life example in the true nature of the so-called license to practice law, taken from a November 10, 2001 article in the LA Times entitled, Clinton Resigns from the High Court Bar. Quote, former President Clinton hereby respectively requests to resign from the bar of this court. His lawyer, David E. Kendall, said in a 2-page letter to the High Court's clerk. Clinton's resignation from the Supreme Court bar will have little practical impact. Clinton has not practiced before the Supreme Court and was not expected to argue any cases in the future. End quote. Clinton resigned only from the Supreme Court bar and from no other bar. The former so-called license to practice law in question is the certificate of admission issued by the British Esquire Chief Justice of the Supreme Court. Just like the one issued in de facto state of California, where the Chief Justice has final say-so over who gets licensed, in parentheses, Chief Justice is the Supreme Court, every other license to practice law held by Clinton for doing business in all other courtrooms remains intact. the only possible license to practice law. The certificate of admission does not fit the definition of license per se, but is a de facto license, as proven below, issued by the Supreme Court of the jurisdiction. Notes: plenary, full in all respects or requisites. Entire, complete, also complete, as embracing all the parts or members. End notes. Source of the license and the British title of nobility. Since the code painstakingly avoids ever actually naming / identifying the imaginary license to practice law, we must look deeper to discover the true nature of the certificate of admission and why it is construed as a license to practice law. An underlying aspect of the certificate of admission, and likely the only reason we are ever even told of a license to practice law, is because it is the equivalent of the right to practice law revealed at 7 Corpus Juris Secundum 4, page 801, and the actual referenced case. Quote, in this state, the right to practice law is conferred by letters patent, issued under the Great Seal of the state by its chief executive. The right to practice law is a property right existing by virtue of letters patent from the state as the sovereign. 168A, 229, 114, N.J., EQ 68. End quote. The word patent is defined as follows. 1. A manifest or apparent to everybody, requiring no search to discover, conspicuous, evident, plain as the fraud was patent, covered or protected by letters patent, secured from interference by government protection. 3. Open for general inspection as letters patent. 3. Law, a grant of any privileged franchise, etc., made by sovereign authority. A standard dictionary of the English language, Funk and Wagnall's Company, 1903. 1. A government protection to an inventor, securing to him for a specific time the exclusive right of manufacturing, exploiting, using, and selling an invention. The right granted. 2. Hence any official document securing right. Funk and Wagnall's Standard Dictionary, International Edition, 1958. End quote. The true relationship between Crown and United States should be coming into focus. The source of a patent, as well as letters patent, from the beginning has always been the sovereign, the Crown, the originator of this device. Because the Crown had a supreme need for distinguishing its commercial interests in America, while continuing to conduct business in the name of its strawman esquires, the notion of a sovereign artificial person, in parentheses, United States, a so-called sovereign state, had to be concocted and introduced into the legal world. Officially proclaiming United States a sovereign thereby endowed the enterprise with a sense of legitimacy and propriety. While still controlling utterly, however, the destiny of the new corporation via its esquires. For esquires, the chain of command still runs to the Crown. Historical note 24 of the 56 founding fathers, almost half were king's esquires. The actual case cited from Corpus Juris Secundum above, 168A, 229, 114, NJ, EQ 68, sheds more light on this phenomenon. Quote, in this state, the right to practice law is conferred by letters patent issued under the Great Seal of the state by its chief executive and Ray branch supra. This has been the custom from the very beginning of the province of New Jersey, in Ray Han supra, so that attorneys at law in New Jersey are the holders of a franchise granted by the state through the governor by letters patent by the same authority as formerly was exercised by the British Crown. 1 Pollock and Maitland's History of English Law, 191. A franchise is a royal privilege or branch of the king's prerogative subsisting in the hands of a subject. 2 BL Com 37, a special privilege conferred by government on individuals and which does not belong to the citizens of the country generally by common right. ANG. A. Corp. Page 4. Since the right to practice an ordinary calling, business, or profession is property, State v. Chapman supra, it follows that the right to practice a profession conferred by the state as a franchise by virtue of what was originally the king's prerogative is a property right. 168A, 229, 114, NJEQ 68. End quote. Investigating letters patent, we find hist. A document granting some right or privilege issued under government seal but open to public inspection. Black's Law Dictionary, 7th edition. An instrument proceeding from the government and conveying a right, authority, or grant to an individual. Black's Law Dictionary, 1st edition. From within the definition of letter, letters patent, an open document under seal of the government granting some special right, authority, privilege, or property, or conferring some title. A Standard Dictionary of the English Language, Funk and Wagnalls Company, 1903. No attorney can produce a valid state-issued license to practice law, and no such license exists. However, there is such thing as a right to practice law, which is a special property right and, as confirmed above within corpus juris secundum, said right is granted by means of letters patent. The so-called license to practice law can be none other than the letters patent certificate of admission, a document that can only be construed as the fabled license to practice law, and then only covertly by and within the judicial system, as confirmed in the dictionary definition of letters patent immediately above. The British Esquire run Supreme Court in the granting of letters patent tactly confers the British title of nobility, Esquire. Attorneys at law are free to begin using their new title upon receipt of the certificate of admission. Bar membership is incidental, in parentheses, non-essential, the right to practice law, end parentheses, follows in the wake of the letters patent and establishes a sham straw man between the judicial system and the people. Since there is no requirement that an attorney at law identify himself as an esquire, there must be some other factor at play that induces such extraneous behavior. Quote, admission to the practice of law is membership in an ancient and honorable profession that has for its goal the furtherance of the administration of justice, and the attorney is an instrument for the achievement of such noble purpose. McFarland v. George, App. 319, S.W. 2D 662. Admission to the practice of law is membership in an ancient and honorable profession that has for its goal the furtherance of the administration of justice, and the attorney is an instrument for the achievement of such noble purpose. Case law McFarland v. George, App 319, capital SW, 2D 662. Profession includes much more than the mere management of the prosecution and the defense of litigated cases. Case law, Commonwealth of Pennsylvania v. Wheeler, 73, capital P, A, Super 164. Accepting employment entails duty to courts and faithful performance of services. 7 Corpus Juris Secundum, 4, page 801. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. Case law 97, capital N, capital W, 2D 287, 255, MINN 307, in re Lord. What better way of advertising one's true colors, parentheses, military service, per Merriam-Webster Dictionary, re the source of one's newfound power, than by voluntarily affixing the addendum, King's Esquire, on the end of one's name. British corporations have now copyrighted and own every type of code within the entire U.S. judicial system. The private policy of British corporations is being enforced in American courtrooms in the form of a property right bestowed upon a special class of citizens who became British esquires. Black's Law Dictionary is copyrighted British law. Whereas the Bar Association is presented as the supreme force in the legal realm. It is actually only a club of private henchmen under the control of the Supreme Court, which grants a special property right, in parentheses, to practice law, in letters patent disguised as certificates of admission, thereby covertly conferring the title of Esquire upon recipients. The corrupt, unregistered, and illegitimate Bar Association dutifully slinks along behind the master, nevertheless, a vital tool in the designs of the legal masters of the world, a storefront for deflecting public scrutiny and providing a semblance of piety within the legal profession. Esquires carry out the business of the crown, i.e., extraction of both participatory payments arising out of the original commercial joint venture between the colonies and the crown, and war reparations, called war contributions. American colonial belligerence. Notes: Strawman, a front, a third party who is put up in name only to take part in a transaction. Black's Law Dictionary, 6th edition. Ex-mayor of New York Rudy Giuliani is the most recent recipient, but apparently the past many American presidents have each been honored with knighthood, Sir title of nobility bestowed by the crown. Piety, fidelity to natural obligations. End notes. The fox guards the henhouse. Besides the fact that all 3 branches of what passes for government in America, the legislative, judicial, and executive branches of bankrupt, de facto U.S. Inc., are run almost exclusively by personnel operating under a British title of nobility. Every prosecuting attorney at every level of government operates in a manner that makes a mockery of the separation of powers doctrine under attorney and client and corpus juris secundum 1980 we have. His first duty is to the courts and the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. The office of attorney is vital to the well-being of the court. Attorneys, as officers of the court, have duty to maintain respect due court, which duty should exceed that imposed upon the public generally, and which duty should not be looked upon lightly, should not be shirked under the guise of representing interest of a party litigant. 7 Corpus Juris Secundum 4. Duty of attorney is to court if litigant client's interest threatens a state interest. 7 Corpus Juris Secundum 43. 1. Who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. 7 Corpus Juris Secundum 4. It is generally accepted that an attorney is an officer of the court and, as such, an officer and arm of the state. 7 Corpus Juris Secundum 4. Virgin Islands Bar Association vs. Dench, D.C. Virgin Islands 124 F. SUPP. 257. The internal memo from the executive director of the State Bar of California referenced earlier is in complete harmony with the above cites from Corpus Juris Secundum. The State Bar of California is a constitutional agency in the judicial branch of state government, and the purpose of the State Bar is to act as the administrative arm of the California Supreme Court in matters relating to the regulation of the legal profession. As abundantly shown above, the duties and obligations of Bar Association attorneys lie within the court and the public. In parentheses, governmental interests, and never the client. Clients are fodder for the wealth confiscation and freedom usurpation activities of the court. Attorneys are elevated above others with a special property right and title of nobility and empowered with quasi-immunity to ensure that the courts get their daily ration of code-ignorant customers. Prosecuting attorneys are by definition part of the executive branch, but because all attorneys are officers of the court and members of the judicial branch, prosecutors must first reflect for the judge his or her lifeline in the marketplace, and second for the executive branch, which issues his/her paycheck. While the Attorney General is a part of the executive branch of government, as an attorney, he is also an officer of this court. When he appears in court in a legal matter, he is acting as an attorney. Case Law 255, capital MINN dot 370 97 capital N capital W 2D 287. This factor confirms the most egregious conflict of interest in government today, in that a prosecuting attorney's first duty is drumming up business for the court/judicial branch, private commercial enterprise, enforcing policy of British corporations. This arrangement is a self-initiating business monopoly operating under the charade of government altruism, where the prosecuting attorney's actual agenda is pleasing the judge and the judge's foreign masters by bringing in sacrificial client victims from the enemy camp, Main Street, USA, not in standing guard as a sentinel of freedom, as a member of the executive branch, and ensuring that justice prevails. This philosophy manifests for non-prosecuting attorneys as well. At a 1999 private get-together, a junior of LA's former city attorney, Gil Garcita, revealed in conversation with an associate of your author's that is primarily duty as third in command at the city attorney's office was generating new business for attorneys. The judicial system is a private business monopoly posing as an agency of government that dispenses justice and preserves and upholds the U.S. Constitution. Upon investigation, its actual agenda is found to be herding unwitting victims into court for sacrifice at the judicial altar. The judge-attorney brotherhood deals in secret clubhouse, members-only code words, language and procedure specially formulated to ensure that non-insiders do not comprehend what is transpiring. There is an almost infinite number of legal trapdoors, escape hatches, and secret diversionary techniques used for shunting knowledgeable customers when they get too close with the workings of the operation. The original, unenacted 13th article of amendment of the Constitution reads as follows: if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without consent of Congress accept and retain any present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. The entire purpose of the Crown's England's War of 1812 with America, despite having signed the Paris Peace Treaty only 29 years earlier, was the destruction of the official records containing the first 12 states' approval of the new article of the amendment, housed in the Library of Congress. Ratification by three-quarters of the 17 states was necessary before the amendment could be enacted, and Virginia was the only state that had not voted. The so-called War of 1812 was initiated before this could occur, although Virginia later passed the amendment as proposed. Once the building of its contents were destroyed by fire, the war was over. The British withdrew, and members of Congress were pressured in various ways to retain only extant prohibitions in the Constitution, which state merely that the U.S. government cannot grant a title of nobility and that the consent of the Congress is required to accept any and such title. The money changers overseeing the Crown thereby arranged for the continuing, unfettered, commercial conquest of America by stacking all three branches of government with de facto British military officers. Had the Library of Congress not been destroyed, we would have no British agents, esquires, attorneys holding political office in America, and no 14th Amendment, no U.S. corporation in 1871, no 15th Amendment, and no Federal Reserve Act of 1913, no bankruptcy in 1933, no personal income tax, no 6 trillion national debt, and no Social Security Ponzi scheme, and numerous other social, economical, political calamities, all handiwork of King's Esquires. Notes: genuflect, to bend the knee as an act of reverence or worship. Egregious, notably a conspicuously bad flagrant. As much as 1/3 of all court proceedings goes into a judge's retirement fund. A wartime practice described in the definition of the term booty, the capture of personal property by a public enemy on land, in contradiction to prize, which is a capture of such property at sea. The right to booty belongs to the sovereign. but sometimes the right of the sovereign is transferred to the soldiers to encourage them. Bouvier's Law Dictionary, 8th edition. The Supreme Prosecuting Attorney in America, the U.S. Attorney General, is also, per the 1994 U.S. Government Manual, page 390, the permanent representative to Interpol. Interpol is the International Criminal Police Organization, a 169-member nation intelligence gathering / dissemination group whose constitution requires that any such representative expatriate his or her citizenship, further identifying the foreign status of this particular esquire. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. The Constitution for the United States of America, Article 1, Section 9, Clause 8. Sugarcoating the deceit. The reason Hollywood cranks put out so many feel-good lawyer movies where the selfless, kind-hearted, benevolent attorney is played by a box office superstar. The reason there are so many attractive, popular actors and an ever-increasing number of engaging courtroom judge and attorney-related TV shows, the reason all judges carry a quasi-title of nobility, i.e., the honorable, the reason the media carries on the charade disguising the true nature of bar associations with the phony license to practice law, etc., is to obliterate the truth and persuade the masses via continuous bombardment with subliminal messages that judges and attorneys are a swell bunch of patriotic guys and gals who take up for the little guy and work tirelessly for truth, justice, and the American way. Such propaganda gushes forth with increasing frequency as required damage control for the devastating societal impact of the wholesale destruction of lives at the hands of esquires. The entire operation is predicated on keeping victim customers ignorant of the meaning of the secret code words and rituals employed in the process, an unfeeling, cold-blooded, reptilian mentality. The life of an esquire, i.e., all bench officers and all attorneys, is an ultra-deceitful, quasi-genocidal undertaking and charlatanism, where a successful career is determined by the esquire's efficiency and separating the esquire's clients and sometimes even adversaries of the esquire's clients from their wealth / freedom. Esquires deserve no sympathy from anyone because they play by a different set of rules than anyone else. Attorneys win only 50% of their cases, a mathematical fact, but a moot point because attorneys will always get paid, win or lose, whereas other professionals are paid based strictly on results and the quality of their work. Attorneys collect their inflated fees in full, even when they fail, and payment of attorney fees is enforced by the judicial system, conclusive proof of the inherently criminal nature of the U.S. judicial system and all its collaborators. After all, what is a criminal but someone in possession of a valuable commodity that was acquired without exchanging something else of value for it? Half of all fees collected by attorneys are obtained without fair exchange, not much different than extortion, ransom, and solicitation of bribes. The true nature of the legal brotherhood gets clearer and clearer. The judicial system enforces payments of legal fees by judicial decree, even when the attorney fails. So the attorney community will continue bringing business into the court. What other profession gets paid in full for complete failure? Notes: Ponzi scheme. Ponzi, a fraudulent investment scheme in which money contributed by later investors generates artificially high dividends for the original investors, whose example attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue producing activity other than the continual raising of new funds. This scheme takes from Charles Ponzi, who in the late 1920s was convicted for fraudulent schemes he concocted and conducted in Boston. Black's Law Dictionary, 7th edition. For details on the true nature of Social Security, see the curse of co-suretyship. Judges are accorded official immunity because conducting business would be impossible with such a built-in exemption for crimes committed. The quasi-title of nobility, the honorable, his honor, etc., accorded judges is an absolute public relations necessity and a permanent attempt in convincing all that, at least according to the esquires of the judicial system, the judge is honest, even a few, if any, of his /her customers /victims would concur. Contemporary legal profession actually exerts a negative, in parentheses, parasitic, influence on the gross national product, and that its functionaries create no value, but continuously siphon off enormous sums of wealth and money. Better to be a mouse in the mouth of a cat than a man in the hands of an attorney. Spanish proverb. End of notes. Money motivation. When the Fair Debt Collection Practices Act, FDCPA, was enacted on September 20th, 1977, in parentheses Public Law 95-101, the act exempted from its provisions an attorney collecting a debt as an attorney on behalf of and in the name of a client, seizing on the obvious advantage, in parentheses, a debt collector could not threaten legal action, for example, but an exempted attorney could. The number of attorneys handling consumer collection accounts quickly surpassed the total number of lay collectors in the entire industry. Representatives of a major national law firm testifying in a hearing before a subcommittee of the U.S. Senate on May 25, 1983, estimated that in 1982 alone, it received 365,471 consumer accounts for collection, representing a total dollar value of more than 355 million, roughly 10 times the volume collected by average ACA American Collectors Association member agency, determined by National Survey. This law firm also testified that nearly 92% of the consumer collection accounts it handled that year did not involve legal action, i.e., no lawsuit was necessary for 92% of the money it collected. Quoting from the House Report 99 through 405, 1986. Quote, the application of several provisions of the Act to attorneys collecting debts are worthy of note. The restrictions of Sections 804 and 805B on contracts with third parties, neighbors, employers, regarding a consumer's debt are intended to protect the privacy of consumers' financial affairs. These contracts are not legitimate collection practices and result in serious invasions of privacy, as well as the loss of jobs. The committee discerns no reason to make any distinction based upon the identity of the debt collector. End quote. Besides threatening the entire lay collection industry with extinction within 5 years of inception of the FDCPA, practices of the debt collecting esquires generated so much enmity in American consumers /voters that Congress was besieged with demands for help, and in 1986 officially removed the attorney exemption, As cited in the House report, the original basis for the exemption was a belief that state bar associations would adequately police attorney violations, but the evidence revealed a different scenario. The main concern of state and local bar associations is not the protection of consumers, but the protection of lawyers. Despite their setback with the FDCPA, attorneys still have a license for subterfuge, deception, and thievery, courtesy of the monopoly over the field of law held by the bench officers, the coven of esquires. You begin doing asset searches on judges and government attorneys. The magnitude of the con begins to come into focus. Many of these characters are fabulously wealthy, and a great many of them, especially judges, have transferred title of all real property from their name into the name of a trust. The potential of getting nailed under their own name for misdeeds committed against an unending stream of unhappy customers is certainly enough reason to take such measures. Esquires are motivated by money, the lowest form of motivation, proven by the very nature of their profession, an exclusive cult with foreign allegiances whose members thrive on withholding vital information from clients, adversaries, and other marks, in parentheses, intended victims in a confidence game, and who will casually and callously trash the life of anyone for the sake of personal financial gain, depending utterly on the ignorance of the victim clients to perpetuate the con and stay in business. Based on first-hand knowledge and experience, the loftier the position, the more perfidious. Notes. Of or relating to the laity, the mass of people as distinct from those of a particular field, lacking knowledge of a particular subject. Enmity, the spirit of an enemy, hostility. Coven, a secret conspiracy or agreement between two or more persons to injure or defraud another. Black's Law Dictionary, first edition. A secret contrivance between two or more persons to defraud and prejudice another in his rights. Bouvier's Black's Law Dictionary, 8th edition. We always say that we have the most unhappy customers in the world, he said. They are either being sued or are defendants in a criminal case, or are defendants in a family law case. Gerald Kippen, Los Angeles County. End notes. Government Esquire Debt Collectors. Even though regular attorneys must comply with the FDCPA in the collection of debt, government esquire debt collectors do not. Government officials, i.e., U.S. attorneys and assistant U.S. attorneys, are exempted from the act and labor under no such restraints in conducting business. As mentioned earlier, all crime is commercial. Parentheses, Title 27, Code of Federal Regulations, Section 72.11. With a commercial financial charge attached therewith, and any occupational demand for money is classified as debt collection. Government debt collecting esquires bring in tremendous sums of cash for themselves and their masters, unhindered by the restrictions of the FDCPA. A revealing related fact concerning debt collection personnel at IRS, while government officials are expressly exempted from the FDCPA, IRS officials are not. Section 511601-24-2001 of the Internal Revenue Manual reads as follows. Quote, Fair Debt Collection Practices Act, IRC 6304, requires the IRS to comply with certain sections of the Fair Debt Collection Practices Act, FDCPA. These deal with contracts regarding unpaid tax and harassment and abuse of taxpayers. The law applies to contacts with all taxpayers, including corporations and partnerships. If IRS were an agency of the U.S. government, there would be no mention of the FDCPA in its manuals. IRS is not part of the government. So IRS esquires are bound by the restraints of the FDCPA like all other non governmental debt collectors. Military courtrooms. The law of the flag tells us that the colors flown in any forum / on any vessel dictates the law form and jurisdiction under which that entity is conducting business. Original legislation describing the American flag is found at Title 4, United States Code, Chapter 1, Sections 1, 2, and 3. Flags not meeting these exact specifications are expressly excluded as American flags. The flags that fly in today's courtrooms is not the American flag described in Title 4, but rather a gold-fringed military flag of war enforcing the private general equity admiralty / maritime law of the same merchant bankers and shippers who swindled America's gold and bankrupted and conquered the U.S. government between 1907, in parentheses, known as the money panic of 1907 and 1933, in parentheses, depletion of gold stocks and repudiation of obligations, i.e., could not make good on promise for redeeming gold certificates equals insolvency / bankruptcy. Quote, placing a fringe on the national flag, the dimensions of the flag, and arrangement of the stars are matters of detail not controlled by statute, but within the discretion of the President as Commander-in-Chief of the Army and Navy. 34 Ops, Addy, Gen. 483, 1925. End quote. American courtrooms are stacked with foreign military personnel, in parentheses, esquires, in quest of a military objective, in parentheses, mission statement of the Bar Association, doing battle with enemies, in parentheses, debtors of the crown, the creditor, and extracting war reparations, in parentheses, war contributions / taxes from belligerents, American sureties, in the field, battleground colonies, by law. Any courtroom flying a military flag is a military courtroom tribunal under martial law rule. Courtroom flying a military flag is a military courtroom / tribunal under martial law rule. Admiralty is a unique jurisdiction and that it carries criminal penalties for civil offenses. The only jurisdiction where military might is employed to enforce private contracts. Under martial law, the accused is guilty until proven innocent, and a judge, in parentheses, master of the ship / vessel, rules summarily in an administrative proceeding without a jury, as it does in traffic and misdemeanor cases in America. In such matters, the customer has two choices. 1. Appear before a bench officer and attempt to prove himself innocent. 2. Simply concede guilt and mail in the payment. Failure to convene a jury for felonies and certain other circumstances can make for too much bad publicity and so is avoided. Conquest through commerce. You may have wondered why China is on the mind of so many American politicians, and why actors within the U.S. government have been such vocal and legislative champions of China's cause and obtaining most favored nation trading status and being allowed admittance into World Trade Organization, known as the WTO. China, which represents the largest source of cheap labor in the world, China can be undercut Mexican labor by as much as 90%, was bankrupted in 1933, along with America and every other noteworthy government at the time, and was thereafter converted into a communist state in 1949. The Mother Lodge of manpower has now been successfully harnessed for dominating by outproducing and undercutting the labor force of every nation in existence. The planetary economic free for all that quietly began upon China's entrance into the WTO. The inevitable denouement of the clandestine love affair between Beltway commies and Chinese labor is portended nowhere more clearly than in an article from the January 27th, 2002 edition of the LA Times. Cranes lift upstart above competition, page C1. Quote, San Francisco, beneath autumn skies, a freighter carrying four of the world's largest container cargo cranes glided into San Francisco Bay, squeezing under the Golden Gate Bridge en route to the docks of Oakland. That day in the fall of 2000 was a spectacular but not singular triumph for an upstart Chinese company that dominates manufacturing of the most important piece of maritime machinery other than ships. The story of ZPMC's, Shanghai Zhenhua Port Machinery Company's, rise illustrates the gathering and at times controversial economic might of China as it dominates new sectors of global commerce. After being launched in 1992, ZPMC took just 6 years to become the leading maker of ship to shore cranes, and the company has remained at or near the top. In U.S. ports, where the company sold dozens of towering cranes for $5 million to $7 million, for the formula for success was simple: bid low and build alliances. Using its own Chinese labor and its own fleet of delivery ships to cut costs, ZPMC consistently underbid the competition by hundreds of thousands of dollars or more. China's role in the chosen master's attempted conquest of Earth is that of the great equalizer, i.e., the commercial force that amalgamates all competition into a homogeneous mass of ineffectual workers and consumers. And the banker frontmen in District of Columbia have spared no effort to ensure that China's need receive top priority. Did you ever ask yourself how China and Russia ended up on the UN Security Council and its inception? Business as usual for the same gang that conceived, in parentheses, beginning in 1931 in New York City, organized, financed, precipitated, orchestrated, and dictated strategy and tactics for United Nations Coming Out Party World War II. Article 1, Section 10, Clause 6 of the Constitution says, no state shall pass any law impairing the obligation of contracts. Because treaties are voluntarily entered into, international contracts and the obligations of contracts is inviolate. Treaties take precedence over the Constitution by default, and we are hopelessly mired in the entanglements of the political, military, ecological obligations that the DC based executive superstructure has decided is good for us, i.e., enforcement of the will of its masters, the owners of the Federal Reserve notes. The global political landscape is changing, and it doesn't have as much to do with national boundaries as it does with the most common medium of exchange. Anywhere in the world you find Federal Reserve notes changing hands, you will also always find the IRS. Why? IRS is a private, Puerto Rico based intelligence gathering, accounting, and collection agency responsible for policing the travels of every single Federal Reserve note in existence and penalizing / fining anyone that comes in contact with one of these things. If such an unwitting recipient does not carry a U.S. passport, no problem. Virtually every government on earth is bankrupt to the same bankers. So there is not much to concern about where the tax is collected. It all ends up in the coffers of the owners of the banking system. Notes: see Army Regulation, page 840, 10, and 260, 10. 34 Ops, Addy, Gen. 83, and Presidential Executive Order 10,834 of August 21st, 1959. Per Army Regulations, only in military courtrooms are such flags flown. For an entertaining and insightful discourse on the theft of America's gold, see Wizard of Oz in glossary. Surety: a person who is primarily liable for the payment of another's debt or the performance of another's obligation. Black's Law Dictionary, 7th edition. A distinction exists between martial law rule and martial law. Martial law rule has been the normal operating condition in America since 1861, when rulership devolved into the hands of the President of the United States in his capacity as Commander-in-Chief of the military. Martial law, on the other hand, is a state of express, undisguised military rule, with troops in the street and the military serving as police, governing all civilian functions. Americans will know that the country is officially under full-fledged martial law if the President, in a televised address from the Oval Office, ever has a red fringed flag displayed by his desk. Denouement, or denouement, the final unraveling or solution of the plot of a play, novel, or short story. Issue, outcome, any final issue or solution. Portend, to give a sign or warning of beforehand, as in the case of United States, United Nations, is a singular proper noun requiring an apostrophe for the possessive. The primary objective behind instigation of World War II was the establishment of the United Nations, a centralized global police force. A secondary objective was the utter dissemination, depredation, and denigration of the German people, and the complete commercial, fiscal subjugation of Germany. World War Part II, coming only 20 years after World War Part I, was mandated because World War Part I had failed in establishing League of Nations. End notes. An indispensable tool of the chosen masters. A major turning point in the history of Western civilization was the gory, one-sided Battle of Hastings, 1066 AD, wherein a tranquil English society was forever transformed by an invasion of barbarians under the tyrant William, Duke of Normandy, William the Conqueror, a pawn of the chosen masters. The most significant aspects of the conquest were those in the field of law. Anglo-Saxons were stripped of rights and privileges they had enjoyed for 300 years. An effective dictatorship was established, with William collectivizing the executive, legislative, and judicial branches of government under his solitary control. And lastly, but possibly the most detrimental, long-term consequence of all, was the introduction of Norman French attorneys, who brought with them a new language that destabilized the fabric of society and made legal mincemeat of the defenseless Englishmen unlearned in the new French dialect. Quote, Law French, the corrupted form of the Norman French language that arose in England in the centuries after William the Conqueror invaded England in 1066, that was used for several centuries as the primary language of the English legal system. Black's Law Dictionary, 7th edition. All the foregoing are classic tactics and stratagems of the legal masters of the world, a modus operandi that reappeared in America. The land of the free and the home of the brave has more people in prison per capita than any other country. In parentheses, former rights and privileges are now crimes. Courtesy of the Trading with the Enemy Act of October 6, 1917, as amended, and emergency war powers, parentheses 12th, Statute 319, 50, USC, Statute 21, 213, 215, Appendix 16, 26, CFR, Chapter 1, Statute 303, 1 through 6, Section A, and 31 CFR Chapter 5 Statute 500 period 701 penalties. President retains supreme dictatorial power over all aspects of American life and government. Like William, as Commander-in-Chief of the military, e.g., no congressional approval needed for war, all courtrooms in America flying the gold-fringed flag of war are military tribunals under the President's direct control. Complete power over all commerce, transportation, agriculture, communication, etc. And it is the foreign language of attorneys and the encrypted codes, the stock in trade of esquires, that keep them elevated above the sheep that must be shorn. Founding Father Esquires. A glaring and alarming historical fact is that the Paris Treaty of 1783 between Great Britain and United States of America was negotiated on America's behalf by three prominent kings esquires, Benjamin Franklin, John Jay, and John Adams, and each is so identified in the treaty, e.g., John J. Esquire. Curiously, Franklin, the principal negotiator, spent most of his time during the war years traveling between England and France, where George ruled as king simultaneously over both, and Ireland as well. Despite apparently having just been defeated in war, it was King George, not Congress, who convened the Treaty of Peace. He was represented by another officer of the crown, David Hartley Esquire. Since America supposedly won the war, thereby becoming Great Britain's international equal, it is illogical that we would afterwards seek rights granted by King George at the Treaty of Peace. How could George be in any position for granting America anything in the treaty, such as its own land, the land that he supposedly had just officially lost control of and relinquished via military defeat? Why would America's negotiators enter a contract that would effectively nullify the sovereignty we had just achieved? The treaty was signed neither on the soil of the apparent victor, in parentheses America, nor the apparent loser, in parentheses Great Britain, but in a third jurisdiction, France, also decided upon by King George. If we won the war, why were we incapable of dictating the terms of a treaty with a vanquished former foe from a position of strength? The Jay Treaty of 1796, authored by one of the same negotiating esquires, John Jay, also confirms the dubious nature of the outcome of the war. As the king promises hasty withdrawal of his armies, garrisons, and fleets, and the peace treaty of 1783, we find that his forces are still in place 13 years later. Quote, The Paris Peace Treaty, Article 7. There shall be a firm and perpetual peace between this Britannic Majesty and the said States, and his Britannic Majesty shall with all convenient speed withdraw all his armies, garrisons, and fleets from the said United States, and from every post, place, and harbor within the same time. End quote. Quote, the Jay Treaty, Article 2. His Majesty will withdraw all his troops and garrisons from all posts and places within the boundary lines assigned by the Treaty of Peace to the United States. End quote. The Jay Treaty also reveals who holds the upper hand in finance and commerce, requiring the U.S. government to repay certain debt owed British Martins by American civilians. Article 6. Prohibiting trade of molasses, sugar, coffee, cocoa, and cotton with any country in the world other than Great Britain. Article 12. And outlawing trade of numerous items easily construed as war contraband with an enemy of Great Britain. Article 18. An independent confirmation of the United States of America's inferior negotiated status is contained in an excerpt from a 1795 Supreme Court case. And Hallowell v. Dewan's Administrators. 3 U.S. 54 1 L.ed.507 3 Dow 54. On 14th January 1779, Congress resolved that they would not conclude a truce or treaty with Great Britain without the consent of France. The plausibility of a different practical outcome of the Revolutionary War, at least commercially, cannot be denied. That the American negotiators in the Treaty of Peace legally identified themselves as officers of the Crown, holding a British title of nobility alone, should excite a thorough investigation. World domination through deceit. The tradition of deceit and treachery has not faded with time, and the importance of the role of the Norman French attorney kings esquires in the ongoing subjugation of mankind cannot be exaggerated. Corporations, artificial creatures of the state, operating under statutory law, are under the exclusive control of attorneys, who have the final word in all corporate activity and legal matters. Flesh and blood men and women, on the other hand, speak and act for themselves under the common law. However, based on duplicitous use of people's name, corrupted into a corporately colored, all capital letter format, judges and attorneys have justified proceeding against trusting, unwary victims as though they were a corporation, and have convinced virtually all Americans and the bulk of the rest of mankind, by specious behavior, deliberate omission of the truth, and official insistence upon contrived falsehoods, that they need an attorney, are bound by the same codes and statutes as corporations, and are therefore no different than an inert, abstract corporation, in parentheses, slave of the state. John Quincy Public, naively believing that the Honorable Judas Esquire would never mislead him, now dutiful seeks an attorney in virtually all legal matters, voluntarily cementing his enslavement as a ward of the court and a person of unsound mind, and conceding that he is incapable of speaking and acting for himself. Without such trickery enforced by underling esquire judges and attorneys in the judicial system, the chosen masters could not prevail. Notes. FYI, there are 3 particular items that can be traded, bought, and sold only in Federal Reserve notes: gold, oil, and medium-term notes. Medium-term notes are euro-dollar denominated bank debentures, obligations issued in face value amounts of 10, 25, 50, and 100 million US dollars with 1 year and 10-year tenors. More evidence that IRS is part of a foreign military occupation of the de jure states of the Union, under Secretary of the Treasurer and Commission of Internal Revenue, both domiciled in Puerto Rico, is an affidavit signed by Russell K. Stewart upon his appointment as IRS attorney. This affidavit may be seen in appendix under IRS, appoints apparent communist as attorney. In his standard appointment affidavit for securing employment as an IRS attorney, Stewart lined out / deleted the portion of the affidavit stating that he was neither a subversive nor a communist nor a fascist, and that he was not a member of any organization that advocates the overthrow of the constitutional form of the government of the United States. The lined out segments comprise approximately 50% of the affidavit. Stewart appears to be a subversive communist fascist, also appears to advocate the overthrow of the American constitutional form of government. But IRS doesn't have a problem with that. What is the purpose of the affidavit if it need not be sworn to? How many other IRS attorneys share Stewart's philosophy? A possible source of inspiration for Shakespeare's famous line, "The first thing we do, let's kill all the lawyers." The second part of King Henry VI, Act 4, Scene 2. Stratagem, a maneuver designed to deceive or outwit an enemy in war, a deceptive scheme for attaining an advantage. This essay will not indulge any further exposition on these issues. Rather, the reader should form his own opinion based on the facts. The source of most of the above revelations and more concerning this seminal period in American history is "The United States is Still a British Colony" by James Montgomery. Specious, seeming desirable, reasonable, or probable, but not really so. Pleasing or attractive in appearance, but deceptive, fair seeming. By use of what is called a legal fiction, any judge can literally, arbitrarily pretend a false reality into existence, and then hold you accountable for the imaginary reality without informing you of what he has done. A legal fiction is defined as something assumed in law to be fact irrespective of the truth or accuracy of that assumption. Merriam-Webster's Dictionary of Law, 1996, and judges employ such wholesale. Customers of attorneys are called clients. Clients are also called wards of the court in regard to their relationship with their attorney. Corpus Juris Secundum, 1980, Section 4. Wards of court, infants and persons of unsound mind. Black's Law Dictionary, 4th edition. Endnotes. Masters of Commerce and Law. The coven intent on subjugating all of mankind began as but a tiny cabal, actually an elite hate group within a racist cult, determined to swindle all property on earth from all non-group members and rule the world from on high as the chosen masters. They got their initial foothold in the global commercial arena as shippers on the high seas and the Hanseatic League, cutting their teeth on the Negotiable Instruments Law, NIL. That particular form of law, Admiralty Maritime General Equity, was brought ashore in this country in 1851 with the Limited Liability Insurance Act, and is now codified as the Uniform Commercial Code. All meaningful commercial paper falls under the headings of document of title and negotiable instrument, both of which are jealous subjects of the UCC. Incredibly, both the negotiable instrument law and the Uniform Commercial Code are derived from the same voluminous, archaic, cultic, encrypted hate manifesto with its intricate teachings on property rights. Authored by the self-same progenitors of the antisocial policies that we, as outsiders, must contend with, in parentheses, and its myriad forms, day of our life for our very existence. People have been converted into unwitting de facto merchants, trading in worthless fiat money, i.e., Federal Reserve note scrip, and many have become obsessed by necessity with such hollow, life diminishing objectives as getting out of debt, making rent, and paying the bills to the exclusion of a gracious, benevolent, aesthetic lifestyle, and everything else in between. Beginning with the French Revolution, this little coterie of malefactors has been the source of all revolution, insurrection, and global warfare amongst otherwise rational people and nations, whose express purpose is open rebellion against all existing order, and amidst the ensuing turbulence, introducing a new order customized for serving the needs of the instigators of the chaos. The advent of imitation money called credit, along with the almost infinite number of permutations of such pretend money that have emerged therefrom, as well as a host of mutant institutions that have appeared solely for trafficking in such currency, e.g., the rigged stock and bond markets, insurance companies, etc., is the high water mark of the legacy of the money power. Naively unwitting suckers are led along and drawn into such confidence games by the pitchman's lure of getting something for nothing, i.e., acquiring wealth without exchanging labor, a philosophical concept glorified by the same arch charlatan racketeers who contrive these and other financial schemes, as well as the judicial and taxation industries. Over time, the end result of such perfidy is the same story: loss of wealth and freedom by the numerous individual players, and ever increasing acquisition of wealth and political power by the money mongers that created, own, and operate the game. This tiny tribe of gold worshippers successfully corrupted, embezzled the gold of, and fiscally conquered every great civilization in history: Babylon, Byzantium, Egypt, Rome, the British Empire. The crown is a straw man for the chosen masters. And now, America. In the exact same way from within, i.e., without military force, because it is basically inconceivable for average folks that any civilized group of men could be motivated by such absolute, unbridled hatred for all non cult members. These covert, modern day white collar barbarians as a whole have gone unchecked over the millennia, save the periodic provincial expulsion for an unspeakable, abominable, ungodly, sociopathic practice, in parentheses, which will not be discussed here, still rampant today, but highly insulated and ultra secret. The entire existence of this societas criminis, whose leaders claim a divine right to own everything in existence, is dedicated in furthering the ultimate cause of complete political and commercial enslavement of all outsiders and liquidation of any who do not willingly hop on the treadmill. Examine the blueprint and career of any communist country, and you will see what the chosen masters have planned for America and the world, as communism is the quintessential embodiment and manifestation of their psychosis. Factually, communist philosophy is now official policy of the U.S. government. Quote, the ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. law amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state. Senate Document 43, 73rd Congress, First Session. A possible origin of the U.S. Senate's communist stance on the issue of private ownership of property is Bernard Baruch, 1870 to 1965, Wall Street mogul and American presidential economic advisor for more than 40 years. Quote, we are living in a highly organized state of socialism. The state is all. The individual is of importance only as he contributes to the welfare of the state. Property is only his, as the state does not need it. He must hold his life and his possessions at the call of the state. Bernard M. Baruch, Knickerbocker Press, 1918. Mr. Baruch's philosophy, of course, does not apply in the case of the incredible fortunes amassed by him and his fellow communist billionaire comrades, only the property of the little people. Your future. By definition, the UCC encompasses all codified/statutory law in existence, governing all intercourse between and amongst all people, businesses, and governments, as well as the issue of all currency/money, the single most important commodity in modern society. The master merchants that develop the UCC are fixated on the enslavement/extermination of all outsiders by legal, commercial, military, i.e., admiralty means. The sooner you realize the dead seriousness of your would-be self-appointed slave masters/executioners and face facts of how the world goes round, the better chance you will have of avoiding victimization at their hands and enjoying your life. Once people stop agreeing and stop volunteering into commercial subjugation, the holy masters will have some serious problems on their hands. As they comprise only a minute segment of the population, in parentheses, hence the need for all the underdog hate crime legislation which originated in author and institute through their lackeys in D.C. and elsewhere, their influence can be rather easily offset once large numbers of people catch on. The Crown and the U.S. government are bankrupt front operations for these miscreants, propped up for no other reason than to bilk and politically, in parentheses militarily, subjugate any and all who mistakenly do business with either. Despite the best laid plans of your self-appointed overlords, however, the current predicament is now rather easily remedied. The name of the game is commerce. Contracts, in parentheses revealed and unrevealed, accounting, debits, credits, etc., commercial machinery is triggered by, in parentheses unwittingly, voluntarily contracting with private governmental corporations, long since bankrupt and now only shams for Federal Reserve creditors. Consensual contracts are enforced both judicially, in parentheses via the legal system, and privately/non-judicially, in parentheses via the prescriptions of the UCC. When you make a self-determined decision to do business with corporate government, you will invariably suffer the consequences. In America, the notion of freedom extends no further than the right to contract with whomever you wish, and the right to not contract with those you do not. Once a trusting citizen enters a contract with bankrupt government. However, he becomes a fiscal subject, in parentheses, economic slave, and all other freedoms become distant memories. The only thing impeding your survival is your grasp of the essence of the basic terms used to describe any commercial relationship and the rules of commerce as embodied in the Uniform Commercial Code. For the owners of all the currencies of the world, the UCC is the only game in town, eclipsing and engulfing all others. In parentheses, see UCC 1-103. Ignore it at your peril. Heed its tenets for your betterment. Fortunately for all, a few sturdy souls have deciphered the key issues and principal factors for redemptors and have chartered the route through the UCC and revised Article 9 and made it out the other side. Something can be done, and that is arming oneself with the same kind of ammo being used against one, the silver bullets of the articles of the Uniform Commercial Code. The first step is copywriting your all capital letters trade name under the common law as described in detail in the practical section of this manual. No one in the legal system / government, including any esquire of any stature at any level, has any right to use your common law copyrighted property for commercial gain without compensating you, and no law exists that will support such piracy. Those who foolishly believe they are above the law and are untouchable by the little people will quickly discover the dead seriousness of the consequences of dealing with someone who understands the key elements of the Uniform Commercial Code and how to enforce them. The objective of this article is to help the student of the law with an understanding of the actual nature of the legal system so he/she is not tripped up believing the propaganda issuing therefrom and trust in the juristic dissemblers that specialize in crushing dreams and destroying lives. Learn and use the self-same weapon of choice of those who would confiscate the very air you breathe if they could, the Uniform Commercial Code, and afford yourself the best chance of prevailing over pernicious esquires, the organized criminal syndicate that invented them. Notes from Marcellus Eli Ravage. Century Magazine, February 1926, read a quote, "You have not begun to appreciate the depth of our guilt. We are intruders. We are subverters. We have taken your natural world, your ideals, your destiny, and have played havoc with them. We have been at the bottom of not merely the latest great war, but of every other major revolution in your history. We have brought discord and confusion and frustration into your personal and public life. We are still doing it. No one can tell how long we shall go on doing it. No one knows what great and glorious destiny might have been yours if we had just left you alone." End quote. Your authors have a close friend of many years who has personally sat in at the highest levels of the banking world, where real-time display of all stock quotations and all exchanges worldwide can be viewed in a single room, and where insiders may freely simultaneously buy/sell identical securities in different markets and realize the difference in prices generally and illegal practice known as arbitrage. Arbitrage. Despite the dominance of such institutions throughout the world, all are dwarfed in sophistication by the electronic tentacled pseudo-government private military unit, Department of Treasury, in parentheses IRS, Securities and Exchange Commission, Bureau of Alcohol, Tobacco and Firearms, U.S. Secret Service, Bureau of the Public Debt, Financial Crimes Enforcement Network, it's the FINCEN, etc., that enforces global control over the flow of all FRNs, Federal Reserve notes. Note, for non-karmic enthusiasts engaged in such occupations, there is no such thing as a free lunch. British, from the Hebrew, Brit, covenant. Ishman, Brit is brith, Hebrew, ain absolute. Sociopathic, Latin socius, companion, Greek pathy, disease of specified type of or relating to an antisocial personality disorder, capable of violent acts without feeling guilty. Ultralingua Net Online Dictionary. Societas Criminis, Latin, a partnership in crime between two or more people agreeing to share profits and losses. In Russia, for example, the economy is now effectively run by regional crime lords, and the culture of the Christian nation has become utterly destroyed, reduced to a shambles, beginning with the glorious People's Revolution, banker organized, finance armed, orchestrated co op of 1917, wherein, as quoted in the congressional record, 28 bishops and archbishops, 6,776 priests, 6,765 teachers, 8,500 doctors, 54,000 army officers, 260,000 soldiers, 150,000 police officers, 48,000 gendarmes, 355,000 intellectuals, 198,000 workers, 915,000 peasants, as well as Khazar Nicholas II and his family, the Romanovs. Christians all were put to death, murdered, Red October. Breakdown of demographics of ideal communist society based on empirical observations of the former Soviet Union, members of the Communist Party, 1% to 2% workers for serving members of the Communist Party, 40% to 49% police and military for controlling workers and protecting communists, 48% to 49% self-made non-communist party millionaires, less than 0.1%. Where in such a social scheme do you see and your family fitting in? As reported in a November 30th, 2001 article in the LA Times, 18 million children living in poverty. Of the 18 million children in Eastern Europe and former Soviet Union countries living in poverty, 16 million, almost 90%, live in former Soviet countries. Note the popular title Little Book, Animal Farm, an allegory for life under communism, written in 1946 by George Orwell, is also a shockingly accurate depiction of life in America today, as all 10 planks of the Communist Manifesto have been fully implemented, and the world conquerors hate Christianity. The world conquerors hate Christianity with a virulent passion and have succeeded in polluting, eroding, and corrupting the social fabric of all major Christian nations on earth, beginning with France in 1789. We are today nothing else but the world's seducers, its destroyers, its incendiaries, and executioners. Dr. Oscar Levy, Preface, The World Significance of the Russian Revolution by George Pitt Rivers, 1920. Government depends utterly on the consent of the governed. No consent equals no contract. All men are by nature free and independent, and have certain inherent and inalienable rights. Among these are life, liberty, and the pursuit of happiness. To secure these rights and the protection of property, governments are instituted among men, deriving their just powers from the consent of the governed. Constitution of Illinois, Article 2, Section 1. I didn't know I was a slave until I found out I couldn't do the things I wanted. Frederick Douglass. Property may not be taken by government, even for public advantage or welfare, without just compensation. Case law, Louisville Bank v. Radford, 295 U.S., 555, 601, 602. United States v. Butler, 297 U.S. 1. Juristic, of or relating to a jurist, one having a thorough knowledge of law, especially judge, or the profession of law. Pernicious, Latin per, through, nesh, or nex, violent death, having the power of destroying or injuring, tending to kill or hurt, very injurious, deadly, malicious, wicked. End notes. Section 3. The Curse of Co-Suretyship. Why you are held accountable for the national debt. The curse of co-suretyship. Why you are held accountable for the national debt. In 1989, Austin Gary Cooper was prosecuted by the Department of Justice in U.S. District Court for failure to file an income tax return. United States of America vs. Austin Gary Cooper. Case number 89-109-CR-Hoever, Hoevler, in parentheses, Southern District of Florida. In this otherwise ordinary tax case, Cooper elicited a staggering disclosure from the judge that there are simultaneously two citizenships, citizen of the United States and American citizen. Quoting from the case, Cooper, I want a judicial determination. Am I an American citizen or a citizen of the United States? Judge Hoever, you're both. The Department of Justice prosecutor, Linda Kozlowski, an assistant United States attorney, in her closing argument revealed that United States citizenship is based strictly on contract. Referencing Austin Gary Cooper, the prosecutor revealed, Kozlowski, he pays Social Security and he uses the Postal Service, therefore Mr. Cooper is a U.S. citizen. Kozlowski divulged that the payment of Social Security taxes and the use of United States Postal Service constituted contracts of co-surety, parentheses, not co-debtor, that rendered Cooper and anyone else so contracting under federal jurisdiction and a subject of mandatory federal income taxation. Surety is defined as a person who is primarily liable for the payment of another's debt or the performance of another's obligation. Black's Law Dictionary, 7th edition. A co-surety is a surety who shares the cost of suretyship obligations with another / others. Assistant United States Attorney Kozlowski's assertions revealed that any who pay into Social Security and use the Postal Service are considered mutually legally liable as co-sureties for the debt of the United States, i.e., the national debt, and thereby obligated to pay income tax. Flesh and blood, men and women born in one of the 50 several states are American citizens, a standing acquired by birth. Their artificial alter ego trade name is a citizen of the United States, a status acquired via contract. Judge Hoevler also acknowledged that there are other media, in parentheses other than doing business with Social Security and the Postal Service, by which American citizens regularly contract into becoming a citizen of the United States, but declined commenting further. Notes: suretyship, the legal relation that arises when one party assumes liability for a debt, default, or other failing of a second party. The liability of both parties begins simultaneously, in other words, under a contract of suretyship. A surety becomes a party to the principal obligation. Black's Law Dictionary, 7th edition, 1999. Hereinafter, Black's Law 7th, co-suretyship means suretyship with other sureties, the same principle / obligation, the national debt, is the financial obligation of the U.S. government claimed by the Federal Reserve Bank and is based on the use of the Fed's private property, valueless, unredeemable Federal Reserve notes as currency. The Act of July 27, 1868. The Cooper judge's comments are in harmony with legislation passed by the United States Congress formally acknowledging American citizenship and providing for expatriation of American citizens from other citizenships they may hold. Quote, an act concerning the rights of American citizens in foreign states, be it enacted by the Senate of House of Representatives of the United States of America and Congress assembled, that any declaration, instruction, order, or decision of any officers of this government which denies, restricts, impairs, or questions the rights of expatriation is hereby declared inconsistent with the fundamental principles of this government. United States Statutes at Large, Volume 15, Chapter 249, page 223, 40th Congress, July 27th, 1868. End quote. The language used by the 40th Congress unequivocally specifies American citizens in foreign states rather than in foreign countries. What then is the special significance, if any, of a foreign state over a foreign country? Consulting the Constitution of the United States of America, Article 1, Section 8, plus 17, we find the geographical limits and realm of political authority of the United States government. The Congress shall have the power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Looking further in the Constitution's Article 4, Section 4, reveals a political distinction between United States and the several states. The United States shall guarantee to every state in this Union a republican form of government. Further, 19 Corpus Juris Secundum 541, 1990 spells it out even more clearly. The United States government is a foreign corporation with respect to a state. As shown above, it is readily discernible from this simple examination of the Constitution and Corpus Juris Secundum that the 50 several states are foreign states in respect of United States, which exists only within district not exceeding 10 miles square of Washington, D.C. This fact is echoed very unambiguously in the Uniform Commercial Code, hereinafter UCC. Location of United States. The United States is located in the District of Columbia, UCC 9-307. The 50 several states of the Union, therefore, may rightfully be considered as foreign states, and the above excerpt from the act setting forth the stance of the U.S. government, re expatriation of American citizens in foreign states. Notes. Definition of re. R-E-R-I-Y, Latin. In the matter of, in the case of, a term of frequent use in designating judicial proceedings in which there is only one party. Thus, re Vivian signifies in the matter of Vivian, or in Vivian's case. Corporate citizenship. 2.5 years after the act of July 27, 1868, the U.S. government went into business as a for-profit municipal corporation on February 21, 1871. It is interesting that the quarterly list of expatriates is now officially entered into the Federal Register as legal newspaper published every business day, according to its literature by a non-U.S. government company, Internal Revenue Service, IRS. IRS is a commercial business whose two greatest expenses are postage and rent. In parentheses, government agencies do not pay postage and rent. It is an intelligence gathering, accounting, and collection agency for the private Federal Reserve and is domiciled in Puerto Rico under the Secretary of the Treasury of Puerto Rico, aka Secretary of the Treasury, who is also governor of the World Bank and governor of the International Monetary Fund, in parentheses, both of which are headquartered in Washington, D.C. The secretary is also in charge of all private bank paper, i.e., Federal Reserve notes, FRNs of his Federal Reserve employers, and employs the full might of the Department of the Treasury, another non-U.S. government private business, and monitoring every institution / corporation / business / individual that deals in Federal Reserve notes. There is an abundant evidence that U.S. citizenship is actually corporate citizenship, as well as being under the ultimate control of a private business, IRS, as described above. The official list of parties who have renounced U.S. citizenship also includes a corporation, RBC, Reinsurance of Canada. RBC Reinsurance renounced its U.S. citizenship in the second quarter of 2000. Since this artificial person corporation is listed as an expatriate, it can be reasonably assumed that RBC Reinsurance at one time immigrated and became a citizen of the United States. Based on this and other revelatory facts, it may be safely surmised that the only type of entity that can ever become a citizen of the United States is an artificial person. Checking the spelling of the name on your passport, driver's license, sales permits, credit cards, certificates of title, etc., you will discover that the name imprinted thereon is written in all capital letters, the standard method for designating the name of corporations and corporately colored entities, with practice also falls completely outside the accepted rules of English grammar for the spelling of proper names of men and women. An all caps name designates an artificial person, i.e., corporation / corporately colored entity. Further, the prosecutor in Cooper confirmed in open court that U.S. citizenship is based on contract rather than the situs, the situs, of one's birth. Parentheses, one of the 50 several states, for example. The judge in the Cooper case also admitted of two different types of citizenship simultaneously, American and U.S. It can therefore be reasonably concluded that the U.S. citizenship is indeed some kind of corporate / corporately colored citizenship, and that American citizenship is held by men and women and boys and girls born in one of the 50 several states. Notes: the Legislative Act of February 21st, 1871, Congressional Record, 41st Congress, Session 3, Chapter 62, page 419, chartered a federal company entitled United States, i.e., United States, 1871, aka U.S. Inc., a commercial agency, originally designated as Washington, D.C., in accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases Diet v. Turner, 1968, 439 P.2D, 266, 267, State v. Phillips, 1975, 540 P.2D, 936, as well as Coleman v. Miller, 307, U.S., 448, 59, capital S, period, capital C, T, period, 972. 28. Tulane Law Review, 22. 11. South Carolina Law Quarterly, 184. Congressional Record, June 13th, 1967, pp. period, 15641-15646. IRS was officially disclaimed as an agency of the United States government by United States Attorney Betty H. Richardson, November 18, 1993. For a certified copy of the document, see U.S. Attorney disclaims IRS as agency of the U.S. government in Appendix. See also Internal Revenue Service and glossary. RBC equals Royal Bank of Canada. For complete expatriation lists, see www.frissel.com/taxpats.html. Citus, site, situation, place, endnotes. The nature of Social Security. A primary method by which the United States contracts with its consumers is through Social Security and the payment of payroll taxes. Briefly, taxes are levied upon the debt of the United States Congress in favor of the private Federal Reserve Bank. President Franklin Delano Roosevelt and the United States Congress, after declaring bankruptcy, contracted with international banker owners of the Fed, who caused the bankruptcy by swindling America's gold for loans of credit, money created out of thin air, presented as the New Deal. Another cash cow, in parentheses, other than personal income tax, was needed to saddle the American people with joint responsibility, in parentheses, co-suretyship obligations, for the trillions of dollars in interest charges that would be generated courtesy of the presidential congressional treasury. The Social Security system, with Social Security payroll taxes, was devised for this purpose. The Social Security contract is essentially an unconscionable bargain because it binds every account holder for the stratospheric debt of the U.S. government. In the landmark 1937 case, Elvering v. Davis, 301 U.S. 619 81 capital L dot capital E D dot 1307 57 capital S dot CT dot 904 in U.S. Supreme Court ruled that Social Security is a form of welfare. Quote, the scheme of old age benefits created by Title II of the Social Security Act of August 14, 1935, providing for the payment of such benefits and authorizing future appropriations to an account to be set up by the Treasury for such purposes, sufficient to provide for the contemplated benefits, is within the power of Congress to spend money in aid of the general welfare. Because of this fact, application for and use of a Social Security account number is a tacit confession that one is so incompetent in managing his/her own affairs that he/she must appoint the U.S. government as his/her guardian and seek eligibility for welfare payments. Such status is also known by other names, e.g., child of the state and a ward of the court. Those who are incapable of caring for themselves, Social Security account holders and their surety, are subjects of the doctrine of parens patriae, defined as follows. Latin, parent of his or her country, the state regarded as a sovereign, the state in its capacity as provider of protection to those unable to care for themselves. Black's Law Dictionary, 7th edition. Legally, acceptance of a benefit, e.g., welfare, the protection of the state, is the equivalent of acquisition of a legal right in exchange for a promise, albeit a tacit promise, but a promise nevertheless, without which any such benefit would not have been possible. Quote, consideration of a contract as a benefit to the party promising, or a loss or demerit to the party to whom the promise is made, and benefit as an element thereof, means that the promiser has, in return for his promise, acquired some legal right to which he would not otherwise have been entitled. Woolham v. Sizemore, 267 KY 384 102nd capital S dot W dot 2D 323 324. Translation. The fact of having acquired a legal right, in parentheses welfare, protection of the state, is evidence that you must have made some kind of promise / pledge, in parentheses responsibility for payment of the debt of the U.S. government. In the beginning, that facilitated this outcome in the enjoyment of such benefit, mere eligibility for such benefit, parentheses retirement benefits, right to contributions from other payroll taxpayers, discussed below. Legal proof that there is no such thing as a free lunch. This concept is spelled out particularly early in the 1960 U.S. Supreme Court case Fleming v. Nestor, in Case Law 363 U.S. 603 for capital L period capital E D period 2D 1435 apostrophe 80 capital S period capital C T 1367 year 1960. The right to the Social Security benefits is in a sense earned, for the entire scheme rests on the legislative judgments that those who in their productive years were functioning members of the economy may justly call upon that economy in their later years for protection from the rigors of the poorhouse, as well from the haunting fear that such a lot awaits them when journey's end is near. The reason the words right and earned appear in quotes within the above passage is because there is no guaranteed right in Social Security benefits, and nothing is actually earned, i.e., no vested interest. Also from Fleming v. Nestor. Quote, to engraft upon the Social Security system a concept of accrued property rights would deprive it of the flexibility and boldness and adjustment to ever-changing conditions with it demands. End quote. Notice also in the Fleming cite that former functioning members of the economy can only call upon that economy, in parentheses, other than active Social Security payroll taxpayers at the time of retirement, for protection from the rigors of the poorhouse, i.e., retirees, can only hope that the economy will support them, because Social Security does not have to, and may decide against it. As documented below, the so-called economy cannot provide Social Security benefits from anyone born after 1970, and the vast majority of others born before then will receive only partial benefits. Nobody has any accrued property rights, i.e., no vested interest, no guaranteed retirement benefits by virtue of paying Social Security payroll tax, as attested in Carley and Hamilton v. Snook, 281 U.S. 66 Knights v. Jackson, 260 U.S. 1215 in Nashville C. and St. L. R.Y. v. Wallace, 288 U.S. 249. The constitutional power to levy taxes does not depend upon the enjoyment by the taxpayer of any special benefit from the use of the proceeds raised by taxation. Payment of Social Security benefits from the Social Security system is strictly discretionary, not obligatory. Thus, by law and by contract, when a Social Security payroll taxpayer retires, FICA, and the Social Security system is not required to compensate the retiree / Social Security payroll taxpayer. Another reason why Social Security is an unconscionable bargain. FICA, the Federal Insurance Contributions Act. On every pay stub of a payroll check, you will find the term FICA, Federal Insurance Contributions Act. This title is misleading for more than one reason. The word insurance in the title does not involve any insurance policy for the party paying the taxes, as stated above in Fleming v. Nestor. A Social Security payroll taxpayer has no vested interest in Social Security. If there were a valid insurance contract in the name of the party paying the premiums, that party would have vested interest in the contract, but such is not the case. In parentheses, payments are not taxes, not premiums. Rather, the insurance part of the title means federal insurance, i.e., insurance for the federal government's debt in favor of the Federal Reserve Bank. Re, the word contributions in the title of the act. This word does not mean what most people think it means. In legal matters, this term has only one connotation, as demonstrated by the following definitions of contribution. Re, when two or more persons jointly owe a debt, and one is compelled to pay the whole of it, the others are bound to indemnify him for the payment of their shares. This indemnity is called a contribution. Bouvier's Law Dictionary, 6th edition, 1856, hereinafter, Bouvier's 6th. When one of several debtors pays a debt, the creditor is bound in conscience, if not by contract, to give to the party paying the debt all his remedies against the other debtors. Bouvier's Dictionary, 6th edition. A right to contribution exists in the case of debtors who owe a debt jointly which has been collected from one of them. Bouvier's Law Dictionary, 8th edition, 1914, Bouvier's 8th. Therefore, in the Act's title, Federal Insurance Contributions Act, contributions is not referencing the Social Security payroll taxes that are paid in by the taxpayer, but rather the nebulous right of the taxpayer to receive contributions, in parentheses, reimbursement from other taxpayers, in parentheses, co-debtors, and their surety, upon retirement, after having paid off his/her entire fair share of the U.S. government's debt, in parentheses, with a lifetime of labor, without ever revealing the fact what the Social Security scheme provides. The retiring Social Security payroll taxpayer is the right to assert/expect/hope that other taxpayers who have not yet fully paid their fair share, in parentheses, by working and paying over a lifetime, will at least reimburse him/her with the meager stipend necessary for minimal survival in exchange for his 40-year attempt at paying off the national debt, in parentheses, a mathematical impossibility. Chance that the average taxpayer will ever recover the full amount paid in over the work years, 0%. The second Bouvier's definition of contributions above reveals the position of the federal government in this most masterful of confidence games. When one of the debtors pays a debt, once a debtor has paid Social Security payroll taxes for a lifetime, that debtor has paid off all of the debt that he/she is physically capable of paying, their fair share. The creditor is bound by conscience, if not by contract. The creditor, the U.S. government, actually the Federal Reserve. The U.S. government is a straw man for the Fed creditors, though having no contractual obligation to give the retiring taxpayers any form of compensation, is at least morally obligated as follows: to give to the party paying the debt all his remedies against the other debtors. The U.S. government is morally obligated to assist in retiring co-surety/Social Security payroll taxpayer, in parentheses, debtor, in acquiring reimbursement from other co-surety/Social Security payroll taxpayers, in parentheses, debtors, currently paying taxes. The U.S. government thereby fulfills its moral obligation with retirees and defrauds all current Social Security payroll taxpayers by 1. Collecting payroll taxes from current taxpayers. 2. Dispersing payment benefits to retirees out of current collections. And 3. Pocketing the difference. Whereas most believe that surplus collections go into a trust fund in their name, the ugly truth is that Big Brother commandeers the funds for its own purposes. This is the precise reason that the Social Security system will be legally insolvent around the year 2016. The IRS/U.S. government/Federal Reserve has zero legal/contractual obligation toward Social Security payroll taxpayers. And when current payments exceed current collections in 2016, The beginning of the end will be real for all. The above is confirmed in newspaper articles, like the one below that appeared in the August 1st, 2001 edition of the Los Angeles Times entitled, Change of Heart Sought on Social Security Plan. Articles like this keep massaging us with little reminders that Social Security income outgo lines will cross in the year 2016 and that the so-called trust fund will be exhausted in the year 2038. Quote, Social Security faces increased financial strains as the baby boom generation born from 1946 to 1964 begins to retire in about a decade. By 2016, the program will begin paying out more in benefits than it collects in taxes. And by 2038, the trust fund will be exhausted. If any so-called trust fund existed, where Social Security payroll tax money was held in trust in the name of the party who paid in the taxes, the trust fund could never be depleted and the system could never go bust. People spend 30, 40, and sometimes even 50 years of their life paying money into their so-called Social Security account. Upon retirement, they begin receiving, on a monthly basis, only a microscopic portion of the total amount paid in over their lifetime. If these funds were held in trust on their behalf and accounted for in their name, how could the funds ever disappear? The reason people can and will be denied Social Security benefits is because payroll taxes are just that, taxes, collected by IRS, a tax collection agency. No one has any right to enjoy any special benefit from funds raised through taxation, as cited above. Unrestricted perfidy, deceit, and treachery will not go unnoticed much longer. However, the exhaustion point mentioned in the above article is informing us of the end of the shock absorber fund, i.e., those funds specially allocated for the winding down period when large numbers of people begin figuring out they have been conned, spread over a 22-year stretch. However, taxpayer outrage should be a fairly well dissipated enough probably for avoiding mass insurrection against those in charge. Notes: virtually every government on earth is bankrupt to this same group of bankers. Unconscionable bargain, a contract which no man in his senses, not under delusion, would make on the one hand, and with which no fair and honest man would accept on the other. Black's Law Dictionary, first edition, 1891. Wards of court, infants and persons of unsound mind. Black's Law Dictionary, fourth edition, 1951. Stipend, a fixed sum of money paid periodically for defraying expenses. According to the president, the average return on Social Security is less than 2%, and the program in the long run pays retirees less than 30% of what they earned before retiring. Bush again pushes stock investments for Social Security. Los Angeles Times, March 1st, 2002. Ponzi scheme. Most people are familiar with pyramid schemes and chain letters. These are each a breed of Ponzi scheme, in which people who mistakenly believe themselves investors are actually only suckers making donations for the organizers of the con. Ponzi scheme. A fraudulent investment scheme in which money contributed by later investors generates artificially high dividends for the original investors, whose example attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue producing activity other than the continual raising of new funds. This scheme takes from Charles Ponzi, who in the late 1920s was convicted for fraudulent schemes being conducted in Boston. Black's Law Dictionary, 7th edition. This definition is echoed in a December 15, 2001 article in the Los Angeles Times entitled Investments Called Long Time Scheme, wherein an alleged Ponzi scheme is dissected. One line from the article reads as follows, quote, most of the payments were actually money taken in from other investors. A classic Ponzi scheme, end quote. Per the definition from the Black's Law Dictionary, 7th edition, and as confirmed in the article in the LA Times, the Social Security Payroll Taxation / Benefit program meets all qualifications of a Ponzi scheme. Retirees and other Social Security benefit recipients get a full payout of Social Security benefits as expected. In parentheses, receive artificially high dividends compared with those who will get little to / nothing. People who are paying Social Security payroll taxes now, in parentheses later investors, face no hope of receiving Social Security benefits, in parentheses a full payout, because as of 2016, 100% of Social Security payroll taxes collected will be absorbed by retirees, in parentheses old investors, and even retirees will be shorted because of the deficits. And there is no other legitimate revenue producing activity for ensuring that current taxpayers, in parentheses new investors, will get anything. In a Ponzi scheme, usually the only ongoing activity is the raising of more funds from new victims, except for the pittance that has been earmarked for the winding down period from 2016 through 2038. The only thing going on with Social Security is the continuous extortion of payroll taxes from those who are presently working, i.e., new investors. Your DC politicians explain it all for you. From the July 20th, 2001 edition of the LA Times, an article entitled, The System is Broken, Social Security Panel Declares. The system is broken, declared the Commission's co-chairman, former Democratic Senator Daniel Patrick Moynihan of New York, and Richard D. Parsons, Chief Operating Officer of AOL Time Warner, in the report's preface. But is this really true? 6 weeks later, an esteemed colleague of Moynihan, Pete V. Domenici of New Mexico, apparently disagreed in a September 7th, 2001 article in the LA Times. Domenici bucks GOP's policy, taps Social Security surplus. Domenici cites huge surpluses in Social Security rather than impending doom. Washington Senator Pete V. Domenici of New Mexico, the top Republican on the Senate Budget Committee, broke ranks with his party Thursday over the politically sensitive issue of the Social Security surplus, saying that he saw no reason in the world why those funds should not be used for education or defense spending next year. Virtually all of the surplus in 2002 will derive from Social Security payroll taxes paid by individuals with huge surpluses of the last several years. These funds have been used mainly to reduce national debt. Riddle me this, Batman. If there have been huge surpluses in recent years, and a surplus every single year since the inception of Social Security in 1935, how could any so called trust fund ever be exhausted? And how could the system now be broken? If the system is broken today, then it was broken the day it was drawn up because nothing has changed. The potential for disaster, such as the one now looming on the horizon, was a fait accompli from the gate. Social Security has done nothing but rake in taxes from a vast majority of American workers and employers over the last 67 years and pay out benefits for a much tinier number of retirees and disabled Americans. What is happening with the trillions of Social Security payroll tax dollars collected in excess of the benefits being paid out? The mystery is resolved in the legal definition of the word surplus. Strategically appears within the de Menezes article. Surplus is defined as the excess of receipts over disbursements. Black's Law Dictionary, 7th edition. That which is left from a fund which has been appropriated for a particular purpose. The remainder of a thing. The overplus. The residue. Bouvier's Law Dictionary, 6th edition. The only reason Social Security can be called broken and in trouble now, for the first time in its history, is because surplus funds are skimmed and have been skimmed every year for the last 67 years, a built in aspect of the program. As is noted in the de Menezes article, excess funds go elsewhere, e.g., for reducing the national debt, and do not accrue for the benefit of those paying the taxes. The entire racket is confessed by the Supreme Court in one sentence, if by omission, in Fleming v. Nestor. Quote, the Social Security system is a form of social insurance enacted pursuant to Congress, power to spend in aid of the general welfare whereby persons gainfully employed and those who employ them are taxed to permit the payment of benefits to the retired and disabled and their dependents. End quote. Comparing the foregoing Supreme Court explanation of Social Security in Fleming and the following Securities and Exchange Commission allegation of a Ponzi scheme from an August 29th, 1999 article in the Los Angeles Times entitled Two Oregon Films Named in Payphone Ponzi Scheme, it is difficult to make any meaningful distinction between the two. The two grants passed, originally based companies, defrauded as many as 7,000 people concentrated in California, Texas, and Florida by paying early investors, in parentheses, retired and disabled, from deposits of new investors, in parentheses, persons gainfully employed and those who employed them, rather than from investment returns, in parentheses, rather than from returns derived from trust fund investments. The SEC alleged the above Supreme Court quote from the Fleming case tells us that tax dollars collected in excess of what is needed for payment of benefits in any accounting period, in parentheses surplus, are not part of the equation, that there is no provision of benefit for those actually paying the taxes. People paying FICA payroll taxes are supporting those on Social Security welfare. However, nothing accrues for the benefit of those paying the taxes. Surpluses are swept away. Any first year accounting student can tell you that once the retiree benefit dollars to be paid out outnumber worker payroll tax dollars that are collected, the system will not be capable of meeting its financial obligations, a condition known as insolvency, bankruptcy. This fact was known the day the program was instigated in 1935 and, based on the overwhelming pecuniary significance of such aspect, tens of trillions of dollars funded out of Social Security, it cannot be regarded in any light other than intentional. The Sacred Trust Fund. The first paragraph of Title 42 United States Code Section 401, describing the Federal Old Age and Survivors Insurance Trust Fund, begins as follows. A. There is hereby created on the books of the Treasury of the United States a trust fund to be known as the Federal Old Age and Survivors Insurance Trust Fund. The Federal Old Age and Survivors Insurance Trust Fund shall consist of the securities held by the Secretary of the Treasury for the Old Age Reserve Account and the amount standing to the credit of the Old Age Reserve Account on the books of the Treasury. The problem with the so-called trust fund is twofold. One, it is funded solely by taxes. And two, placement of appropriated tax dollars into the fund is strictly discretionary / optional. The first paragraph continues. There is hereby appropriated to the Federal Old Age and Survivors Insurance Trust Fund for the fiscal year ending June 30th, 1941, and for each fiscal year thereafter, out of any monies in the Treasury not otherwise appropriated, amounts equivalent to 100 per centum of 1. The taxes received under Subchapter A of Chapter 9 of the Internal Revenue Code of 1939, which are deposited into the Treasury by collectors of internal revenue before January 1st, 1951, and 2. The taxes received under Subchapter A of Chapter 9 of such code, which are deposited into the Treasury by collectors of internal revenue after December 31st, 1950, and before January 1st, 1953, and 3. The taxes imposed by Subchapter A of Chapter 9 of such code with respect to wages, and by Chapter 21, and 4. The taxes imposed by Subchapter E of Chapter 1 of the Internal Revenue Code of 1939 with respect to self-employment income, and by Chapter 2 of the Internal Revenue Code of 1954. The only Treasury monies that go into the so-called trust fund are those that have been otherwise appropriated, i.e., whatever is left after Big Brother siphons off the surpluses. After the Act quietly divulges that all surpluses can be otherwise appropriated, follows 14 pages of mind-numbing legal eyewash. Because of the cleverness with which words are defined and used by esquire politicians and a running dog press, people mistakenly draw the inference, which is never officially stated as, that every year's surplus is somehow fed into an account in their name in the Federal Old Age and Survivors Insurance Trust Fund. The term trust fund is defined as the property held in a trust by a trustee. Black's Law Dictionary, 7th edition. Obviously, we are missing something here, because no one has ever stepped up to the plate and verified the whereabouts of all the missing trillions and trillions of dollars in surpluses collected since 1935. Surplus dollars paid in by the Social Security payroll taxpayers, like all other tax dollars, are fungible, i.e., not earmarked in any way, and end up wherever the Federal Reserve masters dictate. This is why Domenici can brazenly suggest allocating this year's surplus for education or defense spending. The subject of allocation of the surplus funds that are automatically skimmed from the Social Security has never been an issue until recently, because baby boomers are approaching retirement and the specter of a bankrupt Social Security system in 2016 could no longer be ignored. The notion of the Federal Old Age and Survivors Insurance Trust Fund holding the surpluses of the last 67 years in trust for the parties that paid in the taxes is a hoax. However, for the sake of avoiding wholesale taxpayer convulsions, we are being let down easy. That is why a winding down fund has been allocated to cover benefits for the 22-year stretch between 2016 and 2038, and why the blame is being spread over multiple presidential administrations and Congresses. Insolvent institutions and trust fund doctrine. It is interesting that the only legal definition of the term trust fund doctrine deals strictly with bankrupt enterprises, in parentheses, the U.S. government, and their creditors, in parentheses, Federal Reserve. The principle that the assets of an insolvent company are held as a trust fund to which the company's creditors may look for payment of their claims. Black's Law Dictionary, 7th edition. Contemplating the legal concept of trust fund doctrine is Senate Document 43, 73rd Congress, First Session, March 9th, June 16th, 1933, issued at the time the U.S. government declared bankruptcy, June 5th, 1933, which proclaimed in part, quote, "The ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state." End quote. Since the U.S. government is officially insolvent / bankrupt, and expropriated / nationalized all property in America in 1933, the notion of trust fund doctrine is directly applicable. Any so-called trust fund would apply in the case of the U.S. government and its creditors, the Federal Reserve. Such a trust fund could be supplemented by Social Security payroll taxes built from new investors, but would not be held in trust in their name. Social Security payroll taxes are taxes and inure for the benefit of the U.S. government, not the parties paying the taxes. Taxpayers are being coddled, nurtured, and let down gently, because there are 280 million of them, and most are armed. Hence the need for all the psychiatric manufacture of mass murderers, in parentheses without exception, each was on psychiatric drugs at the time of the murders, to generate the societal climate necessary to justify the passage of gun control legislation. There are only 535 elected officials in Washington, D.C., and only about 3 million total sheriffs, police, marshals, military, and federal agents nationwide. So the cause for anxiety over the populace owning guns is easily grasped. Newspaper articles also quietly and legally notice us that Social Security benefits do not come from the so-called trust fund, in parentheses the same illusory trust fund that people have supposedly been paying into for their entire working life. Current Social Security benefits come from the current collections, and it is spelled out all too clearly in this excerpt from a June 15th, 2001 LA Times article entitled Social Security, Get Tough. Quote, "Social Security is a pay-as-you-go program. Today's payroll taxes fund benefits for today's retirees." End quote. I.e., retirees are cannibalizing the taxes that current wage earners mistakenly believe are going into the trust fund in said current wage earner's name. Each surplus is otherwise appropriated before it can make it into the trust. As long as more dollars are collected in Social Security payroll taxes then are paid out in the Social Security benefits, everything is hunky-dory. The moment that retirees require one more dollar in benefits than dollars collected from current wage earners and payroll taxes, in parentheses 2016, the operation is insolvent and the so-called surplus ruse is blown and can never be used again. The trust fund is the dangling carrot that attracts new investors into the Ponzi scheme. Since wage earners pay in taxes an average 40 years over their lifetime, it is mathematically impossible that anyone's trust fund account could ever be exhausted before reaching retirement age if the funds are allowed to accumulate in his/her name. But that is exactly the case for every single taxpayer born after 1970. Notes: fait accompli, French, accomplished fact, a thing accomplished and presumably irreversible. Pecuniary, of or relating to money. Esquire, attorney, fungible, regarded as commercially interchangeable with other property of some kind. Black's Law Dictionary, 7th edition. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in the world history, the U.S. government. Representative James A. Traficant, Jr., Congressional Record, March 17, 1993, Volume 33. See Chapter 11, Reorganization. Inure, to become of advantage, to pass into use, to be applied. The reality of Social Security benefits. In 1935, the average age of death in America was 65. Based on this statistic, the instigators of the Social Security system, led by an economist by the name of Robert R. Nathan, set the age of eligibility for Social Security benefits at 65. This way, the system could operate at maximum profitability because, on the average, potential beneficiaries would die at the time the first payment became due, thus ensuring a clean sweep of all taxes paid and over the lifetime of the mark, in parentheses, intended victim in a confidence game, with no disbursements. Unfortunately for Social Security, people are now living till age 77, an unaccounted for 12-year Social Security benefits payout period. Accordingly, systems profit now reflect a major discrepancy from initial projections because people who were scheduled to be pushing up daisies are out swinging golf clubs and cutting them down, i.e., still collecting Social Security benefits. Based on the foregoing statistics, and given that the retirement eligibility age for people born after 1960 is now 67, in parentheses, but will likely soon be set at 70. The demographics of the 2038 Trust Fund Death Knell read like this: people born, expected portion of benefits. Before 1940, full benefits for remainder of life after age of 65. After 1939, but before 1952, full benefits till 2016, then partial benefits. After 1951, but before 1971, partial benefits till 2038, then nothing. After 1970, no benefits. Quoting from the Black's Law 7th edition Dictionary of Ponzi Scheme, money from the new investors, people born after 1970, is used directly to repay old investors, people born before 1971, usually without any operation of revenue producing activity other than the continual raising of new funds, collection of Social Security payroll taxes. How can Social Security be anything other than a Ponzi scheme? There has been a surplus in Social Security every year for the last 67 years because more dollars were collected in taxes than were paid out in benefits during every single accounting period. Unfortunately, rather than being held in trust in the name of the Social Security payroll taxpayer, each year's surplus has been quietly routed elsewhere by the unregistered foreign agents at IRS. The reason there is so much talk about privatizing Social Security today and letting people invest a portion of their payroll taxes in the stock market where people can be legally swindled is because of the absolute certainty that Social Security payroll taxes born after 1970 have no hope of any return of their taxes upon reaching retirement age. Once the retiree population in parentheses baby boomers overwhelms than active wage earners in 2016, your public servants in Washington, D.C. will need a new propaganda campaign, if not sooner. Talking head media servants, professionals at gushing crocodile tears, on cue as they inject the lethal message of the chosen masters into mainstream America, should have no trouble in concocting a new half truth. Notes: Savant, a man of exceptional learning. Crocodile tears, simulated or pretended weeping, hypocritical grief. From the tale of ancient travelers that the crocodile weeps over those he devours. Co-suretyship obligations incurred via acceptance of free delivery of mail. Until 1863, there was virtually no delivery of mail in America. Although city delivery was authorized as early as 1794, comparatively little of it was done. At the time, all postage was so high that the additional fee for home delivery made the service undesirable. Mail matter was received at the destination post office and stocked alphabetically in boxes /slots and parentheses as it is still done today, and handed over when a postal patron called at the general delivery window. No disclosure of identity has ever been required for pickup of mail by postal patrons at general delivery, and postal regulations still support this custom. 6C subsection B1 of this section shall not require the disclosure of 1. The name or address, past or present, of any postal patron. Postal Reorganization Act of August 12, 1970, 39 U.S.C. Statute 410, Public Law 91-375, Section 2, 84 Statute 719. When the 7 southern states walked out of Congress on March 27, 1861, there was no longer a quorum, and the existence of the de jure United States of America went into suspension. Exercising his power as Commander-in-Chief of the military, Lincoln issued the first executive order, and the country officially went under martial law. This condition has never been reversed. To secure control of a sovereign constituency that was not aware of the disappearance of its de jure government, a device was needed that would secretly obligate each member in favor of the new de facto, in parentheses illegitimate, military government without his knowledge. During the process of the Civil War, in parentheses the day of the Battle of Appomattox, under the Lincoln Stratocracy, on July 1st, 1863, the United States Post Office Department proudly announced free city delivery service of mail, and city patrons could, from that time forward, receive free city delivery of mail at home if they so choose. Quote, citizens had the option of accepting this service or rejecting it by giving proper notice to the postmaster. Old Post Bags, the story of the sending of a letter in ancient and modern times, by Alvin F. Harlow, 1928. Introduction by Joseph Stewart, Executive Assistant to the Postmaster General, USA. End quote. City postal patrons accepting free delivery, however, were reclassified as customers. The first time in history of commercial term was used as an identifier for American citizens, whereas postal patrons were expressly excepted from identity disclosure requirements when retrieving mail matter. Postal customers were not. Despite the apparent advantage of the new free service, the idea took off very slowly, with long lines of patrons seen in front of the general delivery window decades later. The general delivery clerk has to deal with the family that will never allow its mail to be delivered by carrier, and with a man who brings his family with him to the post office 2 or 3 times a day and inquires for the mail for each one, of which, of course, there isn't any. Story of Our Post Office, the Greatest Government Department in All Its Phases, by Marshall Cushing, 1893. Quote, not only in our larger cities before the days of free delivery, but again and again throughout our history has the long QQ appeared, awaiting its letters at a delivery window. Old Post Bags, the story of the sending of a letter in ancient and modern times, by Alvin F. Harlow, 1928, introduction by Joseph Stewart, Executive Assistant to the Postmaster General, USA. Notes. By law, letter carriers could collect a 2-cent lawful money fee for each letter delivered because letter carriers receive no salary for this service. Quorum, the number of members for any deliberative or corporate body necessary for the legal transaction of business. Stratocracy, a military government, government by military chiefs of an army. Black's Law Dictionary, 6th edition. Congress passes a tremendous amount of controversial legislation during times of war and turmoil, thus avoiding the scrutiny of voters that attends congressional actions in less chaotic times. The first experimental routes for rural free delivery of mail, RFD, were commenced in West Virginia in 1896 with letter carriers working out of Charleston, Halltown, and Uvilla. And notes. Privatization of free delivery of mail. The Postal Reorganization Act of August 12, 1970, in parentheses, Public Law 91-375, 84 Statute 720, abolished the United States Post Office Department and transferred all personnel into the private United States Postal Service, USPS, which was reorganized a year later, whereas the former Post Office Department was an executive department of government. The Postal Service is a semi-autonomous operation independent of Congress, SIC, operating under Executive Branch, USPS. The world's biggest employer is a private corporation. In parentheses, new postal rates go into effect this Sunday, LA Times, January 17, 1999. The Postal Service handles roughly 500 million pieces of mail every day, delivering bills from IRS debt collectors and slave of state corporations and payments from credit-starved customers, all for free. Without this facility, the wheels of commerce would turn much slower, as much as 95% slower, with far less tax generated and collected and far fewer defaults and foreclosures, thereby defeating the purpose of the credit-based economy foisted upon us by the chosen masters. USPS, like the Post Office Department before it, bears no obligation for delivery of mail, a free service since 1863, and still openly advertised as such. Operation of the general delivery window is a common law right. Delivery of mail, in parentheses, into P.O. boxes and mailboxes, constitutes free delivery and is a USPS function. Postage fees cover the transit of mail matter only as far as the destination post office, where postal patrons can legally retrieve mail indefinitely at the general delivery window, in parentheses, under the common law. Notes. Postal Reorganization Act of 1971 has a purpose conversion of postal organization into semi-autonomous operation independent of Congress, operating under executive branch, Baker v. Hazen, 1975, 133 VT 433, 341 A2D 707, 39 USC 201. There are approximately 800,000 USPS employees, 240,000 of which are members of the National Association of Letter Carriers Trade Union. Historical note: cost of postage, set by statute at Title 12 United States Statutes at Large, Chapter 71, Sections 22 and 23, has never been repealed and is still in force today. 2 cents per half ounce when mailed within the several states of the Union, and 3 cents per half ounce mailed in United States District of Columbia. The private policy of a profit-making corporation, i.e., United States Postal Service, can never supersede a U.S. government statute. The key is that the current U.S. government is de facto, not de jure, and we no longer enjoy organic law, but private, copyrighted law / policy of British corporations under the control of the owners of the Federal Reserve. The reason postage prices continually go up is twofold. One, to keep up with inflation, built-in feature of credit money system, and 2, to ensure that the salaries of the 240,000 letter carriers that deliver the mail for free exceed the current rate of inflation, also known as the cost of living index. The Constitution of the United States of America is not merely a league of sovereign states for the common defense against external and internal violence, but a supreme federal government or compositive state, acting not only upon the sovereign members of the Union, but directly upon all its citizens and their individual and corporate capacities. Source: Wheaton Elements International Law, Statute 52, page 78, L.B. and Company, 1866. The Postal Service shall have the obligation, the Commander-in-Chief, to provide postal services to bind the nation together through the correspondences of the people. Source: USPS website. And note: applicants may receive indefinite general delivery service as provided in Domestic Mail Manual DMM D930. See also Postal Bulletin 21870, date 6/23/1994, page 7. Note: the 30-day limit in DMM D930.1.4 refers to how long mail is usually held in the general delivery section, not to how long a person can receive general delivery service. Operation Support, 9/29/1994. Source: Postal Bulletin 21877, 9-29-94, page 7. The use of the general delivery should be discouraged if it is possible to receive mail otherwise, but if a patron insists on receiving his or her mail through the general delivery, the request must be complied with. Postal Laws and Regulations, 1932, Section 776-797, Delivery of Mail, Methods, Transits, Box Renters. Intent behind free delivery of mail. As proclaimed by Congressman Clyde Kelly, Post Office and Post Roads Committee member and United States Postal Policy, in parentheses D. Appleton and Company, 1931, discussing the subject of the Great Postal Highway, i.e., post roads for the free delivery of mail. Every American is the beneficiary of this postal highway and of those leaders who insisted upon its being built on the service foundation. Its very existence is proof that the true objective of the post office is service, not money-making. There never was any other motive than the public welfare behind the establishment of the rural free delivery service. The one test in changes en route must be, will the service be as good or better than formerly? The test of self-support should not determine the future of this facility, which brings benefit to every citizen of the United States, whether he lives in city or country. A more accurate version of the first appearance above, those leaders who insisted upon its being built on the free service foundation. The cost of the postal highway was a lost leader for Lincoln, a giveaway that secured an infinitely greater bounty, unwitting sureties for co-debtor, trade name citizens of the United States, because sovereign Americans also benefit from the mail that is delivered free of charge and the all caps trade name of their citizen of the United States straw man. The sovereign Americans are doubly hooked in. Military aspects of the postal system. USPS as a semi-autonomous operation, free from congressional oversight, with a stated mission, military objective under the President as Commander-in-Chief of the current military regime, as a de facto military unit. Throughout history, the postal system has performed numerous military and quasi-military functions. During World War I, the U.S. Post Office was called upon to perform a bewildering number of non-postal functions. The postal establishment sold Liberty bonds and war-saving certificates. Post offices registered enemy aliens. They handled without charge millions of tons of government mail, such as draft questionnaires and appeals for food conservation. The money order system, authorized by the Act of May 17, 1864, was a wartime measure that achieved permanent acceptance. Sourced the Post Office Department by Gerald Cullinan. Postal clerks, now identified as sales associates on their name tag, are authorized to accept and process passport applications, beginning in 1971, immediately after conversion into the private USPS. For the U.S. Department of State, headed by the U.S. Secretary of State, who administers the war powers. Passport is defined as a license issued during the progress of a war authorizing a person to remove himself or his effects from the territory of one of the belligerent nations to another country, or to travel from one country to a country without arrest or detention on account of the war. Black's Law Dictionary, 1st edition. Selective Service registrants filing out the Selective Service System Registration Form, SSS, Form 1, October 91, are directed as follows. Block 8. When you have completed your form to this point, recheck it and take it to the postal clerk for verification, sign and date in the presence of a postal clerk. In 1931, when Congressman Clyde Kelly introduced United States postal policy, referenced above, the Army and Navy Marine Corps is a branch of the Navy, comprised the totality of the armed forces of the country. Despite the enormity of this fact, Kelly, in describing the value of the postal highway, proclaimed, "It is the highway of service designed by a democracy, with faith for a social institution of vital importance in a people's nation. It is more essential for the protection of the nation than the Army or the Navy of its democratic instrument of a democracy. By virtue of the postal highway, all American citizens, in parentheses, a much greater number than the total enlistment of the Navy and Army, became accountable, responsible for United States Incorporated. Indeed, once one accepts free delivery of mail intended for his citizen of the United States straw man, he or /she incurs an obligation for military service as co-beneficiary. Surety for the person whose trade name appears on the draft notice. Another obvious discrepancy in Kelly's postal policy is the fact that the de jure United States of America is not a democracy, but a republic, guaranteed in Article 4, Section 4 of the Constitution cited earlier in this treatise. Congressman Kelly is not talking about the defunct republic. Rather, He is telling us in no uncertain terms that the postal highway, which is used only for free delivery of mail, is an instrument of the de facto illegitimate democracy (military government stratocracy) instituted by Lincoln. Sifting out the key issues. The postal system was not created as a money-making operation, but as a service facility, where operating at a profit was not a prime consideration. Cost of postage covers transit of mail no farther than the destination post office, where postal patrons can retrieve mail matter at the general delivery window. No one can be denied general delivery service, a traditionally vested common law right established by usage and custom since ancient times. Postal patrons, but not postal customers, can use general delivery indefinitely for retrieving mail and need not disclose their identity, produce government-issued ID. General delivery has never been the subject of legislation of the de facto illegitimate stratocracy, which came into existence with the first executive order issued by Lincoln in his capacity as Commander-in-Chief of the military. Maxim of law. No one is obliged to accept a benefit against his consent, dig.50.17.69, Brum, Max 699. Those who accept a benefit consent and do so voluntarily. Maxim of law. Consent makes the law. Branch, Prince, 8, Mont, 32. Delivery of mail matter is, and has been since July 1st, 1863, a benefit, a mutually agreed upon consensual arrangement, and a voluntarily accepted free service. Public welfare was the solitary motive behind the establishment of free city delivery during the Civil War in 1863. Public welfare was the solitary motive behind the establishment of rural free delivery of mail in 1896, when 90% of the population lived in the country. Acceptance of free delivery of mail matter from USPS under Commander-in-Chief of the military makes one a beneficiary of public welfare and protection of the state. Anyone accepting the benefit of public welfare and the protection of the state establishes that he/she is mentally incapable of caring for himself/herself, and those who cannot care for themselves are subjects of the doctrine of parens patriae, as discussed earlier in this essay in the section on Social Security. People are dragged into this contract through the back door, whereby the promise is extracted as explained in 13 Corpus Juris Secundum 311, cited in Woolam v. Sizemore. Quote, various definitions of consideration are to be found in the textbooks of judicial opinions. A sufficient one is a benefit, free delivery of mail to the party promising, mail recipient, or loss or detriment, costs, injuries, losses incurred delivering mail, to whom the promise is made, government. Benefit, as thus employed, means that the promisor has, in return for his promise, acquired some legal right, welfare, protection of the state, to which he would not otherwise, without conceding mental incompetence upon accepting of free delivery, have been entitled. And detriment means that the promisee, government, has, in return for the promise, forborne some legal right, to charge for delivery of mail, as was done from 1794 through June 30, 1863, which we would have otherwise been entitled to exercise. End quote. Conclusion. As asserted by the Assistant U.S. Attorney in the Cooper case, use of the United States Postal Service constitutes a contract of co-surety that renders anyone so contracting under federal jurisdiction and a subject of mandatory federal income taxation. Welcome to the club. Co-suretyship through licensing. In America, a person with a name designated in all capital letters is legally classified as an individual. The legal definition of individual is citizen of the United States. 5 U.S.C. 552A, Section A, Section 2. A citizen of the United States must be licensed for almost every activity under the sun, proven by the appearance of its name exclusively on every type of issue of license. License is defined as follows. Quote, in international law, permission granted by a belligerent state to its own subjects, to the subjects of the enemy to carry on a trade interdicted by war. Bouvier's Law Dictionary, 8th edition. End quote. As mentioned earlier in this book, the common law is ancient and immutable and predates all codified law, its principles having been established by usage and custom since before recorded history. Based on principles of the common law, no flesh and blood, man/woman need obtain the permission of any abstract contrivance of the mind, such as a government, for fulfilling basic needs for survival and keeping his/her body alive. The only way artificial governments can govern and rule over a living, breathing man is by convincing him that he is a subject of another/others far wiser than he and deciding what is best for him, in parentheses, and then administrating legalized deadly violence against him should he stray too far from the herd. Making a man believe that he is a subject can be accomplished in many ways, one of which is corruption of the name, as discussed in the first essay in this manual. As a sovereign, your ultimate remedy is in the common law and international law, i.e., trade, commerce, exchange with other sovereigns, and when involved in commerce, intercourse of any kind, the greatest power resides in your true name. Of course, anyone can forego these options and pursue remedy in the name of his/her bankrupt citizen of the United States debtor trade name, which always welcomed by government but eminently ineffective in achieving one's objectives. However, as is discernible from the definition of license above, licensing of subjects comes into play when a trade/occupational calling is interdicted, in parentheses prohibited, or forbidden, by war, as is presently the case in America. Trading with the enemy is defined as, quote, the federal offense of carrying on commerce with a nation or with a subject or ally of a nation with which the United States is at war. Black's Law Dictionary, 7th edition. The Trading with the Enemy Act of October 6, 1917, in parentheses H.R. 4960, Public Law 91, though admitting of the possibility that citizens of the United States could be considered as the enemy when involved in monetary transactions within the United States, also expressly excluded them from such categorization in the following passage. Quote, Section C. Such other individuals, or body, or class of individuals, as may be natives, citizens, or subjects of any nation with which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business. End quote. However, the Amendatory Act to the Trading with the Enemy Act, also known as the Emergency Banking Relief Act of March 9th, 1933, in parentheses 48 Statute 1, amended the Trading with the Enemy Act at a time when United States was not in a shooting war with any foreign foe, omitting the clause excluding citizens of the United States as enemies in war, and including them as such instead via insertion of the following innocuous little passage, end quote, by any person within the United States or any place subject to the jurisdiction thereof. Chapter 1, Title 1, Section 1B. By operation of law, all persons, in parentheses, citizens of the United States, involved in monetary transactions within the United States were now officially enemies of the United States government, and as such required a license for almost every type of commercial activity imaginable. The above definition of license from Bouvier's Law Dictionary, 8th edition, now becomes more understandable. Quote, the international law, permission granted by a belligerent state to its own subjects, or to the subjects of the enemy, to carry on a trade interdicted by war. End quote. The fact that sovereign Americans do not qualify as persons within the United States, and hence are not subjects of the legislation, was not explained for them by the U.S. government in 1933, nor any time thereafter, in parentheses, and never will be. Using this legislation as justification, however, federal and state government agencies launched a nationwide campaign to convince all Americans that they needed a license for virtually every activity they were involved in, and managed successfully inculcating the stratagem into society over the ensuing decades. Notes. Interdict: to prohibit or restrain authoritatively, forbid. Subject: one who owes allegiance to a sovereign and is governed by that sovereign's laws. Black's Law Dictionary, 7th edition. There is no requirement in any vehicle code requiring a driver license for anyone not engaged in the commercial activity of the transportation or persons or property for hire or compensation, in parentheses, cab drivers, bus drivers, limousine drivers, and truck drivers. The code encrypting esquires that write the vehicle code, however, have very cleverly circumvented this non-requirement via the federal definition of motor vehicle. Motor vehicle is a commercial term and signifies that any automobile, motor home, bus, truck, van, motorcycle, etc., that is registered with any motor vehicle department is a vehicle used in the transportation of persons or property for hire or compensation, and therefore requires a license for its operation, even though the driver, in parentheses, another commercial term, is not directly involved in commerce. He/she is operating a commercial motor vehicle, in parentheses, involved in the transportation of persons or property for hire or compensation. Thus, the need for a license. No judge and no attorney and no police officer can identify any section of any vehicle code that requires a private for pleasure automobile used strictly for non-commercial purposes be registered with the state. Registration of a private use only automobile is voluntary. Inculcate: to impress upon the mind by frequent and emphatic repetition, and still. Stratagem: a maneuver designed to deceive or outwit an enemy in war. The introduction of the need for licensing and the enforcement thereof was instigated over a longish period of time, thereby avoiding mass resistance from the populace. People in California, for example, were not propagandized the need for a driver's license for non-commercial purposes, in parentheses, i.e., for pleasure use only, until 1957, 24 years following the Amendatory Act, when the driver license was introduced. The commercial chauffeur license and commercial operator license were combined into the new driver license, artfully confusing the public over the need for a driver license in order to drive. End notes. Licensing equals legal liability. When a sovereign American voluntarily applies for, accepts, endorses in his name, and uses as his own a license issued in the all-capital letter trade name of his straw man, that party is signing for accommodation because the straw man is incapable of signing and has cemented his status as surety for the citizen of the United States, enemy, debtor, individual named thereon, because every accommodation party is ever and always a surety. It cannot be any other way. Quote, an accommodation party is always a surety. UCC 3-419, Note 3, Paragraph 2. End quote. The straw man named on the license has neither the hand nor the body required for applying a signature. Another party must perform these acts on its behalf, someone capable of assuming legal liability for the person in whose name the license is issued, an accommodation party. The voluntary act of applying for a license that is issued in the straw man's trade name by executing one's own signature in place of the straw man's is concrete evidence of voluntary assumption of the status of surety. Quote, one who undertakes to pay money or perform others' acts in the event that his principal fails to do so. The surety is directly and immediately liable for the debt. Barron's Law Dictionary, 3rd edition, 1991. End quote. As asserted by the Assistant U.S. Attorney in the Cooper case, the act of paying Social Security payroll taxes into the Social Security account of the individual named on the Social Security card constitutes a contract of co-surety that places anyone so contracting in the federal jurisdiction and a subject of mandatory federal income taxation, since the entity listed on every license that you carry is the same as that on the Social Security card in your possession. There is no reason to believe that the same liabilities do not apply. Volunteering and co-suretyship. The Internal Revenue Code, in parentheses, Title 26, United States Code annotated, states that our system of taxation is based upon voluntary compliance. As everyone knows from the cavalcade of cases that are enthusiastically reported by the news media, those who do not voluntarily comply and file income tax returns and pay income tax are forced into complying and paying with fines, indictments, seizures of property, garnishments, and incarceration. Q. When did the voluntary part come into the picture? And A, in parentheses, though by no means an exhaustive list. The moment you voluntarily paid in your first penny of Social Security payroll tax, which was, of course, preceded by your parents voluntarily enrolling you in the Social Security system when you were a minor, and your subsequent failure upon attaining the age of majority to withdraw from the program and nullify / cancel the contract, thereby tacitly consenting with the terms of the contract in full, albeit unwittingly making yourself welfare eligible. The first time you voluntarily accepted free home delivery of mail matter from an agent of the Commander-in-Chief, i.e., de facto military personnel of the United States Postal Service, in parentheses, note, although you can officially notice the postmaster that you have been accepting free delivery of mail matter under mistake and no longer wish free delivery. The headaches that come with such a move are significant. Capture of legal title of the trade name under the common law and control of same through the UCC allows both use of the Postal Service and control of the destiny of the citizen of the United States trade name. The first time you voluntarily applied for and signed for and paid for and received a license for a privileged activity in the all capital letters name of your citizen of the United States / individual / United States government employee trade name and assumed responsibility for payment and performance of the straw man's obligations associated therewith by signing for accommodation, and the first time you undertook numerous other voluntary acts, such as applying for and paying for and receiving a passport from United States Department of State and registering to vote in the all capital letters citizen of the United States trade name, and then affixing your own personal signature as accommodation party and therefore surety on each document. Notes. For a conclusive treatment on this subject, see how to sign your signature without liability. End note. The situation. The only reason you have suffered at the hands of those who would bleed every ounce of economic lifeblood from your withered carcass is because you were unaware of the artificially manufactured justification technique used by such con men for wreaking holy hell with your life. Corruption of your name. It has taken over 2,000 years, but this little band of extortionists has put together quite an operation for itself, and it all depends on your continued ignorance of your name as personal property and the significance of your true name spelled in an all capital letter / abbreviated format. The reason government, bank, corporate, court, and tax agency computers spit out bill statements and threatening correspondence with your name corrupted into an all caps format is because the entity named thereon is the actual target, the account holder, the customer. They are utterly dependent on your mistakenly believing that the all caps name identifies you. So you will assume the role of accommodation party and surety for the artificial person they have created. Such is the depth of their deceit, their entire earthly objective, every waking moment of every single day of their hideous little existence, predicated on keeping you and your family and your friends ignorant of the real meaning behind your name set in capital letters, and the significance of applying your own signature when it's, in parentheses, the straw man's, is required. For those afflicted with the curse of co-suretyship, the pathology can be grim. Loss of wealth, loss of possessions, loss of shelter, loss of family, loss of self-respect, loss of health, and even loss of life. It matters not whether one willingly submits and acts in accordance with the agenda of the chosen masters, and does as one is told. The foregoing milestones comprise the schedule of events for one and all. The only difference is the timing. There is no logic in these plans. And this is the very reason that most people cannot conceive that anyone else would have such evil intentions. However, if unchecked, everyone, including the perpetrators, will lose in the end. Probably the most tragic and regrettable fact of all is that none of these statements contained in this volume constitute hyperbole. Your authors wish it were not so, but such is the gravity of the situation we are faced with. Notes: Pathology: the sum of the morbid conditions, processes, and results in the course of a disease. Relief. No matter how black it may be for some, there is abundant hope for those who are capable of seeing what is right in front of them. For such people, the curse of co-suretyship is as temporary as the common cold and more easily treated as well. Capture and control under the common law of the trade name that others have been exploiting at your expense requires nothing more than asserting the fact in writing, taking the steps of filing the statement in the legal notices section of the newspaper, and with the county clerk / recorder establishes public notice and makes it that much better. Following public notice of your new common law copyrighted trade name, creation of the legal relationship between the two of you via a private agreement and a security agreement, and execution and filing of a UCC financing statement to perfect the matter can be completed in days. These documents legally distinguish you from the trade name and give you legal control over it in all financial and legal matters, including those involving government actors who carried out the ugly plot, in parentheses, at the behest of the chosen masters that put us in this mess in the first place. The degree of control over your economic life depends only on your understanding of the power that resides in legal ownership of your true name and trade name and your effectiveness in communicating it. Mere notification of the relationship between you and the trade name is sometimes sufficient to stop a would-be predator. For others that require more persuasion, the material in the presentment handling section will take care of the vast majority. For the minute percentage that insists on kicking and screaming every step of the way until closure, the publisher can suggest other contacts that can assist you in your needs. Full speed ahead. Notes: hyperbole, poetic, or rhetorical overstatement, exaggeration. End notes. Section 4. Annotated Glossary of Terms. Annotated Glossary of Terms. Cracking the Code. Note: UCC means Uniform Commercial Code. Per UCC Statute 1-104, when there arises a conflict between current code and a deleted section, the deleted section controls, i.e., nothing is ever actually deleted. Therefore, earlier editions of the UCC would be useful. Introduction. Do not expect to understand the UCC at a glance. It is the culmination of thousands of years by effort by countless collaborators and was never supposed to have been deciphered. Understanding the code can be likened to solving a giant jigsaw puzzle. One is not going to see the picture with all the pieces in disarray. A few pieces must be connected before one can gain awareness of the fundamental issue at hand, build on them, and eventually solve the puzzle. But this need not take an inordinate amount of time. One good way to go about it is to follow the annotations accompanying the definitions of terms that direct you to see and compare other related terms in the glossary. By gathering bits of understanding from different places and from different points of view, the pieces of the puzzle begin to fit together and the big picture can take shape very quickly. There are a number of key terms that will provide a good entrance point to the glossary for gaining an understanding of the redemption process. Some of those terms would be straw man, birth certificate, transmitting utility, value, redemption, and House Joint Resolution 192 of June 5th, 1933. All terms have bearing on what has happened and is currently happening, thereby making it very interesting material for anyone concerned about survival and freedom. Glossary. Ab initio. Abinitio. Latin. From the beginning. From the first act. Black's Law Dictionary, first edition. Absolute rights. As regards right to interfere with contractual obligations of another. Absolute rights. Which individual may exercise without reference to motive are rights incident to ownership of property, rights growing out of the contractual relations, and right to enter or refuse to enter contractual relations. By the absolute rights of individuals is meant those which are in the primary and strictest sense such as would belong to their persons merely in the state of nature, and which every man is entitled to enjoy, whether out of society or in it. The rights of personal security, of personal property, of private property do not depend upon the Constitution for their existence. They exist before the Constitution was made, or the government was organized. These are what are termed the absolute rights of individuals, which belong to them independently of all government, and which all governments which derive their power from the consent of the governed were instituted to protect. W&P, Volume 1, Compare, Droit. Acceptance. The voluntary act of receiving something or agreeing to certain terms. And contract law, acceptance is consent to the terms of an offer, creating a binding contract, the taking and receiving of anything in good part, and as if it were a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. The act of a person to whom a thing is offered or tendered by another, whereby he receives the thing with the intention of retaining it, such intention being evidenced by a sufficient act. Black's Law Dictionary, 6th edition. An agreement, either by express act or by implication from conduct, to the terms of an offer so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counter-offer. Black's Law Dictionary, 7th edition. A negotiable instrument, especially a bill of exchange, that has been accepted for payment. Black's Law, 7th edition. Acceptance by silence. When the court implies a promise or holds that good faith requires a party not to violate these expectations, it is recognizing that sometimes silence says more than words, and it is understanding its duty to the spirit of the bargain is higher than its duties to the technicalities of the language. Acceptance for value. See also remedy, acceptance, value, holder in due course, and banker's acceptance. Note: by acceptance for value is implied a taking, an acceptance of something in exchange for another thing previously provided, e.g., a using credit balance previously established to purchase something. Value, as peculiarly defined within the UCC, is an esoteric term and implies that some sort of credit has been established beforehand, whereby the party with the credit may take, accept, purchase some item in commerce based on his credit, i.e., what is owed. It implies in numerous types of situations. Basically, if a party has established his position as a creditor of some sort, he can unilaterally accept, in parentheses, purchase, / take, anything that would help reconcile the credit discrepancy by executing that particular transaction. Such a creditor, having essentially a credit balance, need not obtain anyone's approval before acting so. One example of this is the acceptance for value of a document bearing the creditor's trade name, e.g., the birth certificate. The source of all credit and accountability value associated with the trade name is the sovereign, flesh and blood man / woman from whose true name the trade name was derived. Acceptance of a bill of exchange. In mercantile law, the act by which the person on whom a bill of exchange is drawn, in parentheses called the drawee, assents to the request of the drawer to pay it, or, in other words, engages or makes himself liable to pay it when due. It may be by payroll or in writing, and either general or special, absolute or unconditional, and it may be impliedly as well as expressly given. But the usual and regular mode of acceptance is by the drawee's writing across the face of the bill the word acceptance, and subscribing his name, after which he is termed the acceptor. Black's Law Dictionary, 1st edition. See also Banker's Acceptance, Bill of Exchange, Sight Draft. Parole, a word, speech, hence oral or verbal, expressed or evidenced by speech only, not expressed by writing. Black's Law Dictionary, 4th edition. Acceptance of draft, certified check. Section A means the drawee's signed agreement to pay a draft is presented. It shall be written on the draft and may consist of the drawee's signature alone. Acceptance may be made at any time and becomes effective when notification pursuant to instructions is given or the accepted draft is delivered for the purpose of giving rights on the acceptance to any person. B. A draft may be accepted although it has not been signed by the drawer, is otherwise incomplete, is overdue, or has been dishonored. C. If a draft is payable at a fixed period after sight and the acceptor fails to date the acceptance, the holder may complete the acceptance by supplying a date in good faith. D. Certified check means a check accepted by the bank on which it is drawn. Acceptance may be made as stated in subdivision A, or by a writing on the check which indicates that the check is certified. The drawee of a check has no obligation to certify the check. Refusal to certify is not dishonor of the check. UCC 3-409. Acceptor. Acceptor means a drawee who has accepted a draft. UCC 3-103, Section 1. The person who accepts a bill of exchange, in parentheses generally a drawee, or who engages to be primarily responsible for its payment. Black's Law, 1st edition. Accommodation. An arrangement or engagement made as a favor to another, not upon a consideration received. Something done to oblige, usually spoken of a loan of money or commercial paper, as a friendly agreement or composition of differences. The word implies no consideration. While a party's intent may be to aid a maker of note by lending his credit, if he seeks to accomplish thereby legitimate objectives of his own, and not simply to aid maker, the act is not for accommodation. Black's Law, 6th edition. 1. A loan or other financial favor. 2. The act of signing an accommodation paper as surety for another. Black's Law 7th edition. Note: all of your licenses, permits, utility services, bank accounts, travel documents, W-4 forms, tax returns, paychecks, etc. are in your strawman's fictitious trade name, not your true name. Until now, when you signed any of these items, you were signing for accommodation and obligating yourself, albeit unwittingly, on behalf of your trade name. See strawman. Accommodation endorser. A party who places his name to a note without consideration for purposes of benefiting or accommodating some other party. Black's Law Dictionary, 6th edition. Accommodation loan. A loan for which the lender receives no consideration in return. Accommodation maker. One who puts his name to a note without any consideration with the intention of lending his credit to the accommodated party. Note: when you sign a traffic citation, which is a promise to, in parentheses, appear and then pay, i.e., a promissory note, you are the accommodation maker, your straw man, the accommodated party. Accommodation note. One to which accommodating party has put his name, without consideration, to accommodate some other party who is to issue it and is expected to pay it. Black's Law 6th edition. UCC 3-419. Note: all promises to pay are done by accommodation. The flesh and blood man or woman signs the note for accommodation on behalf of the trade name. The fictitious straw man, in parentheses trade name, an artificial person created by government, is transmitting utility, whereby all goods and services of the industrial society flow into and out of the possession of the flesh and blood man / woman. The straw man, having no life, no brain, and no body with which to apply a signature, must be accommodated by the actual / attached man / woman, also known in this context as a surety. Accommodation party. One who signs commercial paper in any capacity for purpose of lending his name, i.e. credit, to another party to instrument. Such party is a sureter, or surety. Note: when you sign a traffic citation, IRS Form 1040, etc., you are the accommodation party. You are the source of all credit for the party whose name appears on the driver's license, Social Security card, etc., in your possession. You have provided the trade name with value, in parentheses credit, your entire life. Accommodation surety. See voluntary surety, under surety. Account. Account, except as used in account for, means a right to payment of a monetary obligation, whether or not earned by performance. I, for property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed of, for services rendered or to be rendered, for a policy of insurance issued or to be used, for a secondary obligation incurred or to be incurred, for energy provided or to be provided, for the use or hire of a vessel under a charter or other contract, arising out of the use of a credit or charge card, or for information contained on or for use with the card, or as winnings in a lottery or other game of chance operated or sponsored by a state, governmental unit of a state, or persons licensed or authorized to operate the game by a state or governmental unit of a state. The term includes healthcare insurance receivables. The term does not include rights to payment evidence by chattel paper or an instrument, commercial tort claims, deposit accounts, investment property, letter of credit rights or letters of credit, or rights to payment for money or funds advanced or sold, other than rights arising out of the use of a credit or charge card or information contained on or for use with the card. UCC 9-102 Section A, Section 2. See also Consumer Transaction. Account number. Note, same as account. 2. The sovereign creditor's mirror image, private side, in parentheses of the governmental double entry bookkeeping ledger. Account number, e.g., 1, 2, 3, 4, 5, 6, 7, 8, 9, of the straw man's debtor's public side Social Security account number, e.g., 123-45-6789. All IRS, in parentheses, and state tax agency correspondence references the account number as the dashless version of the Social Security account number. Account debtor. Account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. UCC 9-102, Section A, Section 3. Accounting. Accounting, except as used in accounting for, means a record that is all of the following. A. Authenticated by a secured party. B. Indicating the aggregated unpaid secured obligations as of a date not more than 35 days earlier or 35 days later than the date of record. C. Identifying the components of the obligations in reasonable detail. UCC 9-102, Section A, Section 4. Accusation. A formal charge against a person, to the effect that he is guilty of a punishable offense laid before a court or magistrate having jurisdiction to inquire into the alleged crime. Black's Law Dictionary, 6th edition. Note, per listing of informer/informant of the birth document, and as subscribed thereto by one's mother, one has, by definition, had an accusation preferred against one. This is also very possibly the basis for all subsequent insistences by Big Brother that the all capital letters trade name references the man or woman so identified by the birth document. See also informer, identification of goods, proper, all capital letters written. Action. Action in the sense of a judicial proceeding includes recoupment, counterclaim, set off, suit in equity, and any other proceedings in which rights are determined. UCC 1-201, Section 1. See also set off. Adhesion contract. A contract so heavily restrictive of one party, while so non-restrictive of another, that doubts arise as to its representation as a voluntary and uncoerced agreement, implies a grave inequality of bargaining power. The concept often arises in the context of standard form printed contracts prepared by one party and submitted to the other on a take it or leave it basis. The law has recognized there is often no true equality in bargaining power in such contracts and has accommodated that reality in construing them. Barron's 3rd edition. Note, a driver's license application and an IRS Form 1040 are examples of an adhesion contract. Admiralty. A court which has a very extensive jurisdiction of maritime causes, civil and criminal. C. Admiralty law, maritime. Note: Admiralty courts, i.e., municipal court, superior court, etc., comprise the only jurisdiction that can enforce a criminal penalty for a civil offense. No other type of jurisdiction has this capability. This is why people must post bail prior to arraignment or trial and are sometimes sentenced to jail time, in parentheses, two aspects of criminal procedure. For civil offenses, such as traffic citations, wherein no party is injured and no property damaged, all courts in America operate as admiralty courts. Admiralty law. The terms admiralty and maritime are virtually synonymous. Black's Law Dictionary, 6th edition. Affiant. The person who makes and subscribes an affidavit. The word is used in this sense interchangeably with deponent, but the latter term should be reserved as the designation of one who makes a deposition. Black's Law Dictionary, 1st edition. Note, see also affidavit. Note, as relates to the redemption process, affiant, as defined as the natural-born flesh and blood, sentient being, whose name is designated in upper and lowercase letters, in parentheses, one's true name, in accordance with the rules of English grammar, who executes and signs an affidavit under oath. Affidavit. A written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before an officer with authority to administer such oath. Black's Law Dictionary, 1st edition. See also Commerce. Note: the capacity to issue one solemn declaration of truth, one sacred word, is the most basic, fundamental, underlying, foundational concept of all commerce, society, and civilization. An affidavit is a written statement under oath executed and sworn to before an authorized officer on the maker's commercial liability that all assertions contained within the affidavit are true, correct, and complete, not misleading, the truth, the whole truth, and nothing but the truth. An affidavit is the most solemn, unequivocal, and ceremonial means extant to express truth without evasion, concealment, deception, or insincerity. As distinguished from testimony, an affidavit is not subject to cross-examination and is intended to be a complete, self-contained document. All truth is subjected, and only each free will being possesses the right, duty, privilege, and capacity to state that affiant's own truth in accordance with the unique nature, perspectives, and priorities of the affiant. No one has the authority nor the ability to state the truth of another. As per the maxim of law, the order of things is confounded if everyone preserves not his jurisdiction. Because truth is supreme in commerce, an affidavit is the most important document in commerce, and stands as the truth, unless rebutted, point for point, by counter-affidavit, signed and certified on the executing party's commercial liability as true, correct, and complete. In parentheses, i.e., not misleading, the truth, the whole truth, and nothing but the truth. Exodus 20, verse 16. The 9th commandment states, "Thou shalt not bear false witness against thy neighbor." The Bible is especially harsh on those who bear false witness. Lies are weapons that are easy to utter, difficult if not impossible to undo when spread as rumors, and can destroy lives. People often act on what is told to them and kill or are killed on the basis thereof, such as by marching off to war, believing authorities, or blindly obeying one's superiors. Caveat emptor is as wise an attitude in the field of words and ideas as it is concerning goods or services. For one's group's official attempt at avoiding the consequences of bearing false witnesses, see connaître, Kolnidre. Affidavit of service. An affidavit intended to certify the service of a writ, notice, or other document. Black's Law Dictionary, 1st edition. Note: when using the mails / United States Postal Service for service of commercial process, it is always wise to include an affidavit of service along with the item served. In so doing, one averts the potential claim by the recipient: I received the envelope, but it was empty. A sample affidavit of service is found in Part 2 under Handling Presentments. Agreement. Agreement means the bargain of the parties in fact, as found in their language, or by implication from other circumstances, including course of dealing or usage of trade or course of performance, as provided in this code. Whether an agreement has legal consequences is determined by the provisions of this code, if applicable, otherwise by the law of contracts. Section 1-103 and UCC 1-201 in Section 3. Compare contract. Note: in other words, you have formed an agreement in fact and are inextricably linked with the trade name by course of dealing, usage, trade, and course of performance. The legal consequences of the marriage with your strawman trade name is spelled out in the code. Where applicable, where not applicable, it references Section 1-103, which states that all other forms of law shall supplement its provisions. The UCC is the supreme codified law on the planet. Legal consequences are dictated under the UCC. In law, and the UCC is the supreme law, there are only two kinds of people: debtors and creditors. All capital letters written. A proper name appearing in all capital letters falls outside the rules of English grammar, which authorizes the use of a capitalized letter only for a very limited number of well-defined uses, such as the initial letter of a proper name. A capital letter is defined as of the large size used at the beginning of a sentence or as the first letter of a proper name. No lexical authority for use of all capital letters in the name of a man or woman has yet been referenced by those who would insist on corrupting the true names of men and women by displaying their name in all capital letters. An all capital letters written version of one's name is not one's true name, but an artificial construct, existing by force of law only. No authority of English grammar recognizes such a contrivance. The legal term in propria persona means in one's own proper person. How can one do anything outside of one's own proper person, unless there exists some other person, by whom / which one could act? Using the juristic artifice known as legal fiction, parties identified by their proper noun name have been ascribed corrupted. All capital letter names, all legal pleadings, court records, and licenses use only names appearing in all capital letters, i.e., newborn artificial persons existing in contemplation of or by force of law alone. See legal fiction. Proper, fictitious name, artificial person, idem sonens, informer, juristic person. Allodial, free, not holden or of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. Black's Law Dictionary, first edition. See also allodium, or feudal. Allodium, MLOG, allod, all, OD, patrimony, CICEL, auth, OE, ETH, in FL, akin, by graduation, land held by absolutely in one's own right, and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Black's Law Dictionary, first edition. See note at allodial. Appearance: a coming into court as party to a suit, whether as plaintiff or defendant. The former proceeding by which a defendant submits himself to the jurisdiction of the court. Bouvier's Law Dictionary, 8th edition. Note: there are two kinds of appearance, general and special. See bail. Appellation: accosting, appeal, calling by name, title, pronunciation. Burt's Latin English Dictionary, 1926. French appellation, 13th, C. A.D. L. Appellation, E.M. Of action, F. Apparel, to accost, address, call upon. Appealing, appeal. Obs. 1. The action of appealing to a higher court or authority against the decision of an inferior one. The appeal so made. Ground of appeal, title, claims. Observation rare. 2. Gen. The action of appealing or calling on, entreaty, or earnest address. Calling designation. 3. The action of calling by a name. Nomenclator. 4. A designation, name or title given. A. To a particular person or thing. B. To a class. A descriptive or connotative name. 1. A name or title. 2. The act of naming or calling. Act of calling by a name or designation. Webster's Collegiate Dictionary, 5th edition, 1947. Appealing, calling, naming. Appellation. Cassell's French-English and English-French Dictionary. See note section entitled The Con Beneath the Con and Maintaining Fiscal Integrity in Part 1 of this manual. Accost, to speak to first. Address, greet. Manner or act of addressing, greeting. Note: the significance of this term in your quest for personal sovereignty cannot be exaggerated. Appellation may be construed as simply a name, but its true meaning is infinitely more profound. Its actual meaning is that which is used by others for the purpose of gaining your attention. How you then respond after receiving such greeting / address is the prerogative of a sovereign. Art, a principle put in practice and applied to some art, machine, manufacture, or composition of matter. Black's Law Dictionary, 1st edition. Artificial, created by art or by law, existing only by force of or in contemplation of law. Black's Law Dictionary, 1st edition. Note: names of persons appearing in all capital letters are not written in English and exist only by force of or in contemplation of law. Persons so named are artificial persons. See juristic person, proper, all capital letters written, idem sonans, and fictitious name. Artificial person. C. Artificial and person. Assignee, the person or business to whom a security interest in collateral is transferred. Attachment, a security interest attaches to collateral when it becomes enforceable against the debtor with respect to the collateral, unless an agreement expressly postpones the time of attachment. UCC 9-203, Section A. Note, depending on the type of collateral, a security interest attaches and becomes enforceable under different circumstances. See UCC-203 for details. Under previous Article 9, which is still essentially in harmony with revised Article 9, when the three basic prerequisites of a security interest exist, i.e., agreement, value, and collateral, the security agreement became enforceable between the parties and was said to attach. And note, attorn, law, attorner, 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 whence law, Latin, attornere, to turn, turn to, assign, attribute, dispose, arrange, order, appoint, constitute, ordain, decree, to, turner, to turn. The analogical spelling is, but under the influence of medl, a tournaire, the late af became a tourneur, whence a torn passed into the English law books. 1. Trans, to turn over to another, to assign, transfer, in parentheses, goods, tenants, service, allegiance, etc. 2. To transfer oneself, in parentheses, i.e., one's homage and allegiance from one lord to another, to yield allegiance, or do homage to, as lord. 3. To agree formally to be the tenant of one into whose possession the estate has passed, to do some act which constitutes a legal acknowledgement of the new landlord. Attorney, in a sense of one appointed or one constituted, whence all the specific uses, in parentheses, the statement found in the law dictionaries for the last 200 years that the word means one who acts in the turn of another is a bad guess. For spelling one appointed or ordained to act for another, an agent, deputy, commissioner, in later times only, figure, and perhaps with conscious reference to sense. 2. Attorney in fact, private attorney, one duly appointed or constituted, to act for another in business and legal matters, either generally, as in payment, receipt, and investment of money, in suing and being sued, etc., or in some specific act, which the principal, by reason of absence, is unable to perform in person, hence the contrast in person, and by attorney. Frequent also in senses. 3. Attorney at law, public attorney, a professional and properly qualified legal agent practicing in the courts of common law, in parentheses, as a solicitor, practiced in the courts of equity, one who conducted litigation in these courts, preparing the case for barristers or counsel, whose duty and privilege it is to plead and argue in open court. 4. Transfer, an advocate, pleader, mediator. 5. Specific title of the law, officer of various councils, etc., and the clerk of various courts. 6. The king's attorney, earlier descriptive designation of the legal officer now called Attorney General, Mr. Attorney, the style used in addressing, in parentheses, formerly also speaking of, him. 7. Attribute, as in attorney, cunning. etc. See the truth about Esquires in Part 1 of this manual, also attorney and client. Attorney and client, his first duty is to the courts and the public, not to the client. And wherever the duties to his client conflict with those he owes as an officer of the court and the administration of justice, the former must yield to the latter. The office of attorney is indispensable to the administration of justice, and is intimate and peculiar in its relation to, and vital to the well-being of the court. An attorney has a duty to aid the court in seeing that actions and proceedings in which he is engaged as counsel are conducted in a dignified and orderly manner, free from passion and personal animosities, and that all causes brought to an issue are tried and decided on their merits only. Duty not looked on lightly. Attorneys, as officers of the court, have duty to maintain respect due court, which duty should exceed that imposed upon the public generally, and which duty should not be looked upon lightly, and cannot be shirked under the guise of representing interest of a party litigant, arm of state, as attorney, an officer of the court, and as such an officer and arm of the state, in parentheses 124 F SUPP 257. Nature and duty of obligation. One who is admitted to practice as attorney at law, both by virtue of his oath of office and customs and traditions of the legal profession, owes to the court the highest duty of fidelity. In parentheses 97 N period W 2D 287 255 Min 370. In re Lord, accepting employment entails duty to courts and faithful performance of services. Vital public interest. The relation of attorney and client is affected by vital public interest. Letters patent. Right to practice law is a property right existing by virtue of letters patent. 168 A 229 114 NJ EQ 68 7 Corpus Juris Secundum 4 1980. Practicing attorney. Ability which is greater than that possessed by average citizen. 7 Corpus Juris Secundum 29 1980. Accepting employment entails duty to courts and faithful performance of services. See note. U.S. vs. Frank, DCNJ 53F 2D 128, reversed on other grounds. Laughlin vs. U.S. 57F 2D 1080 and reversed on other ground. Pierce, U.S. 59F 2D 518 in Ray Kelly, D.C. Mont 243 F 696, Florida, petition of Florida State Bar, ASSN Association, 186, SO, period, 280, 134, FLA, 851, NEB, State, X, REL, X is EX, REL, Nebraska State Bar Association vs. Jensen, 105, NW 2D 459, 171, NEB 1, CERTIORARI, denied. Certiorari denied 81S CT 905 365 US 870 5 LED 2D 860 ND hyphen States vs. Stokes 243 NW 2D 372 WIS Petition of Board of Law Examiners Examination of 1928 210 NW 710 191 WIS 359 VA Holt vs. COM 138 SE 2D 809 205 VA 332 reversed on other grounds 85 S CT 1375 381 US 131 14 LED 2D 290 LA State vs. Woodville 108 SO 309 161 LA 125 Min Hop vs. Clapperich 28 NW 2D 780 224 MINN 224 173 A period L period R period 622. Note: by definition, the obligations and duties of attorneys are toward the court and the public. Abstraction of the mind that favors government, never the client. Clients are fodder for the freedom, usurpation, and wealth confiscation activities of the court. Attorneys are there to ensure that the court is well stocked with paying customers. It is a rigged game, with attorneys enjoying many special privileges, such as having their fees enforced by judicial decree, even when they lose, in exchange for shepherding unwitting client victims into court at the sacrificial judicial altar. Clients are also wards of the court, and therefore persons of unsound mind. See client and wards of court. Attornment. 1. A turning over, transference, assignment. The transference of his homage and service by a tenant to a new feudal lord, hence legal acknowledgment of the new landlord. Authenticate. Authenticate means to do either of the following: A. To sign. B. To execute or otherwise adopt a symbol, or encrypt, or similarly process a record in whole or in part, with the present intent of the authenticating person to identify the person and adopt or accept a record. UCC 9-102, Section A, 7. Aver, in pleading, to declare or assert, to set out distinctly and formally, to allege. Black's Law Dictionary, 1st edition. Bail. By bail is understood sureties, given according to law, to ensure the appearance of a party in court. The persons who become surety are called bail. Sometimes the term is applied with a want of exactness to the security given by a defendant in order to obtain a stay of execution after judgment in civil cases. Bail is either civil or criminal. Bouvier's Dictionary, 6th edition. One who becomes the surety for the appearance of the defendant in court. Bouvier's Law Dictionary, 8th edition. To deliver the defendant to persons who, in the manner prescribed by law, become the security for his appearance in court. Bouvier's 8th. Monetary amount for or condition of pre-trial release from custody, normally set by a judge at the initial appearance. The purpose of bail is to ensure the appearance of the accused at subsequent proceedings. If the accused is unable to make bail, or otherwise unable to be released on his or her own recognizance, he or she is detained in custody. The 8th Amendment, U.S. Constitution, provides that excessive bail shall not be required. Black's Law, 6th edition. The surety or sureties who procure the release of a person under arrest by becoming responsible for his appearance at the time and place designated. Those persons who become sureties for the appearance of the defendant in court. Black's Law Dictionary, 6th edition. Note: if a straw man / trade name / defendant cannot make / pay bail, then the man / woman attached with the straw man / trade name / defendant becomes the bail. This is formal legal recognition / acknowledgement that is particular man / woman is the surety for the appearance of the dummy / straw man / trade name / defendant in parentheses artificial person in court. See dummy and surety and appearance. Bailee. Bailee means the person who, by a warehouse receipt, bill of lading, or other document of title, acknowledges possessions of goods and contracts to deliver them. UCC 7-102, Section 1, Section A. Bailment. A delivery of something of a personal nature by one party to another, to be held according to the purpose or object of the delivery, and to be returned or delivered over when that purpose is accomplished. Bouvier's Law Dictionary, 8th edition. A cycle of bailment commences when a mother delivers a baby, something of a personal nature, to the state by signing the birth certificate and registering and surrendering legal title to the biological property, i.e., the baby's body. See dummy, surety, appearance. Bank. Bank means an organization that is engaged in the business of banking. The term includes savings bank, savings and loan associations, credit unions, and trust companies. See also person. UCC 9-102, Section A, Section 8. Bank acceptance. Draft drawn on and accepted by bank. Bouvier's 8th edition. Banker. In general sense, person that engages in business of banking. In narrower meaning, a private person who keeps a bank, one who is engaged in the business of banking without being incorporated, one who carries on the business of banking by receiving money on deposit with or without interest, by buying and selling bills of exchange, promissory notes, bonds or stock, other securities, and by loaning money without being incorporated. Under some statutes, an individual banker, as distinguished from a private banker, is a person who, having complied with the statutory requirements, has received authority from the state to engage in the business of banking, while a private banker is a person engaged in banking without having any special privileges or authority from the state. Black's Law Dictionary, 6th edition. See private banker. Banker's acceptance. A bill of exchange, draft payable at maturity that is drawn by a creditor against his or her own debtor. Banker's acceptances are short-term credit instruments most commonly used by persons or firms engaged in international trade. They are comparable to short-term government securities, for example, treasury bills, and may be sold on the open market at discount. Black's Law Dictionary, 6th edition. A bill of exchange drawn on and accepted by a commercial bank. Black's Law, 7th edition. See bank, banker, private bank. House Joint Resolution 192 of June 5th, 1933. Banker's Note. A commercial instrument resembling a banknote in every particular, except that it is given by a private banker or unincorporated banking institution. Black's Law Dictionary, first edition. See banker, private bank. Bankruptcy, popularly defined as insolvency, the inability of a debtor to pay his debts as they become due. Technically, however, it is the legal process under the Federal Bankruptcy Act by which assets of the debtor are liquidated as quickly as possible to pay off his creditors and to discharge the bankrupt, or free him of his debts so he can start anew. In reorganization, on the other hand, liquidation may be avoided and the debtor may continue to function, pay his creditors, and carry on business. Barron's Third. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization in world history, the U.S. government. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Statute 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. H.J.R. 192, 73rd Congress in session, June 5, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States and the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government assists today in name only. Congressional Record, March 17, 1993, Volume 33, see Chapter 11, Reorganization. Bar 1. A partition or railing running across a courtroom, intending to separate the general public from the space occupied by the judges, counsel, jury, and others concerned in the trial of a cause, the whole body of attorneys and counselors, or the members of the legal profession collectively, who are figuratively called the bar. They are thus distinguished from the bench, which term denotes the whole body of judges. Black's Law Dictionary, 6th edition. Barratry. In maritime law, an act committed by the masters or mariners of a vessel for some unlawful or fraudulent purpose contrary to their duty to the owners, whereby the latter sustain injury. It may include negligence, if so gross as to evidence fraud. In criminal law, common barratry is the practice of exciting groundless judicial proceedings. Black's Law Dictionary, 1st edition. See note. Note. Both definitions apply equally in the courtroom. In the first, the master is the judge. In parentheses, in some jurisdictions, judges are called masters. The mariners are the attorneys. The vessel is your trade name. The only rightful owner of the vessel is you, and the injury to you, the owner, is the loss of wealth or freedom. In the second, the judges and attorneys proceed against you without the requisite claim to do so, acting on behalf of fictitious entities, i.e., corporations / governments. Per Erie Railroad v. Tompkins, 1938, 304 U.S. 64-92. The bankruptcy of 1933 had placed everything under the 14th Amendment. Erie's ruling that there was no more general federal common law was open admission of anarchy, tyranny. Law and contracts fell under a private colorable law merchant in colorable admiralty maritime law, the special federal common law. See special of the Uniform Commercial Code. Issues are decided in general. See general equity, conscience of the court, not special equity. Explicit terms of express contracts, adopting private commercial paper as money, resulted in an at law mixture of public maritime bankruptcy, equity, etc. In the same court, the judge moves between one and the other as the situation indicates, including shifting from equity into admiralty in order to impose criminal penalties in civil matters. This is why you must post a bond, something normally reserved for civil proceedings, on a misdemeanor traffic citation, a criminal proceeding, in parentheses, even though the matter is actually civil in nature, arguing the Constitution is frivolous, since one has long since consented with what is happening. End note. Bearer. Bearer means the person in possession of an instrument, document of title, or certificate security payable to bearer, or endorsed in blank. UCC 1-201, Section 5. Bill. Commercial transactions. A written statement of the terms of a contract or specification of the items of a contract or of a demand. Also, a general name for any item of indebtedness, whether receivable or payable. Black's Law Dictionary, 6th edition. Also, the creditor's written statement of his claim, specifying the items. In mercantile law, the creditor's written statement of his claim, specifying the items. It differs from an account stated in this, that a bill is the creditor's statement. An account stated is a statement that has been assented to by both parties. Bouvier's 8th edition. Bill of exchange. A written order from A to B, directing B to pay C a certain sum of money therein named. A bill of exchange is an instrument, negotiable in form, by which one, who is called the drawer, requests another, called the drawee, to pay a specified sum of money. A bill of exchange is an order by one person, called the drawer, or maker, to another, called the drawee, or acceptor, to pay money to another, in parentheses, who may be the drawer himself, called the payee, or his order, or to the bearer, if the payee or a bearer transfers the bill by endorsement. He then becomes the endorser. Black's Law, 1st edition. See note, payee. It has recently been discovered that the IRS has its own bank account, in parentheses, semi-secret, called a Treasury Tax and Loan Account, or TTL, in every banking / financial institution that deals in Federal Reserve notes. It has also been verified that the IRS levies are affected from the Special Procedures Function Department, or Office, via simple facts, bill of exchange, instructing the particular bank, saving and loan, credit union, brokerage house, etc., to debit the depositor's / taxpayer's account and credit the TTL. Bill of lading. In common law, the written evidence for the contract and carriage and delivery of goods sent by sea for a certain freight. 1H BL 359. Black's Law Dictionary, 1st edition. See note. Birth. The act of being born or wholly brought into separate existence. Black's Law Dictionary, 1st edition. See note and note at birth record. Note, a man or woman is born. Trade names are wholly brought into separate existence. Each event qualifies as a birth. The birth certificate documents a muddied mixture of the two events that allows the system to both claim that it is your birth certificate, yet also claim to hold legal title of, in parentheses, not ownership of, the corporately colored trade name. Birth certificate, a formal document which certifies as to the date and place of one's birth, and a recitation of his or her parentage, as issued by an official in charge of such records. Furnishing of such is often required to prove one's age. Black's Law Dictionary, 6th edition. See note, birth, birth record, document of title, field warehouse receipt, bond. Note, a birth certificate is a negotiable document, in parentheses see document, a registered security, in parentheses see securities, pedigree chattel, in parentheses see chattel, document that establishes the existence of the straw man, in parentheses see straw man, a distinct artificial person, in parentheses see artificial person, person with fictitious trade name, in parentheses fictitious name, document of title for a straw man, warehouse receipt, in parentheses see field house receipt, for your body, delivery receipt. For many years, the designator, U.S. Department of Commerce, Bureau of the Census, appeared on birth certificates. In America, the original birth document is generally created at county level, in parentheses sometimes at city level, via birth documents from the hospital. The source of the following information is U.S. Vital Statistics System Major Activities and Developments, 1950-95, in parentheses published by U.S. Department of Health and Human Services. Beginning with the 1939 revision, the birth certificate became the standard certificate of live birth, and there have been 11 different subsequent issues of this document. The National Office of Vital Statistics had its beginnings in 1935 when the Division of Vital Statistics, then in the Bureau of the Census, was mandated to promote a cooperative system of vital statistics and vital records. From the earliest days of their existence, the American Bar Association and American Medical Association provided strong support for establishing offices to collect vital statistics. From page 47 of the book, quote, from this time, 1836 forward, the course of registration and vital statistics was to be recognized as basic to the development of public health organization and practice. Part of the motivation of the act was to improve vital records as legal documents for the security of property. End quote. Vital records are legal documents for the security of your private property, your true name, and trade names, whatever name appears on the documents. The source of the following information is the Model State Vital Statistics Act and Regulations 1992 revision, in parentheses, U.S. Department of Health and Human Services. Live birth is defined as follows. Quote, live birth means the complete expulsion or extraction from its mother of a product of human conception, irrespective of the duration of the pregnancy, which after such expulsion or extraction breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. Heartbeats are to be distinguished from transient cardiac contractions. Respirations are to be distinguished from fleeting respiratory efforts or gasps. The National Office of Vital Statistics was established and the Public Health Service in 1946, with the head of the office reporting directly to the Surgeon General, a military commander. This means that collection, maintenance, and dissemination of all vital statistical information are in the hands of the military, as dictated over by the Commander-in-Chief. Section 24 of the Act, copies from the System of Vital Statistics, contains the most revelatory passage. Quote, Section A, the State Registrar, in parentheses, and other custodians of vital records authorized by the state registrar to issue certified copies, end parentheses, shall, upon receipt of an application, issue a certified copy of a vital record in his or her custody, or a part thereof, to the registrant, his or her spouse, children, parents, or guardian, or their respective authorized representative. Others may be authorized to obtain certified copies when they demonstrate that the record is needed for the determination or protection of his or her personal or property right. The state agency may adopt regulations to further define those who may obtain copies of vital records filed under this Act. End quote. Per the Act, all state registrars are merely custodians of property and look after your personal property, i.e., the true name and trade names. You are the rightful owner of that property. The so-called custodian can be lawfully commanded by the rightful owner, in parentheses, you, not to give out the property to anyone else. Such an order would put a permanent roadblock in the path of any who would use the name to make money at any level of government. That property could not be touched by anyone other than the state registrar and you. And you might be able to demand surrender of custodianship of the property and receive it. Note also that the Act uses the non-judicial, in parentheses, common law term authorized representative instead of a statutory term. The American Association of Motor Vehicle Administrators, the American Bar Association, and the National Conference of Commissioners on Uniform State Laws received acknowledgement from the U.S. Department of Health and Human Services for their input in the revision of the Act. In parentheses, end of data from Model State Vital Statistics Act and Regulations. Per the definition of birth above, the document references both the newborn baby and the straw man / trade name. A certified birth certificate may usually be obtained at county / state level, depending on the state in question. Your birth certificate is one-of-a-kind security instrument in which your property is reposed. The first known evidence of government placing a dollar value on people, in parentheses, per head, is contained in the draft of proposed legislation, in parentheses, which is supposed to originate within the legislative branch at House of Representatives from President Abraham Lincoln on July 14th, 1862, contained on page 3285 of Messages and Papers of the Presidents. Quote, fellow citizens of the Senate and House of Representatives, herewith is a draft of a bill to compensate any state which may abolish slavery within its limits, the passage of which substantially as presented, I respectively and earnestly recommend, Abraham Lincoln, in all capital letters, by the way. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that whenever the President of the United States shall be satisfied that any state shall have lawfully abolished slavery within and throughout such state, either immediately or gradually, it shall be the duty of the President, assisted by the Secretary of the Treasury, to prepare and deliver to such state an amount of 6% interest-bearing bonds of the United States equal to the aggregate value at $blank per head of all slaves within such state as reported by the census of the year 1860, the whole amount for any one state to be delivered at once, if the abolishment be immediate, or in equal annual installments, if it be gradual, interest to begin running on each bond at the time of its delivery and not before. And be it further enacted, that if any state, having received any such bonds, shall at any time afterwards by law reintroduce or tolerate slavery within its limits contrary to the act of abolishment upon which such bonds shall have been received, said bonds received by said state shall at once be null and void, in whosoever hands they may be, and such state shall refund to the United States all interest which may have been paid on such bonds. End quote. A man in Santa Barbara, California, who obtained his original birth record / document from the Department of Commerce some years ago via a Freedom of Information Act request, reported endorsements of 17 different foreign countries on the document. There may also be other types of birth documents used by the U.S. government and others to obtain loans of credit. Birth record. Official statistical data concerning dates and places of persons' birth as well as parentage, kept by local government officials. Black's Law Dictionary, 1st edition. See note, birth certificate. Note, under birth certificate, the definition references one's birth, and under birth record, the definition references a person's birth. One means flesh and blood, man / woman. Person means artificial entity / juristic person. See also individual. Blank. See blank endorsement in blank. Blank endorsement, the endorsement of a bill of exchange or promissory note by merely writing the name of the endorser, with cut mentioning any person to whom the bill or note is to be paid, called blank. Because a blank or space is left over it for the name of the insertion of the endorsee or of any subsequent holder, otherwise called an endorsement, in blank. Black's Law Dictionary, 1st edition. Endorser, he who endorses, i.e. being the payee or holder, writes his name on the back of a bill of exchange, etc. Black's Law Dictionary, 1st edition. Endorsee, the person to whom a bill of exchange, promissory note, bill of lading, etc. is assigned by endorsement, given him a right to sue thereon. Black's Law Dictionary, 1st edition. Bona fide purchaser. A bona fide purchaser is a purchaser for value in good faith and without notice of any adverse claim who takes delivery of a security in bearer form, or of one in registered form issued to him or endorsed to him or in blank. UCC 8-302, one who has purchased property for value without any notice of any defects in the title of the seller. Black's Law Dictionary, 6th edition. One who pays a valuable consideration, has no notice of outstanding rights of others, and acts in good faith concerning the purchase. Barron's, 3rd edition. See note. Note. When you consummate the redemption process, you are a bona fide purchaser of your birth certificate and trade name. End note. Bond, a certificate or evidence of a debt on which the issuing company or governmental body promises to pay the bondholders a specified amount of interest for a specified length of time, and to repay the loan on the expiration date. A long-term debt instrument that promises to pay the lender a series of periodic interest payments in addition to returning the principal at maturity. In every case, a bond represents debt. Its holder is a creditor of the corporation and not a part owner, as is the shareholder. Black's Law Dictionary, 6th edition. See also note birth certificate, industrial bond. Note the birth certificate is the bond instrument employed by the government to secure loans. Booty. The capture of personal property by a public enemy on land, in contradistinction to prize, which is a capture of such property at sea. After booty has been in complete possession of the enemy for 24 hours, it becomes absolutely his, without any right of post limini, in favor of the original owner, particularly when it has passed bona fide into the hands of a neutral. The right to booty belongs to the sovereign, but sometimes the right of the sovereign or of the public is transferred to the soldiers to encourage them. Bouvier's 8th edition. See note Vice Admiralty Courts, prize, also prize law. Post limini, post liminim, a fiction of the civil law by which persons or things taken by the enemy were restored to their former status on coming again under the power of the nation to which they formerly belonged. Bouvier's 8th edition. Note, literally and legally, property taken from you by the IRS or the courts is booty. IRS soldiers are encouraged to capture booty by offering them rights in the booty they capture. It is believed the agent on a particular case takes the taxpayer's first 6 payments in toto, in parentheses, and a significant percentage of any lump sum settlement proceeds. It is believed that 1/3 of the booty captured in a maritime vice admiralty court, in parentheses, e.g. traffic court, by the judge ends up in the judge's personal retirement fund. This would also explain the dramatic increase in the application of forfeiture laws and seizure laws in America over the last decade. End quote. Capacity. Legal capacity is the attribute of a person who can acquire new rights, or transfer rights, or assume duties according to the mere dictates of his own will, as manifested in juristic acts, without any restraint or hindrance arising from his status or legal condition, ability, qualification, legal power, or right, applied in this sense to the attribute of persons, in parentheses, natural or artificial, growing out of their status or juristic condition, which enables them to perform civil acts, as capacity to hold lands, capacity to devise, etc. Black's Law Dictionary, 1st edition. Capital letter, adjective, in parentheses, of letters, of the large size used at the beginning of a sentence or as the first letter of a proper name, A, C, E, D. Note, names written in all capital letters are artificially constructed names of artificial persons. See all capital letters written proper. Cash proceeds. Cash proceeds means proceeds that are money, checks, deposit accounts, or the like. Backed up by UCC 9-102, Section A, Section 9. Census. The official counting or enumeration of the people of the state or nation, with statistics of wealth, commerce, education, etc. In Roman law, a numbering or enrollment of the people with a valuation of their fortunes. See note, census, regilis, taxpayer. Note, the first definition, modern, above does not preclude the second, ancient. Please also note that the UCC filing offices operate in the private realm, and that filings therein are not contingent upon the provision of identifying serial numbers, such as Social Security account numbers. Black's Law Dictionary, first edition. Census regalis or regalis, the royal property or revenue. Bouvier's, 8th edition. Certificate, a document in which a fact is formally attested. Black's Law Dictionary, 7th edition. A written assurance or official representation that some fact has or has not been done, or some event occurred, or some legal formality complied with. Black's Law Dictionary, 1st edition. Certificate of Title. Certificate of title means a certificate of title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. UCC 9-102, Section A, Section 10. Certified check. See acceptance of draft. Cestua or cestua, used frequently in composition and law French phrases. Black's Law Dictionary, 1st edition. Cestuaqui trust. Law, French, one who possesses equitable rights and property and receives the rents, issues, and profits from it. Beneficiary. Black's Law Dictionary, 7th edition. He who has a right to a beneficial interest in and out of an estate, the legal title to which is invested in another. The person who possesses the equitable right to property and receives the rents, issues, and profits thereof, the legal estate of which is vested in a trustee. Black's Law Dictionary, 1st edition. See cestua, cestaque use. Note, cestaque trust is French for literally, he that trusts. This particular species of trust is known as a constructive trust and is constructed by operation of law, in parentheses fiat. Such a trust is really only the appearance of a trust, i.e., it only looks as if it is a trust, but has no creator /trustor /grantor /settlor, the flesh and blood party normally responsible for bringing a trust into existence. Per corpus juris secundum, every government is a constructive trust, concerning which Black's Law 5th edition states, a trust raised by construction of law, or a rising by operation of law, as distinguished by an express trust. Constructive trusts do not arise by agreement or from intention, but by operation of law and, in parentheses, and not or, fraud, active or constructive. The U.S. government creates by operation of its law the colorable cestaque trust, and is, as the creator or constructor of the trust, the, in parentheses, non-flesh and blood owner thereof. Every corporate entity, such as your straw man trade name, has two diametrically opposite kinds of status concerning this trust. Every citizen of the United States is simultaneously a co-trustee and co-beneficiary by operation of law. As co-trustee, your straw man has duties and obligations such as paying taxes, obeying laws, and obtaining a license for almost every normal activity of life. As co-beneficiary, your juristic person straw man has benefits, privileges, and opportunities, such as welfare, protection of the state, free delivery of mail, and use of the courts, etc. In court, the judge acts as a executor /administrator over the trust, managing the estates of the people who function as persons through the all capital letters juristic trade names, existing as fictitious entities under limited liability through a court proceeding. The judge decides which corporate debtor entity owes which other corporate creditor entity what money / specific performance, thereby constructing the terms of the construct trust on the spot. The straw man is a non-living and therefore dead entity and, as a citizen of the United States based on the 1933 U.S. bankruptcy, also civilly dead in the law, i.e., no standing in law / insolvent. Such persons are thereby completely foreclosed from accessing substance, law, and sovereignty, and can possess only government-granted limited liability privileges, e.g., a driving privilege. Sesquique use. The person for whose use and benefit property is being held by another, who holds legal title to the property. Black's Law Dictionary, 7th edition. He for whose use and benefit lands and tenements are held by another. The sesquique use has the right to receive the profits and benefits of the estate, but the legal title and possession in parentheses, as well as the duty of defending the same, reside in another. Black's Law Dictionary, 1st edition. CFR, Code of Federal Regulations. Chapter 11, Reorganization. In addition to voluntary and involuntary proceedings in which a debtor is adjudged bankrupt, under Chapter 11 a debtor is permitted to postpone all payments on debts so that he can reorganize his business, while other bankruptcy proceedings seek to have the debtor's assets sold and to have all the creditors paid to the extent possible. Chapter 11 seeks to give the debtor a breathing spell with the hope that his business will recover and all his creditors will be fully repaid. Barron's Law Dictionary, 3rd edition. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization in world history, the U.S. government. James A. Trafficant, Jr., Congressional Record, March 17, 1993, Volume 33. See Note, Bankruptcy. Note, the U.S. government, aka United States, Inc., aka Washington, D.C., is legally bankrupt and in Chapter 11 reorganization. The Secretary of the Treasury is the receiver in bankruptcy, in parentheses, Reorganization Plan Number 26, 1955, USCA 903, Public Law 94-564, Legislative History, page 5967, and runs the corporation on behalf of the creditor, the Federal Reserve. See also United States. Charge. To impose a burden, obligation, or lien, to create a claim against property, to claim, to demand, to instruct a jury on matters of law. An encumbrance, lien, or burden, an obligation or duty, a liability, an accusation, in contracts, an obligation, binding upon him who enters into it, which may be removed or taken away by discharge. Black's Law Dictionary, 1st edition. Charge back, the action of a bank indebting or otherwise revoking a credit given to a customer's account, which credit usually has been given for a check deposited in the account. See Note, Chargeback. Chargeback, Section A. A collecting bank has a security interest in an item in any accompanying documents or the proceeds either. Section 2. In case of an item for which it has been given credit available for withdrawal as of right, to the extent of the credit given, whether or not the credit is drawn upon or there is a right of charge back. UCC 4-210, Section A, Section 2. Note, fiat, a positive and authoritative command that something be done, an order or decree, authorization. And note. Chattel, an article of personal property, any species of property not amounting to a freehold or fee in land. The term chattels is a more comprehensive one than goods, as it includes animate as well as inanimate property. Black's Law Dictionary, first edition. Chattel mortgage, an absolute pledge to become an absolute interest if not redeemed at a fixed time. Chattel paper. Chattel paper means a record or records that evidence both a monetary obligation and a security interest in specific goods. A security interest in specific goods and software used in the goods. A security interest in specific goods and license of software used in the goods. A lease of specific goods or a lease of specific goods and license of software used in the goods. In this paragraph, monetary obligation means a monetary obligation secured by the goods or owed under a lease of the goods and includes a monetary obligation with respect to software used in the goods. The term does not include 1. Charters or other contracts involving the use or hire of a vessel, or 2. Records that evidence a right to payment arising out of the use of a credit or charge card or information contained on or for use with the card. If a transaction is evidenced by records that include an instrument or series of instruments, the group of records taken together constitutes chattel paper. UCC 9-102, Section A, Section 11. Citizen. In American law, one of the sovereign people, a constituent member of the sovereignty, synonymous with the people. Scott v. Sanford, 19 Howe, U.S. 404-15 L.E.D. 691, Bouvier's Law Dictionary, 8th edition. Citizens are members of a political community who, in their associated capacity, have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. Black's Law Dictionary, 6th edition. Civil law, that body of law which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. The system of jurisprudence held and administered in the Roman Empire, particularly as set forth in the compilation of Justinian and his successors, comprising the Institutes, Code, Digest, and novels, and collectively denominated the Corpus Juris Civilis, as distinguished from the common law of England and canon law. Black's Law Dictionary, 6th edition. See municipal, citizen, compare common law. Claim, a challenge of property or ownership of a thing which is wrongfully withheld, to demand as one's own, to assert a right or title. Black's Law Dictionary, 4th edition. See note. Note, a claim is a dispute over title, most fundamentally concerning who holds the legal title to your trade name. The holder of legal title to your trade name is the master and creditor. Your straw man is the slave and debtor. We must reclaim and reunite right and title to our straw man in order to dissolve the bonds of indentured servitude. The subject / citizen is the straw man. You are the sovereign, per the UCC. Acquiring rights evidences value. You acquired rights to title of your straw man at the moment of his birth. See value. Droit. Clearfield Trust Doctrine. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen. Where private corporate commercial paper, Federal Reserve notes, and securities, checks, is concerned, for purposes of suit, which corporations and individuals are regarded as entities entirely separate from government. Clearfield Trust Company versus United States, 318 U.S. 363-371, 1942. Stare decisis. Latin, to stand by things decided. The doctrine of precedent, under which it is necessary for a court to follow earlier judicial decisions when the same points arise again in litigation. Client. A client is one who applies to a lawyer or counselor for advice and direction in a question of law, or commits his cause to his management in presenting a claim or defending against a suit in a court of justice. One who retains the attorney is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. Corpus Juris Secundum, 1980, Section 4. See note, attorney and client. Note, clients are wards of the court, i.e., infants and persons of unsound mind. The scarecrow / straw man in The Wizard of Oz was a person of unsound mind. The wards of court, attorney and client, Wizard of Oz. The Code. A system used for brevity or secrecy of communication, in which arbitrarily chosen words, letters, or symbols are assigned definite meanings. Webster's, a collection of compendium or revision of laws. A complete system of positive law, scientifically arranged and promulgated by legislative authority. Black's Law Dictionary, 4th edition. All law today is code, and as such must be deciphered / decoded. Code of Federal Regulations. The annual of executive agency regulations published in the Daily Federal Register, combined with previously issued regulations that are still in effect. Abbreviation CFR. Code of Hammurabi. The oldest known written legal code produced in Mesopotamia during the rule of Hammurabi, who reigned from 1792 to 1750 BC. Black's Law, 7th edition. A king of Babylonia who expanded his kingdom into the first great Babylonian empire. He also established one of the earliest written collections of law. Hammurabi based his code of laws on older collections of Sumerian and Akkadian laws, which he revised and expanded. One principle of the code of Hammurabi is that the strong shall oppress the weak. The code begins with a prologue introduction celebrating Hammurabi's military victories. He promises to treat conquered peoples justly and says he honors their gods. The provisions of the code cover many legal matters, including false accusation, witchcraft, military service, land and business regulations, family laws, tariffs, wages, trades, loans, and debts. The World Book Encyclopedia, 2000. Collateral. Collateral means the property subject to a security interest or agricultural lien. The term includes all of the following: A. Proceeds to which a security interest attaches. B. Accounts, chattel paper, payment intangibles, and promissory notes that have been sold. C. Goods that are subject of a consignment. UCC 9-102, Section A, Section 12. Anything that is used to guarantee the payment of a loan or the fulfillment of some other obligation. See note. Note, the property subject to a security interest. The collateral is your trade name and, by implication, your body, labor, and property. Your birth certificate is chattel paper, in parentheses, a security. Accounts does not exclude Social Security account numbers. The U.S. government has a legal security interest in both your trade name and the Social Security account number. Color. Semblance, disguise. Color is often used to designate the hiding of a set of facts behind a sham, taking advantage of the confidence but technically proper legal theory or legal right. Barron's, 3rd edition. See Color of Law. Color of law, the appearance or semblance, without the substance, of legal right, misuse of power, possessed by virtue of state law, and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Black's Law Dictionary, 5th edition. Colorable, that which is in appearance only, and not in reality, what it purports to be, hence counterfeit, feigned, having the appearance of truth. Black's Law Dictionary, 5th edition. In the law of trademarks, this phrase denotes such a close or ingenuous imitation as to be calculated to deceive ordinary persons. Black's Law Dictionary, 5th edition. Note, colorable equals phony. Commerce. The exchange of goods, productions, or property of any kind, the buying, selling, and exchanging of articles, the transportation of persons or property by land, water, and air, the various agreements which have been for their object facilitating the exchange of the products of the earth or the industry of man with an intent to realize a profit. Black's Law Dictionary, 1st edition. An interchange of goods or commodities, especially on a large scale between different countries, foreign commerce, or between different parts of the same country, domestic commerce. Sexual intercourse, Webster's Dictionary. Commerce is a term of the largest import. It comprehends intercourse for the purpose of trade in any and all its forms, including the transportation, purchase, sale, and exchange of commodities between the citizens of our country and the citizens or subjects of other countries, between the citizens of different states. The power to regulate it embraces all the instruments by which such commerce may be conducted. Black's Law Dictionary, 1st edition. The exchange of goods, productions, or property of any kind, the buying, selling, and exchanging of articles. Intercourse, by way of trade and traffic between different peoples or states, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities and agencies by which it is promoted, and the means and appliances by which it is carried on, and transportation of persons as well as of goods, both by land and sea, also interchange of ideas, sentiments, etc., as between man and man. Black's Law Dictionary, 5th edition. See note, maxims of commerce. Note, commerce in everyday life is the vehicle or glue, in parentheses bond tissue, that holds or binds the corporate body politic, in parentheses society as a whole, together, per Title 27 United States Code USC Statute 72.11. All crime is classified as commercial in nature. This is Admiralty jurisdiction. See UCC definition of defendant in the glossary and the item entitled prisoners, prisons, and courts, as well as the above mentioned 27 USC 72.11 under crime is commerce. An appendix for examples of this, more specifically, commerce consists of a mode of interacting, doing business, resolving disputes, etc., whereby all matters are executed under oath, certified on each party's commercial liability by sworn affidavit, and what is intended to possess the same effect as true, correct, and complete, not misleading, the truth, the whole truth, and nothing but the truth. This affidavit format is usually required in written matters, such as an IRS Form 1040, an application form for a driver's license, voter registration, a Treasury Direct account, a notary's copy certification by document custodian form, and on nearly every single document upon which those in the system desire others to be bound/obligated. Such means of signing as a sworn oath, i.e. affidavit, executed under penalty of perjury, true, correct, and complete. Whereas in a court setting, testimony, in parentheses, oral affidavit, is stated in judicial terms by being sworn to the truth, the whole truth, and nothing but the truth, so help me God. In addition to asserting all matters under solemn oath of personal, commercial, financial, and legal liability for the validity of each and every statement, the participant must provide material evidence, i.e., ledgering/bookkeeping, proving the truth, validity, relevance, and verifiability of each and every particular assertion to sustain credibility. In society, commerce comes before and is more essential than a legal system, and can exist independently of and function without need of legal systems. Commercial law, the non-statutory variety as presented in maxims 1 through 10 under maxims of commercial law, is the economic extension of natural law into man's social world and is universal in nature. See maxims of commercial law. Commercial law, a phrase used to designate the whole body of substantive jurisprudence, in parentheses, e.g., Uniform Commercial Code, Truth in Lending Act, applicable to the rights intercourse of persons engaged in commerce, trade, or mercantile pursuits. Black's Law Dictionary, 6th edition. See Note of Commerce, Maxims of Commercial Law. Note, commercial law is the economic extension of natural law into man's social world and deals with the fundamental principles of human interaction concerning proof of claim, in parentheses, dispute over title, and resolution of disputes. The fundamental purpose of commercial law is to maintain the commercial harmony, integrity, and continuity of society, sometimes also stated as to maintain the peace and dignity of the state. Over the millennia, these principles have been discovered through experience and distilled and codified into 10 fundamental maxims. There is no legal issue or dispute possible which is not a function of one or more of these principles. The 10 maxims underlying commerce and all commercial law, including the UCC, are listed above under commerce, The UCC is a particular codification of commercial law orientated towards the contemporary legal, financial, monetary, and banking systems. The entirety of world commerce now functions in accordance with the UCC version of commercial law. Commercial tort claim. Commercial tort claim means a claim arising in tort with respect to which either of the following conditions is satisfied. A. The claimant is an organization. B. The claimant is an individual and both of the following conditions are satisfied regarding the claim. 1. It arose in the course of the claimant's business or profession. 2. It does not include damages arising out of personal injury to or the death of an individual. Found in UCC 9-102, Section A, Section 13. Common law. The common law is that which derives its force and authority from the universal consent and immemorable practice of the people, and has never received the sanction of the legislator by an express act, which is the criterion by which it is distinguished from the statute law. It has never been reduced to writing. By this expression, however, it is not meant that all those laws are at present merely oral, or communicated from former ages to the present solely by the word of mouth, but that the evidence of our common law is contained in our books of reports, and depends on the general practice and judicial adjudications of our courts. 2. The common law is derived from two sources, the common law of England and the practice and decision of our own courts. In some states, the English common law has been adopted by statute. There is no general rule to ascertain what part of the English common law is valid and binding. To run the line of distinction is a subject of embarrassment to courts, and the want of it a great perplexity to the student. It may, however, be observed generally that it is binding where it has not been superseded by the Constitution of the United States, or of the several states, or by their legislative enactments, or varied by custom, or where it is founded in reason and consonant to the genius and manners of the people. 3. The phrase common law occurs in the 17th article of the amendments of the Constitution of the United States. In suits at common law, where the value in controversy shall not exceed $20, says that article, the right of trial by jury shall be preserved. The common law here mentioned is the common law of England, and not of any particular state. The term is used in contradistinction to equity, admiralty, and maritime law. 4. The common law of England is not in all respects to be taken as that of the United States or of the several states. Its general principles are adopted only so far as they are applicable to our situation. Bouvier's Law Dictionary, 6th edition. Note: system of jurisprudence that originated in England and was later applied in the United States and the several states, originally based on the procedures developed by free, sovereign, allodial landowners to resolve disputes over land, such as borders and ownership. After the Norman Conquest of 1066, common law came to be based on judicial precedent, in parentheses court decisions, that was increasingly absorbed into the crown. By such means, what is called common law in name became increasingly Roman civil law. The true common law is completely independent of all governmental involvement. All governments are variants of Roman civil law, the law of kings, princes, and rulers. Nevertheless, common law remained based on transmitted, established principles rather than legislative enactment, in parentheses statutes, statutory law, codes. Great care should be used concerning the precise manner in which the term common law is defined, understood, and used. One should ascertain the implication of the words, e.g., what law is common where and to what. Traditionally, in the absence of statutory law regarding a particular subject, the judge-made rules of common law are the laws on that subject. Thus, traditional phrase at law refers to the state of the law in a particular field prior to the enactment of legislation in that field. Compare statute and Roman civil law. Communicate. Communicate means to do any of the following. A. To send a written or other tangible record. B. To transmit a record by any means agreed upon by the person sending and receiving the record. C. In the case of transmission of a record, to do or by a filing office to transmit a record by any means prescribed by filing office rule. UCC 9-102, Section A, Section 18. Complaint. In civil practice, in those states having a code of civil procedure, the complaint is the first or initiatory pleading on the part of the plaintiff in a civil action. It corresponds to the declaration in the common law practice. In criminal law, a charge preferred before a magistrate having jurisdiction that a person named in parentheses or an unknown person has committed a specified offense with an offer to prove the fact to the end that a prosecution may be instituted. It is a technical term descriptive of proceedings before a magistrate. The complaint is an allegation made before a proper magistrate that a person has been guilty of a designated public offense. Black's Law Dictionary, 1st edition. Note, a private man cannot commit a public offense. Only a public man, in parentheses, straw man trade name, can commit a public offense. And note, Conference of Governors, March 6th, 1933. Note, accommodation of the federal bankruptcy, whereby the governors of the 48 several states of the Union pledged their faith and credit to the aid of the national government, and thereafter formed numerous socialist programs such as the Council of the State Governments, Social Security Administration, etc. Purportedly to deal with the economic emergency, they operated under the Declaration of Interdependence of January 22nd, 1937, and published some of their activities in the Book of the States, Volume 2, page 144. See in this state. Constitutor. In civil law, he who promised by a simple pact to pay the debt of another, and this is also a principal obligation in civil law. One who, by a simple agreement, becomes responsible for the payment of another's debt. Black's Law Dictionary, 1st edition. Latin and orderer, arranger, Roman law. A person who, by agreement, becomes responsible for the payment of another's debt. Black's Law, 7th edition. Note, when you sign a traffic ticket, you become the constitutor for the debt created by the policeman. In parentheses, see Senate Document 43, 73rd Congress, First Session, and House Joint Resolution 192 of June 5th, 1933, for clarification of why this is so. Money is brought into existence by borrowing. The cop creates the new money by issuing a charge in his name. In parentheses, he signs the ticket first. His intent is to transfer the debt to you as constitutor. If you adopt the role of authorized representative or agent, you incur no liability for signing, because you are not signing as a principal. Signing the ticket by order of name, in parentheses, name of cop, John Henry Doe, by John Henry Doe, authorized representative or agent, leaves you without responsibility for payment / performance, as you are not a constitutor. See how to sign your signature without liability on page 310 and section 10 for further explanation. Constructive, that which is established by the mind of the law in its acts of construing facts, conduct, circumstances, or instruments. That which has not the character assigned to it in its own essential nature, but acquires such character in consequence of the way in which it is regarded by a rule or policy of law, hence, inferred, implied, made out by legal interpretation. The word legal being used sometimes in lieu of constructive. Black's Law Dictionary, 4th edition. Note: Corpus Juris Secundum defines a government as a constructive trust. Black's Law Dictionary, 5th edition, defines constructive trust as a mixture of law and fraud. Today, all courts are private commercial tribunals collecting from the assets, i.e., every citizen of the United States, in the Chapter 11 reorganization in bankruptcy of the U.S. As such, every court today is a court of general equity, wherein the judge can pick and choose from any body of law on earth informing his decision, with the final basis of decision-making being the conscience of the court, in parentheses, meaning whatever the judge feels. All such courts are corporate contract courts, dealing with fictitious entities and contracts between them. The straw man of each disputant or party to controversy is within the bankruptcy and the corporate U.S., which is a public trust under the 14th Amendment. Such an arrangement has only two parties, co-trustee and co-beneficiary. A public trust has no creator / trustor / grantor / settlor, as with an express trust, in parentheses, which involves three parties, not two, as with a public trust. In sifting, sorting, and selecting from the law and facts of a case, a judge forms a constructive trust in which the judge constructs the terms of the particular trust contract emerging out of the dispute. A trustee of a public trust has duties and obligations. A beneficiary receives or derives benefits from the trust. Every straw man trade name today has duties as a co-trustee, along with privileges as a co-beneficiary of the public trust. Consequently, in every court case today, the judge is constructing the terms of the constructive trust to decide which straw man owes the other straw man what recompense / specific performance. Consumer goods. Consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes. UCC 9-102, Section A, Section 23. Note: per this definition, an automobile used primarily for personal, family, or household purposes qualifies as consumer goods. Consumer transaction. Consumer transaction means a transaction in which 1. An individual incurs an obligation primarily for personal, family, or household purposes. 2. A security interest secures the obligation, And 3, the collateral is held or acquired primarily for personal, family, or household purposes. The term includes consumer goods transactions, UCC 9-102, Section A, Section 26. Assignments of commercial deposit accounts are governed by revised Article 9, although assignments of deposit accounts in consumer transactions remain excluded. Notes Penelope Christopherou of Cleary, Gottlieb, Steen and Hamilton in New York City. The definition of consumer transaction and revised Article 9 does not include a monetary component, she says, and as a result, certain pledges of deposit accounts by high net worth individuals in transactions entered into for personal, family, or household purposes would be excluded from revised Article 9's coverage, notwithstanding the size of the financing. William C. Smith, ABA, the American Bar Association, Journal, August 2001, page 54. Note, assignment of deposit, in parentheses, checking, savings, passbook, time, accounts in transactions entered into primarily for personal, family, or household purposes are not addressed in revised Article 9. Contract. An agreement between two or more persons which creates an obligation to do or not to do a particular thing. Its essentials are competent parties, subject matter, a legal consideration, mutuality of agreement, and mutuality of obligation. Black's Law Dictionary, 5th edition. Note, all contracts, whether express or implied, are subject to the universal essentials of contract law, pertaining to the fundamentals of the interaction between the parties. These fundamentals are well codified in many places, e.g., the California Civil Code, sections 1549, ET-SEQ. Statute 1549, Contract. What? A contract is an agreement to do or not to do a certain thing. 1550. Essential elements of contract. It is essential to the existence of a contract that there should be 1. Parties capable of contracting. 2. Their consent. 3. Lawful object. And 4. A sufficient cause or consideration. Statute 1556. Who may contract? All persons are capable of contracting, except minors, persons of unsound mind, and persons deprived of civil rights. Statute 1565. Essentials of consent. The consent of the parties to contract must be 1. Free, 2. Mutual, and 3. Communicated by each to the other. 1567. An apparent consent is not real or free when obtained through 1. Duress, 2. Menace, 3. Fraud, 4. Undue influence, or 5. Mistake. Statute 1598. When contract wholly void, where a contract has but a single object, and such object is unlawful, whether in whole or in part, or wholly impossible of performance, or so vaguely expressed as to be wholly unascertainable, the entire contract is void. Statute 1608. Effect of its illegibility. If any part of single consideration for one or more subjects, or of several considerations for a single object, is unlawful, the entire contract is void. Statute 1620. Express contract what? An express contract is one, the terms of which are stated in words. Statute 1621. Implied contract what? An implied contract is one, the existence and terms of which are manifested by conduct. Statute 1441. A condition in a contract, the fulfillment of which is impossible or unlawful within the meaning of the article on the object of contracts, or which is repugnant to the nature of the interest created by the contract, is void. Statute 1636. Contracts. How to be interpreted. A contract must be so interpreted as to give effect to the mutual intention of the parties as it existed at the time of contracting, so far as the same is ascertainable and lawful. Statute 1668. Certain contracts unlawful. All contracts which have for their object, directly or indirectly, to exempt anyone from responsibility for his own fraud, or willful injury to the person or property of another, or violation of law, whether willful or negligent, are against the policy of the law. Statute 1709. Fraudulent deceit. One who willfully deceives another with intent to induce him to alter his position to his injury or risk is liable for any damage which he thereby suffers. Contribution. Contracts, when two or more persons jointly owe a debt, and one is compelled to pay the whole of it, and others are bound to indemnify him for the payment of their shares. This indemnity is called a contribution. Bouvier's 6th edition. When one of several debtors pay a debt, the creditor is bound in conscience, if not by contract, to give to the party paying the debt all his remedies against the other debtors. Bouvier's 6th edition. A right to contribution exists in the case of debtors who owe a debt jointly, which has been collected from one of them. Bouvier's 8th edition. The right that gives one of several persons who are liable on a common debt the ability to recover rateably from each of the others when that one person discharges the debt for the benefit of all. Black's Law Dictionary, 7th edition. War contribution. Black's Law, 7th edition. See War Contribution, Ponzi Scheme, The Curse of Co-Suretyship in Part 1 of this manual. Convey. To transfer as property or title to property from one person to another. American Heritage Dictionary. Corporation. An artificial person or legal entity created by or under the authority or laws of a state. An association of persons created by statute as a legal entity. The law entreats the corporation itself as a person that can sue and be sued. The corporation is distinct from the individuals who comprise it. Shareholders. The corporation survives the death of its investors, as the shares can usually be transferred. Black's Law, 6th edition. See Corporation Aggregate. Corporation Sole. Public Corporation. Corporation Aggregate. A corporation aggregate is one composed of a number of individuals vested with corporate powers, and a corporation as the word is used in general popular and legal speech, and as defined at the head of this title, means corporation aggregate. Corporation Sole. A corporation consisting of one person only, and his successors in some particular station, who is incorporated by law in order to give his successors in office some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. In this sense, the sovereign in England is a sole corporation. So is a bishop. So are some deans distinct from their several chapters. And so is every parson and vicar. A corporation soul consists of a single person, who is made a body corporate and politic, in order to give him some legal capacities and advantages, and especially that of perpetuity, as a bishop, dean. Black's Law Dictionary, first edition. Compare corporation, aggregate. Corruption. An act done with an intent to give some advantage inconsistent with official duty and the rights of others. The act of an official or fiduciary person who unlawfully and wrongfully uses his station or character to procure some benefit for himself or for another person, contrary to duty and the rights of others. Black's Law, 5th edition. Co-sureties, joint sureties, two or more sureties to the same obligation. Black's Law, 4th edition. Co-suretyship, a surety who shares the cost of performing suretyship obligations with another. Black's Law, 7th edition. Co-suretyship. Coven, a secret conspiracy or agreement between two or more persons to injure or defraud another. Black's Law, 6th edition. A secret contrivance between two or more persons to defraud and prejudice another in his rights. Bouvier's, 8th edition. Covenous, deceitful, fraudulent, having the nature of, or tainted by coven. Black's Law, 6th edition. Credit. The credit of an individual is the trust response in him by those who deal with him that he is of ability to meet his engagements, and he is trusted because through the tribunals of the country he may be made to pay. Black's Law, 1st edition. Note: credit means belief. It comes from the Latin word credere, believe, trust. It is also inextricably linked with one's name. If one examines the above abstract from Black's Law, 1st edition, the inherent fraudulent nature of the current credit system is abundantly clear. The only reason trust is reposed in anyone by the folks at the Federal Reserve is because an individual can be made to pay via the tribunals of the country, a type of transaction requiring no trust, with a built-in insurance policy for the con. Credit equals belief, equals no substance, equals Federal Reserve notes. Creditor. Creditor includes a general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of an insolvent debtor's or assignor's estate. UCC 1-201, Section 12. Note: each type of representative of creditor listed above is, in itself, a precise description of Secretary of the Treasury, who is the official receiver in bankruptcy over the bankrupt U.S. government, in parentheses, Reorganization Plan Number 26, 1950, 5, USCA 903, Public Law 94-564, Legislative History, page 5967. Such also describes the underlings of Secretary of the Treasury, one of whom is the Commissioner of Internal Revenue. In law, in parentheses, the most senior form of codified law on the planet is the UCC. There are only two kinds of people, debtors and creditors. The same is true in any statutory court. Judges and attorneys are also included in this definition. Creditor, per the Internal Revenue Code, also means employer. See note at employer. De facto. In fact, indeed, actually. This phrase is used to characterize an officer, a government, a past action, or a state of affairs which must be accepted for all practical purposes, but is illegal or illegitimate. Thus, an office, position, or status existing under a claim or color of right, such as a de facto corporation. Black's Law Dictionary, 6th edition. Note: the U.S. government is a de facto corporation, in parentheses, bankrupt / insolvent. De jure. Law, Latin, as a matter of law, existing by right or according to law. Black's Law, 7th edition. Descriptive of a condition in which there has been total compliance with all requirements of law, of right, legitimate, lawful, by right and just title. In this sense, it is contrary of de jure. Black's Law, 6th edition. Debt, not defined in the UCC. Debtor. Debtor means any of the following. A person having an interest other than a security interest or other lien in the collateral, whether or not the person is an obligor. B, a seller of accounts, chattel paper, payment intangibles, or promissory notes. C, a consignee. UCC 9-102, Section A, Section 28. A person or business that owes money or is otherwise obligated to another party. Note: your straw man fits in Section A above. A debtor is as enslaved as he is obligated. The Federal Reserve issued credit to the United States government against the all capitals trade name of your straw man shortly after the birth of the two of you, thus incurring the obligation to repay the credit in parentheses Federal Reserve notes that was loaned. However, since the straw man has no body and no means of repaying anything, the burden becomes yours as the physical recipient of all the benefits, in parentheses, transmitting utility benefits, that have been bestowed upon you throughout your entire life in exchange for the government's use of your trade name. Your straw man's all caps trade name is referenced above as your name only because it is a piece of property that you own, in parentheses, but legal title is held by government before redemption. Your straw man's trade name is an artifice existing only by force of / in contemplation of law, and neither references you nor identifies you. Your true name, see true name, written in accordance with the rules of English grammar, more closely identifies you, but is still only another piece of property. See appellation. Default, the omission or failure to fulfill a duty, observe a promise, discharge an obligation, or perform an agreement. In practice, omission, neglect, or failure, when a defendant in an action at law omits to plead within the time allowed him for that purpose, or fails to appear on the trial, he is said to make default, and the judgment entered in the former case is technically called a judgment by default. Black's Law, 1st edition. See defaulter, defendant. Defaulter, one who makes default, one who misappropriates money held by him in an official or fiduciary character, or fails to account for such money. Black's Law, 1st edition. Defendant. Defendant includes a person in the position of defendant in a cross-action or counterclaim. UCC 1-201, Section 13. Delivery. With respect to instruments, documents of title, chattel paper, or certified securities means voluntary transfer or possession. UCC 1-201, Section 14. A voluntary transfer of title or possession from one party to another. A legally recognized handing over of one's possessory rights to another. Whether actual delivery would be cumbersome or impossible. The courts will find a constructive delivery sufficient, provided the intention is clearly to transfer title. Barron's Third. Note: did your mother voluntarily deliver you into the warehouse district/county? Another delivery occurs when the U.S. government accepts the document of title, in parentheses, birth certificate, associated with the trade name/sovereign newborn is pledged/transferred by written endorsement, receiving in return a birth certificate, in parentheses, i.e., token/warehouse receipt/field warehouse receipt as evidence of said delivery/pledge/deposit/transfer. The UCC authorizes your mother to do this as your representative at Section 3-402. Denial: a traverse in the pleading of one party of an allegation of fact set up by the other. A defense. Black's Law, 4th edition. Deposit account. Deposit account means a demand, time, savings, passbook, or similar account maintained with a bank. The term does not include investment property or accounts evidenced by an instrument. Found in UCC 9-102, Section A, Section 29. Dignity. In English law, an honor, a title, station, or distinction of honor. Dignities are a species of incorporeal herediments, in which a person may have a property or estate. Black's Law, 1st edition. 1. The state of being noble, the state of being dignified. 2. An elevated title or position. 3. A person holding an elevated title, a dignitary. 4. A right to hold a title of nobility, which may be hereditary or for life. Black's Law, 7th edition. Note: an attorney's English title of nobility comes from his/her dignity. Discharge, the opposite of charge, hence to release, liberate, annul, unburden, disencumber. In the law of contracts, to cancel or unloose the obligation of a contract, to make an agreement or contract null and inoperative. Discharge is a generic term. Its principal species are rescission, release, accord and satisfaction, performance, judgment, composition, bankruptcy, merger. To satisfy or dismiss the obligations of contract or debt, the method by which a legal duty is extinguished. BDLT 1983. Note: because of the bankruptcy of the U.S. government as memorialized in House Joint Resolution 192 of June 5th, 1933, in parentheses known as the HJR 192, it is no longer possible to pay off/extinguish debts. We used to be able to pay debts using specie, known as gold and silver coin, but that was declared against public policy in HJR 192. Now we can only discharge debts by passing debt paper, in parentheses Federal Reserve notes, as legal tender. Dishonor, a term applied to the non-fulfillment of commercial engagements. To dishonor a bill of exchange or promissory note is to refuse or neglect to pay it at maturity. Bouvier's, 8th edition. In mercantile law and usage, to refuse or decline to accept a bill of exchange, or to refuse or neglect to pay a bill or note at maturity. A negotiable instrument is dishonored when it is either not paid or not accepted, according to its tenor. On presentment for that purpose, or without presentment, where that is excused. Civil Code, California, Statute 3141, Black's Law, 1st edition. Tenor. By the tenor of an instrument signifies the true meaning of the matter therein contained. Cowell, Bouvier's, 8th edition. Disputable presumption. A species of evidence that may be accepted and acted upon when there is no other evidence to uphold contention for which it stands, and when evidence is introduced supporting such contention, evidence takes place as presumption, and there is no necessity for indulging in any presumption. A rule of law to be laid down by the court, which shifts to the party against whom it operates the burden of evidence merely. Black's Law, 6th edition. Note: right to legal title of your straw man is a disputable / rebuttal presumption that was presumed by the U.S. government and can be successfully disputed / rebutted. No one holds a higher claim, title of your trade name than you, because you comprise the sole source of its existence and have acted as surety for its misadventures since you attained the age of majority and became legally responsible for your own actions. District of Columbia, D.C., a territory situated on the Potomac River and being the seat of government of the United States. It was originally 10 miles square and was composed of portion of Maryland and Virginia ceded by those states to the United States. But in 1846, the tract coming from Virginia was retroceded. Legally, it is neither a state nor a territory, but is made subject by the Constitution to the exclusive jurisdiction of Congress. Black's Law Dictionary, 1st edition. A portion of the country, originally 10 miles square, which was ceded to the United States by the states of Virginia and Maryland, over which the national government has exclusive jurisdiction. Bouvier's, 8th edition. Note: a municipal corporation incorporated February 21st, 1871. In parentheses, 16 Statute 419, Chapter 62, 41st Congress, 3rd edition, an act to provide a government for the District of Columbia, reorganized June 8, 1878. 20 Statute 102, Chapter 180, 45th Congress, 2nd Session, an act providing a permanent form of government for the District of Columbia. Document. Document means a document of title or a receipt of the type described in subdivision, Section 2 of Section 7201, UCC 9-102, Section A, Section 30. Note: a birth certificate is a document of title for a trade name. A receipt of the kind described in subdivision 2 of Section 7-201 is a warehouse receipt. Therefore, a birth certificate, a document of title, is a warehouse receipt. See UCC 7-202. Document of title. Document of title includes bill of lading, dock warrant, dock receipt, warehouse receipt, or order for delivery of goods, evidencing that the person entitled under the document has the right to receive, hold, and dispose of the document and the goods it covers. UCC 1-201, Section 15. Note: a birth certificate qualifies as a document of title because it is both a warehouse receipt and a dock receipt. Draft: an order in writing directing a person other than the maker to pay a specified sum to a named person. Drafts may or may not be negotiable instruments, depending on whether the elements of negotiability are satisfied. Draft is synonymous with bill of exchange. Barron's, 3rd edition. Draft means a draft as defined in Section 3-104, or an item other than an instrument that is an order. UCC 4-104, Section 7. An instrument is a note if it is a promise, and is a draft if it is an order. UCC 3-104, Section E. Instrument. Instrument means a negotiable instrument. UCC 3-104, B. Drawee. Drawee means a person ordered in a draft to make payment. UCC 3-103, Section 2. One to whom a bill of exchange or a check directs a request to pay a certain sum of money specified therein. In the typical checking account situation, the bank is the drawee. The person writing the check is the maker or drawer, and the person to whom the check is written is the payee. Barron's, 3rd edition. Compare acceptor. Drawer. Drawer means a person who signs or is identified in a draft as a person ordering payment. UCC 3-103, Section 3. Note: when you sign a check, you are the drawer, and you are ordering your bank, the drawee, to pay a sum certain to the order of the payee. Droit. French, right. 1. A legal right or claim. 2. The whole body of law. Black's Law, 7th edition. Droit, droit. Law, French, double right. History. The unification of the right of possession with the right of property, also termed jus duplicatum, dret, driet. Compare absolute rights. Black's Law, 7th edition. Note: as the Sesteque Trust, this term also comes to us from Norman French attorneys. You have had the right of possession of your juristic straw man trade name your entire life, but you have been denied title. The name is property because it is held in custody elsewhere. In parentheses, State Registrar. The process contained herein unites right of possession with right to hold your property. In parentheses, trade name. Doulocracy. Greek, doulos, servant, kretin, to rule. A government in which servants or slaves have so many privileges that they essentially rule. Also spelled doulocracy. Black's Law, 7th edition. Compare mixed war. Dummy, one who purchases property and holds legal title for another, usually to conceal the identity of the true owner, a straw man. Sham, make-believe, pretended, imitation, person who serves in place of another, or who serves until the proper person is named or available to take his place. In parentheses, e.g., dummy corporate officers, dummy owners of real estate, Black's Law, 6th edition, dummy corporation. Note, your straw man is a dummy and serves in the place of another, you. When the straw man's trade name is called in court and you answer up, you become the proper person and are available to take his place and do. This is how the switch takes place. See also in propria persona. Dummy corporation. Corporation formed for sham purposes and not for conduct of legitimate business, e.g., formed for sole reason of avoiding personal liability. Black's Law, 6th edition. Note, the United States government formed the dummy corporation identified as your trade name in parentheses with neither your mother's not your knowledge, a / consent, for purpose of making you personally liable for repayment of loans of credit from the Federal Reserve. E.g. means exemplia gratia, for example. EID number. Note, EID number is a unique numerical identifier bearing similarity with employer identification number, EIN, and Social Security account number, SSAN, just as IRS and state tax agencies denote the dashless SSAN, e.g., 1, 2, 3, 4, 5, 6, 7, 8, 9, as the account number and case number. We insert a single dash after the fourth digit and call it the EID number, e.g. 1, 2, 3, 4, 5, 6, 7, 8, 9. Once you achieve standing as creditor over your straw man debtor trade name, you also acquire standing as employer because you, as creditor, are accorded the same standing as any other creditor. It is not unfeasible to consider your straw man Social Security account number with a single reposition dash as a unique EID number for you, the new employer. Employee. For purposes of this chapter, the term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of a corporation. Internal Revenue Code, Section 3401, Section D, Subtitle C. Employer. For the purposes of this chapter, the term employer means the person for whom an individual performs or performed any service of whatever nature as the employee of such person, except that 1. If the person for whom the individual performs or performed the services does not have control of the payment of the wages for such services. The term employer means the person having control of the payment of such wages. Internal Revenue Code, Section 3401, Section D, Subtitle C. Employer Identification Number, EID number. Ens legis, a creature of the law, an artificial being, as contrasted with a natural person, applied to corporations, considered as deriving their existence entirely from the law. Black's Law, 4th edition. Note, this is a precise legal description of the all capital letters named straw man trade name. Equity. The application of the dictates of conscience or the principles of natural justice to the settlement of controversies. B. A system of jurisprudence or a body of doctrines and rules developed in England and followed in the United States, serving to supplement and remedy the limitations and the inflexibility of the common law. Aced. More generally, justice. Historically, equity developed as a separate body of law in England in reaction to the inability of the common law courts and their strict adherence to writs and forms of action to entertain or provide a remedy for every injury. The king therefore established the High Court of Chancery, the purpose of which was to administer justice according to the principles of fairness in cases where the common law would give no or inadequate redress. Equity law, to a large extent, was formulated in maxims such as equity suffers not a right without a remedy, or equity follows the law, meaning that equity will derive a means to achieve a lawful result when legal procedure is inadequate. Equity and law are no longer bifurcated, but are now merged in most jurisdictions. Though equity jurisprudence and equitable doctrines are still independently viable, Barron's Law, 3rd edition. Note, this is a very nobly described and apparently altruistic form of law, and may have even been so at one time. Today, equity has much more insidious implications because it is founded entirely on the conscience of the court, i.e., literally whatever the judge wants to do. See Admiralty Law, Vice Admiralty Courts. Note at Barratry. Escrow. A written instrument such as a deed temporarily deposited with a neutral third party, the escrow agent, by the agreement of two parties to a valid contract. The escrow agent will deliver the document to the benefited party when the conditions of the contract have been met. The depositor has no control over the instrument in escrow. In common law, escrow applied to the deposits of instruments for conveyance of land, but now it applies to all instruments so deposited. Money or property so deposited is also loosely referred to as escrow. Barron's 3rd edition. Esquire. Esquire, esquire, squire. French, M.F., esquire, a square shield bearer, squire. Scuterius. Scutum, shield, arius, akin to O.H.G., scidia sheath. A member of the English gentry ranking immediately below a knight. Webster's Third New International Dictionary of the English Language Unabridged, 1976. A man belonging to the higher order of English gentry, ranking immediately below a knight, applied to various officers in the service of a king. In the U.S., the title belongs officially to lawyers. OED, originally a shield bearer or armorer bearer, an attendant on a knight. In modern times, a title of dignity, next in degree below knight and above gentleman. Webster's Revised Unabridged College Dictionary. In English law, a title of dignity, next above gentleman and below knight. Black's Law, 1st edition. See The Truth About Esquires in Part 1, Section 2 of this manual for a full expose. A stop. To stop, bar, or impede. To prevent, to preclude. Black's Law, 1st edition. Estoppel. Party is prevented by his own acts from claiming a right to detriment of other party who was entitled to rely on such conduct and has acted accordingly. An estoppel arises when one is concluded and forbidden by law to speak against his own act or deed. Estoppel is a bar or impediment which precludes allegation or denial of a certain fact or state of facts, in consequence of previous allegation or denial or conduct or admission, or in consequence of a final adjudication of the matter in a court of law. It operates to put party entitled to its benefits in same position as if thing represented were true. Estoppel is or may be based on actual or constructive fraudulent conduct. Admissions or denials by which another is included to act to his injury, agreement on and settlement of facts by force of entering into contract, concealment of facts. Black's Law, 5th edition. ET SEQ et sec, an abbreviation for et sequentia, and the following, thus a reference to P.1 ET SEQ, means page first and the following pages. Black's Law, 1st edition. Ex parte, one side only, by or for one party, done for, in behalf of, or on the application of, one party only. Black's Law, 1st edition. Fault. In the civil law, negligence, want of care, an improper act or omission, injurious to another and transpiring through negligence, rashness, or ignorance. There are 3 degrees of faults: the gross, the slight, and the very slight fault. The gross fault is that which proceeds from inexcusable negligence or ignorance. It is considered as nearly equal to fraud. The slight fault is that want of care which a prudent man usually takes of his business. The very slight fault is that which is excusable, and for which no responsibility is incurred. Black's Law, 1st edition. Federal. Of or pertaining to, or founded upon, and organized by a compact or act of union between separate sovereign states, as 1. By a league for common interest and defense as regards external relations, the internal sovereignty of each member remaining unimpaired, as the Hanseatic League or the German Confederation, or 2. By a permanent act of union founded on the consent of the people duly expressed, constituting a government supreme within the sphere of the powers granted to it by that act of union, as the United States of America. The Constitution of the United States of America is of a very different nature than that of the German Confederation. It is not merely a league of sovereign states for their common defense against external and internal violence, but a supreme federal government or compositive state, acting not only upon the sovereign members of the Union, but directly upon all its citizens in their individual and corporate capacities. Wheaton Elements International Law, Statute 52, page 78. L. B. and Company, 66. From 1776 to 1789, the United States were a confederation. After 1789, it was a federal nation. Standard Dictionary of the English Language. Funk and Wagnalls Company, 1903. Note: observe the last 2 entries above for what they reveal and confirm. 1. That it was acknowledged no later than 1866, in parentheses, date of publication of Elements International Law, that people have both a private, in parentheses, individual, and corporate capacity. This is the essence of the difference between true name and trade name, flesh and blood man and straw man, and 2. The several states were nations/countries unto themselves, and referenced in the plural between 1776 and 1789, but following the unanimous adoption of the Constitution, in parentheses, Rhode Island was last to adopt, May 20, 1790. They were unified into a single federal nation and spoken of in the singular. End note. Federal Insurance Contributions Act, FICA. See the curse of co-suretyship in Part 1 of this manual. Insurance Contribution Ponzi Scheme. Federal Reserve Note. The highest example of a commercial lien is a Federal Reserve note, commonly found in commercial circulation, and is a commercial lien upon the labor and industry of all Americans by the international banking system. See The Fundamental Principles and Process of Commercial Law by Hartford Van Dyke. Note: the monetary unit for most of the world's trade, Federal Reserve Note, FRN, is not defined in law dictionaries, though the former United States notes are FRNs are commercial, military, private, Federal Reserve, reinsurance scrip. They are permanently unfulfilled, irredeemable evidence of debt. All FRNs are loaned/borrowed into existence. It is a closed system and, as in the board game Monopoly, bankrupts and bankruptcies are inevitable. Only the principal amount is loaned/borrowed into circulation. However, because interest payments must be tendered, the only source for these payments is the original principal amount, thereby making it mathematically impossible to ever pay off the total debt of principal plus interest. More FRNs must be borrowed into circulation in order to make interest payments and yet still be able to retire the principal amount of the original loan, thus pushing the borrower further into debt. A never-ending, ever-worsening cycle. Federal Reserve notes are promises to pay, as described above, but they are corporate promises to pay. There is no such thing as personal income. For a comprehensive technical treatment of the nature of Federal Reserve notes, see a memorandum of law, an appendix. Military, pertaining to war or to the army, concerning with war, concerned with war. Black's Law, 6th edition. Note: the Amendatory Act, March 9, 1933, to the Trading with the Enemy Act of October 6, 1917, namely the Emergency Banking Relief Act of March 9, 1933, defined the American people as the enemy, legally, of the United States government because of the U.S. bankruptcy, through which the private international Federal Reserve System became the government, in parentheses, creditor of the United States. Ramifications of bankruptcy, the nature of the Federal Reserve. Reinsurance, sharing of risk among insurance companies. Part of the insurer's risk is assumed by the other companies in return for part of the premium fee paid by the insured. By spreading the risk, reinsurance allows an individual company to take on clients whose coverage would be too great a burden for one insurer to carry alone. Barron's Dictionary of Finance and Investment Terms, 1991. For a comprehensive treatment of how you have become the reinsurer of loans of FRNs, and a chapter of American history that is not taught in schools, see Ramifications of the Bankruptcy, the Nature of the Federal Reserve Notes. Reinsure, to insure under a contract by which a first insurer relieves himself from a part or from all of the risk and devolves it upon another insurer. Ramifications of bankruptcy, the nature of Federal Reserve notes. Scrip, a certificate to be exchanged for goods, as at a company store. Webster's. Note, company store equals any place using FRNs / in U.S. jurisdiction. Federal Rules of Civil Procedure. The rules governing proceedings instituted in the U.S. District Courts. Black's Law, 7th edition. Federal Zone. The terms in this state, and state, and the two capital letter federal postal designation, for example, in parentheses, CA, NY, TX, FL, MA, ME, etc., and the 5-digit ZIP, Zoning Improvement Plan, code signified United States jurisdiction. See in this state, Senate document number 43, 73rd Congress, First Session, District of Columbia, United States, per California Revenue and Taxation Code, Statute 6017, 11,205, 17,018, and 23,034. Feudal, pertaining to feuds or fees, relating to or growing out of the feudal system or feudal law, having the quality of a feud as distinguished from allodial. Black's Law, 1st edition. Fiat, an order or decree, especially an arbitrary one. Black's Law, 7th edition. Fictitious name, a counterfeit, feigned, or pretended name taken by a person, differing in some essential particular from his true name, in parentheses, consisting of Christian name and patronymic, with the implication that it is meant to deceive or mislead. See note. Patronymic, name of the household, /father, /family, surname. Note, opposite of a true name, your all capital letters straw man trade name is a fictitious name created by the bankrupt corporate U.S. government at the time of your birth. See birth, and wholly brought into separate existence via the birth record / document. You have mistakenly believed that the fictitious all capital letters trade name referenced in / identified you when, in fact, it is only a piece of property, in parentheses, corporation, corporately colored, that is inextricably linked with you and your true name. The U.S. government presently holds legal title, original birth document, Ray, the fictitious name, but title is easily recovered by your redemption of the document of title, i.e. the birth certificate. See legal fiction, capital letter, all capital letters written, idem, sonens, artificial person, proper. Field, warehouse receipt, document issued by warehouseman evidencing receipt of goods which have been stored. Such may be used as collateral for loans. Black's Law, 6th edition. Field, mill, a sphere of action or place of contest. B, a battleground. The term field is a military term signifying battleground. The county recorder issues a field warehouse receipt evidencing receipt of goods, newborn baby, which have been stored, delivered, in warehouse, county. The birth certificate is a field warehouse receipt and, as such, may be used as collateral for loans. File number. File number means the number assigned to an initial financing statement pursuant to subdivision A of section 9519 UCC 9-102 A36. Filing office. Filing office means an office designated in section 9501 as the place to file a financing statement UCC 9-102 A37. Financing statement. Financing statement means a record or records composed of an initial financing statement and any filed record relating to the initial financing statement, UCC 9-102, Section A, Section 39, a document filed with the UCC office, or in some cases the county auditor, that details the money and or goods pledged by one party to guarantee the fulfillment of an obligation to another party. WSUG. Fixtures. Fixtures means goods that have become so related to particular real property that an interest in them arises under real property law. UCC 9-102, Section A, Section 41. Flag, law of. In maritime, the law of that nation or country whose flag is flown by a particular vessel. A ship owner who sends his vessel into a foreign port gives notice by his flag to all who enter into contracts with the master that he intends the law of that flag to regulate such contracts, and that they must either submit to its operation or not contract with him. Black's Law, 4th edition. Note: the flag of law, or the law of flag, pertains to the legal and lawful import or use of a nonverbal symbolic notice defining jurisdiction and applicable law. The significance in admiralty and maritime jurisdictions is stated above in quotes and identifies the current legal system in America. This aspect of law more closely approaches the true essence of the nature and significance of names than any other. In a courtroom, the judge wants to recognize only your, all capital letters, flag, in parentheses, i.e., your corporately colored juristic trade name flag. See trademark. Fraud. An intentional perversion of truth for the purpose of inducing another, in reliance upon it, to part with some valuable thing belonging to him, or to surrender a legal right. A false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another so that they shall act upon it to his legal injury. Any kind of artifice employed by one person to deceive another. A generic term embracing all multifarious means which human ingenuity can devise, and which are resorted to by one individual to get advantage over another by false suggestions or by suppression of truth, and includes all surprise, trick, cunning, dissembling, and any unfair way by which another is cheated. Black's Law, 5th edition. Fraud vitiates every transaction in all contracts. Indeed, the principle is often stated, in broad and sweeping language, that fraud destroys the validity of everything into which it enters, and that it vitiates the most solemn contracts, documents, and even judgments. Fraud, as it is sometimes said, vitiates every act, which statement embodies a thoroughly sound doctrine when it is properly applied to the subject matter in controversy, and to the parties thereto, an improper forum. 37. American Jurisprudence, 2nd edition, Fraud, Statute 8. FRCP, see Federal Rules of Civil Procedure. General, pertaining to or designating the genus or class, as distinguished from that which characterizes the species or individual. Universal, not particularized, as opposed to special. Principal or central, as opposed to local. Open or available to all, as opposed to select. Obtaining commonly or recognized universally, as opposed to particular. Universal or unbounded, as opposed to limited. Comprehensible in whole, comprehending the whole, as distinguished from anything applying to or designated for a portion only. Black's Law, 1st edition. General appearance. An appearance for general purposes which waives a party's ability later to dispute the court's personal jurisdiction. Black's Law, 7th edition. General intangibles. General intangibles means any personal property, including things in action, other than accounts, chattel paper, commercial tort claims, deposit accounts, documents, goods, instruments, investment property, letter of credit rights, letters of credit, money, and oil, gas, or other minerals before extraction. The term includes payment intangibles and software. UCC 9-102, Section A, 42. Gentile, of or pertaining any people not Jewish, a person who is not Jewish, especially a Christian. The Torah outlawed the issue, offspring of a Gentile, as that of a beast. In the Talmud, Mik 8, Talmud, referring to Ezekiel, I.C., Jewish Encyclopedia, 1901, Volume 5, page 621. See note, Goy, Goyim, goods. Note, per the Jewish Encyclopedia and the Torah, in parentheses, the first 5 books of the Old Testament, by reference, Gentiles, i.e. non-Jews, are beasts. Good faith. Good faith means honesty in fact and the observation of reasonable commercial standards of fair dealing. UCC 9-102, A 43. Note, good faith is sincere inner intent to be honest, truthful, and open in all aspects of a contract offered or being negotiated. End quote. Goods. Goods means all things that are movable when security interest attaches. The term includes 3. The unborn young of animals. The term also includes a computer program embedded in goods and any supporting information provided in connection with a transaction relating to the program if 1. The program is associated with the goods in such a manner that it is customarily considered part of the goods, or 2. By becoming the owner of the goods, a person acquires a right to use the program in connection with the goods. The term does not include a computer program embedded in goods that consist solely of the medium in which the program is embedded. The term also does not include accounts, chattel paper, commercial tort claims, deposit accounts, documents, general intangibles, instruments, investment property, letter of credit rights, letter of credit, money, or oil, gas, or other minerals before extraction, UCC 9-102, Section A, 44. A term of variable content and meaning, all things which are movable at the time of identification to the contract for sale, investment securities, and things in action, also includes the unborn young of animals. Black's Law, 6th edition. Note: all things which are movable equals newborn children at the time the security interest attaches equals birth and execution / registration of the birth document / certificate. Identification to the contract equals newborn's footprints and informers, (mothers), signature, contract equals birth, certificate. Things in action equals human fetuses, newborn babies, unborn young of animals equals human fetuses, according to Strong's in Goyim below. Goyim equals animals. According to the Jewish Encyclopedia and Gentile above, a Gentile is a beast. See field warehouse receipt, identification of goods, Gentile, Goyim. Goy, goyam, goys, often disparaging a non-Jewish person, Gentile, also goy, Yiddish, Hebrew goy, people non-Jews, goyim, Gentile, goyim, a foreign nation, hence a Gentile, also a troop of animals or a flight of locusts. Gentile, heathen, nation, people, the New Strong's Exhaustive Concordance of the Bible, 1995. Goy, Gentile. Note: literally, Goyim means nation. It is also Jewish slang for cattle or animals. Per Jewish thinking, there are only two nations in the world, the Jewish nation and the Gentile, non-Jewish nation, i.e. Goyim. See Gentile, goods. Guarantor, one who makes a guarantee or gives security for a debt, while a surety's liability begins with that of the principal. A guarantor's liability does not begin until the principal debtor is in default. Black's Law, 7th edition. Guarantee, a promise to answer for the payment of some debt or the performance of some duty in case of the failure of another who is liable in the first instant. Hold harmless agreement, a contract in which one party agrees to indemnify the other. Black's Law, 7th edition. Holder, the holder of a bill of exchange, promissory note, check, or other commercial paper is the person who has legally acquired possession of the same by endorsement or delivery, and who is entitled to receive payment of the instrument. Person who is in possession of a document of title or an instrument or an investment security drawn, issued or endorsed to him or to his order, or to bearer or in blank. Black's Law, 6th edition. With respect to a negotiable instrument, means the person in possession if the instrument is payable to bearer, or, in the case of an instrument payable to an identified person if the identified person is in possession. Holder, with respect to a document of title, means the person in possession if the goods are deliverable to bearer or to the order of the person in possession. UCC 1-201, Section 20. Holder in due course. Holder in due course. A person who in good faith has given value for a negotiable instrument that is complete and regular on its face, is not overdue, and, to the possessor's knowledge, has not been dishonored. Black's Law, 7th edition. In commercial law, a holder of an instrument who took it for value in good faith and without notice of any claim or defense against it. UCC 3-302, Section 1, and who can enforce the instrument free from all claims and personal defenses. UCC 3-305. A payee may be a holder in due course. A holder does not become a holder in due course of an instrument by purchase of it at a judicial sale, or by taking it under legal process, or by acquiring it in taking over an estate, or by purchasing it as part of a bulk transaction not in regular course of business of the transferor. A purchaser of a limited interest can be a holder in due course only to the extent of the interest purchased. Black's Law, 6th edition. Compared. Bona fide purchaser. See note. Note. A holder is not necessarily the holder in due course. Per the first definition above, you are the only one who can be the holder in due course of a negotiable instruments, bearing your straw man's trade name. In commercial law, the phrase holder in due course signifies the operation and standing of one with supreme and irrefutable claim on a negotiable instrument. House Joint Resolution 192 of June 5th, 1933. Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, that a. Every provision contained in or made with respect to any obligation which purports to give the obligee the right to require payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in nor made with respect to any obligation hereafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, and any such coin or currency which at the time of payment is legal tender for public and private debts. Public Law 73-10. See note and note at escrow. Note. As a result of House Joint Resolution 192 of June 5, 1933, HJR 192, a debt can no longer be paid because the only way lawful payment can be made with gold or silver, coin, currency, was made illegal, since the new legal tender consists solely of private Federal Reserve notes, which are private commercial script representing debt. Transference of such script between users merely discharges the relative debt between them. No matter how much exchange of FRNs transpires between users, the debt incurred in the creation of those FRNs still exists, and interest is still owed for the privilege of receiving FRNs, in parentheses, instead of United States notes, in one's corporately colored trade name. One must pay a fine as the surety of the trade name, called income tax, out of the supply of FRNs at one's disposal to the owners of the FRNs. The Federal Reserve Bank, FRB. The more FRNs one acquires, i.e., the more liability one accumulates, the more one is fined. Internal Revenue Service, unregistered foreign collection agency, private accountancy firm, and intelligence gathering unit of the FRB collects the fines. How do FRNs come into existence? The sureties of the trade names, in parentheses, owners of the birth certificates, i.e., American men and women, borrow credit via a pledge. How is the pledge actualized? By signing and promising to pay. Before the bankruptcy in 1933, money was backed by substance. After the wizard, in parentheses, see Wizard of Oz, the conned us out of our unalienable right to pay debts with gold, substance, and hence our sovereignty, there had to be something else to back the currency. The bankrupt U.S. government fabricated a juristic mirror image name from our true name, transmitting utility, inscribed it on our birth certificate, used the birth certificate as a negotiable document of title, in parentheses, a security, for the newly created trade name, and hypothecated our body, labor, and property, see hypothecate, with the Federal Reserve in exchange for credit, gave us transmitting utility benefits in exchange for use of our property, the trade name, thereby hooking us into the cycle and obligating us, our labor, and our property as surety for the loan, all without our knowledge and without our consent. In other words, the bankrupt federal government has hypothecated everything you own, including your labor, for credit, in parentheses, belief, /air, Federal Reserve notes, from the Federal Reserve. All wealth in the nation was nationalized, in parentheses, legally usurped, by the U.S. government, in parentheses, see Executive Order Outlawing Gold in Appendix and Senate Document Number 43, 73rd Congress, First Session. People, as sureties for the trade name, were converted into chattel property, and juristic name straw man was wholly brought into separate existence on our birth certificate and other subsequent documents, such as the Social Security card. The political industrial society was then set up to run strictly via trade names. One can now enjoy the benefits of the American industrial society, buying and selling only in the trade name of one straw man. Before HJR 192, money represented substance. Now, money represents debt because it is issued as credit. How does one obtain money now? By getting a loan of credit, in parentheses, belief, /air, from the creditors in bankruptcy. How does one get such loan? Simply by signing one's signature on a promise to pay. The foundational instrument for all money, the endorsed document, is thereby created, and the FRB creditors issue the credit, purely an accounting procedure against the pledged assets, i.e., you, your labor, and your property. The lender, the FRIB. The Federal Reserve Bank has no stake and no risk in the process. See promissory note for exact text from the Federal Reserve publication. Since the basis of all money creation is the common signature and a promise to pay, this very process can be employed for one's benefit when faced with a demand for payment / performance called a presentment or presentment, and is outlined in the presentment handling section in Part 2 of this manual. If one carefully reads through the legalese above in HJR 192, one can see that no obligee, in parentheses, the one who is owed money, can require payment in a particular kind of coin or currency. The fact that debts can be discharged through the use of FRNs does not also authorize an obligee to require payment in FRNs, and likewise any other particular /specific currency. When an artificial person requires that you pay in FRNs, he is in violation of HJR 192 and acting against public policy. End note. Human being. Sea monster. Ballantyne's Law Dictionary, 1930. Hypothecate. Hypotheca was a term of the Roman law and denoted a pledge or mortgage. Black's Law, first edition. 1. To pledge to a creditor as security without delivering over mortgage. 2. To put in pledge by delivery, as stocks given as security for a loan. Aced. To pledge something as security without turning over possession of it. Hypothecation creates a right in the creditor to have the thing pledged sold in order that the claim may be satisfied out of the sale proceeds. Barron's third edition. To pledge a thing without delivering the possession of it to the pledge, the master, when abroad, and in the absence of the owner, may hypothecate the ship, freight, and cargo to raise money requisite for the completion of the voyage. Your body, labor, and property have been put in pledge, mortgaged, hypothecated to the Federal Reserve creditors, courtesy of the U.S. government borrowing credit, Federal Reserve notes, against your birth certificates. Your body, labor, and property comprise the substance, in parentheses collateral, that guarantees repayment of the loan. The trade name of the straw man is derived from the birth certificate, which has the name inscribed on it, and is used as a security instrument in the transaction. Idem sonans. Sounding the same or alike, having the same sound, a term applied to names which are substantially the same, though slightly varied in the spelling, as Lawrence and Lawrence, and the like. Note, your straw man's trade name, in parentheses in all capital letters, sounds exactly like your true name, in parentheses, initial letters only capitalized. When spoken, when written, however, the two names represent two entirely different entities. One is a legal construct, the name of an artificial person under whose trade name you conduct business. The other is your true name, and references and identifies you, and expresses your standing as a sovereign. Both names constitute property, however, and may be copyrighted under the common law. C. Fictitious name, all capital letters written, proper artificial person. Identification, proof of identity. Black's Law Dictionary, 6th edition. Identification of goods. Goods to which the contract refers even though the goods so identified are not conforming. Such identification can be made at any time and in any manner explicitly agreed to by the parties. UCC Statute 2-505, Black's Law, 6th edition. Note, goods equals people, contract equals birth certificates, non-conforming equals the man or woman described on the original birth document / contract no longer conforms to the identification factors, in parentheses, footprints, eye color, hair color, height, weight, etc., described on the original birth document / contract. Identification can be made at any time equals identification can be made at birth and at any time subsequent thereto, in any manner explicitly agreed to by the parties, equals any way you can be persuaded to accept the accusation and identify yourself with the name on the birth certificate. The mother is the party who usually signs the birth document in the box designated informer or informant per Black's informer or an informer prefers an accusation, in parentheses, a criminal matter. This is the seminal incident of being accused of having / owning / being associated with an all capital letters name. You own the straw man's name, but it neither references nor identifies you. The name that more closely references and identifies you is your true name. The U.S. government holds the title of the trade name in the form of the original birth document until it is redeemed by you. Impairing the obligation of contract. A law which impairs the obligation of a contract is one which renders the contract in itself less valuable or less enforceable, whether by changing its terms and stipulations, its legal qualities and conditions, or by regulating the remedy for its enforcement. To impair an obligation of a contract within prohibition of Article 1, Statute 10, U.S. Constitution, is to weaken it, lessen its value, or make it worse in any respect or in any degree, and any law which changes the intention and legal effect of the parties, given to one a greater and to the other a less interest or benefit, or which imposes conditions not included in the contract or dispenses with the performance of those included, impairs the obligation of the contract. A statute impairs the obligation of a contract when by its terms it nullifies or materially changes existing contract obligations. Black's Law, 5th edition. In bar, C bar. In blank, a term applied to the endorsement of a bill or note where it consists merely of the endorser's name without restriction to any particular endorsee. Black's Law, 1st edition. In personam, Latin, into or against the person. Barron's, 3rd edition. In propria persona, in one's own proper person. Black's Law, 1st edition. In rem, a technical term used to designate proceedings instituted against the thing, in contradistinction to personal actions, which are said to be in personam. Note, all IRS proceedings and actions are in rem under Admiralty law, by definition a subset of the UCC. See UCC 1-103. In this state, Federal Zone, Senate Document Number 43, 73rd Congress, First Session, Conference of Governors, March 6th, 1933. Per California Revenue and Taxation Code, Statutes 6017, 11205, 17018, and 23034, the terms in this state, and state are defined in tax jurisdiction purposes as District of Columbia, aka United States. Accordingly, California is not included in this state within the above cited sections of the California Revenue and Taxation Code. The federal postal designation in all capital letters CA, however, is included in this state. Indirect confession, a confession that is inferred from the defendant's conduct. Black's Law, 7th edition. Individual. The term individual means a citizen of the United States. 5 U.S.C. 552A, Section A, Section 2. Endorsement. Endorsement means a signature other than that as a signer, as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of 1. Negotiating the instrument, 2. Restricting payment of the instrument, or 3. Incurring endorser's liability on the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument, place of the signature, or other circumstances unambiguously indicate that the signature was made for a purpose other than endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. UCC 3-204, Section A. The act of a payee, drawee, accommodation endorser, or holder of a bill, note, check, or other negotiable instrument, in writing his name upon the back of the same, with or without qualifying words, whereby the property in the same is assigned and transferred to another. Black's Law, 1st edition. Endorser. Endorser means a person who makes an endorsement. UCC 3-204 B. He who endorses, i.e., being the payee or holder, writes his name on the back of a bill of exchange, etc. Endorsee, the person to whom a bill of exchange, promissory note, bill of lading, etc. is assigned by endorsement, giving him a right to sue thereon. Information. In practice, an accusation exhibited against a person for a criminal offense without an indictment. An accusation in the nature of an indictment, for which it differs only in being presented by a competent public officer on his oath of office, instead of a grand jury on their oath. In French law, the act or instrument which contains the depositions of witnesses against the accused. Black's Law, 1st edition. Note: the birth certificate fulfills all above definitions of an information. Informer. A person who informs or prefers an accusation against another whom he suspects of the violation of some penal statute. Prefer. To bring before, to prosecute, to try, to proceed with. Thus, preferring an indictment signifies prosecuting or trying an indictment. Black's Law, 6th edition. Note: flesh and blood men and women are ruled neither by penal statutes nor any other kinds of statute, unless they are acting as surety for the trade name, in which case they are held accountable exactly as it would be. Statutes obtain only in the case of artificial persons, such as corporations and corporately colored entities, like the trade name. On some birth certificates, the signatory is listed as informer or informant, a term that carries criminal implications. Legally, a newborn is an undocumented enemy of the state, a public enemy, according to the Amendatory Act, March 9th, 1933, to the Trading with the Enemy Act of October 6th, 1917. Any such informer Usually the mother is informing on, i.e., lodging a formal complaint / accusation by deposition and identification of the baby. If an all capital letters trade name appears on the document, the informer may also prefer an accusation that the name as inscribed is attached to the infant associated therewith. This can serve as the basis for any subsequent insistence that the all capital letters trade name directly concerns you, the flesh and blood man / woman. Instrument. Instrument means a negotiable instrument or any other writing that evidences the right to the payment of a monetary obligation, is not itself a security agreement or lease, and is of a type that in ordinary course of business is transferred by delivery with any necessary endorsement or assignment. The term does not include 1. The investment property, 2. Letters of credit, 3. Writings that evidence a right to payment arising out of the use of a credit or charge card, or information contained on or for use with the card. UCC 9-102, Section A, Section 47. An instrument is a note. If it is a promise and is a draft, if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either UCC 3-104, Section E, instrument means a negotiable instrument, UCC 3-104, B. Insurance. 1. An agreement by which one party, in parentheses the insurer, commits to do something of value for another party, in parentheses the insured, upon the occurrence of some specified contingency, especially an agreement by which one party assumes a risk faced by another party in return for a premium payment. 2. The amount for which something or someone is covered by such an agreement. Black's Law, 7th edition. A contract whereby, for an agreed premium, one party undertakes to compensate the other for loss on a specified subject by specified perils. Bouvier's, 8th edition. Note: FICA, Federal Insurance Contributions Act, i.e., Social Security payroll tax, is not an insurance policy in the name of the party paying the premiums. Inter alia, among other things. Barron's, 3rd edition. Internal Revenue Service, IRS. USC, Title 26, Section 1164, Section 62, Puerto Rico Special Fund, in parentheses Internal Revenue, 73rd Congress, Session 2, Chapter 756, June 26, 1934. Congressional Report, page 1234. Quote, the United States of America, through undersigned counsel, hereby responds to the numbered paragraphs of plaintiffs' complaints as follows. 4. Denies that the Internal Revenue Service is an agency of the United States government. United States answer and claim, November 18, 1993. Betty H. Richardson, United States Attorney. Diversified Metal Products Incorporated vs. T. Bow Company Trust, Internal Revenue Service, and Steve Morgan. As revealed above, IRS is domiciled in Puerto Rico under Secretary of the Treasury of Puerto Rico, aka Secretary of the Treasury. IRS officers, agents, and employees are unregistered foreign agents conducting business in America in violation of the Foreign Agents Registration Act of 1938, per signed brief, in parentheses referenced above, from the United States Attorney. IRS is not an agency of the United States government. Investment property. Investment property means a security, whether certificated or uncertificated. Security entitlement, securities account, commodity contract, or commodity account. UCC 9-104, Section 49. Involuntary suretyship. See suretyship. Jurat. A certification added to an affidavit or deposition stating when and before what authority the affidavit or deposition was made. A jurat typically says, subscribed and sworn to before me this day of month and year. Juristic. Of or relating to law. A corporation is a typical example of a juristic person, pertaining or belonging to, or characteristic of, jurisprudence, or a jurist, or the legal profession. Black's Law, 4th edition. Your corporation of one. Artificial person straw man has a juristic trade name and pertains and belongs strictly to jurisprudence and is a juristic person. Juristic person. Black's Law 7th edition mentions juristic person under the definition of artificial person, which is defined under person. Person, an entity, in parentheses such as a corporation, having the rights and duties of a human being. Artificial person, an entity such as a corporation created by law and given certain legal rights and duties of a human being. A being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. Also termed fictitious person, juristic person, legal person. Black's Law, 7th edition. Note, the legal definition of human being is conveniently missing from the law dictionary containing the above definitions. The difference between a human being and an artificial person has been so blurred, intentionally and legally, by those who enrich themselves at your expense via the legal system, that the two terms are so overlapped they are essentially indistinguishable. Treating people as numbers, corporations, etc., is the order of the day for governments, and the virulent hatred of mankind, espoused by those who dominate the world, has been legally justified through such specious subterfuge as the above definitions. Justiciable, proper to being examined in courts of justice, subject to action of court of justice. Black's Law, 4th edition. Note, matters strictly in the realm of common law and the UCC are not justiciable matters. They are prejudicial, non-judicial matters of private, consensual contract. Kangaroo Court. A sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or other tribunal. Black's Law, 5th edition. Kol Nidre, the opening prayer recited on the eve of Yom Kippur, containing a declaration of the annulment of personal vows and oaths. AHD, all vows, obligations, oaths, and anathemas are called konam, konis, or by any other name which we may vow or swear or pledge, or whereby we may be bound from this day of atonement until the next, in parentheses, whose happy coming we await, we do repent. May they be deemed absolved forgiven, annulled, and void, and made of no effect. They shall not bind us nor have power over us. The vows shall not be reckoned vows. The obligations shall not be obligatory, nor the oaths be oaths. Jewish Encyclopedia, 1901, Volume 5, page 539. Yom Kippur, the Jewish Day of Atonement, a holiday marked by prayer and fasting, celebrated in late September or in October. The Doubleday Dictionary, 1975. Anathema, a formal ecclesiastical ban or curse. Any or also any curse. Funk and Wagnell's New College Standard Dictionary, 1947. Note: Kol Nidre is Hebrew for all vows. Per the Jewish Encyclopedia, any Jew invoking the prayer of Kol Nidre forswears all oaths, vows, obligations, etc. that will be taken in the coming year, thereby absolving himself in advance for dishonoring his sworn oath /word. Children have a similar ritual for playing games wherein a child will cross his fingers and then hide his hand behind his back before giving his word / promising something. When confronting about the truth of his sworn statement, the child reveals that he had his fingers crossed and therefore was under no obligation to tell the truth at the time the oath /vow was given. Potentially extremely dangerous consequences are afoot when dealing with someone who has taken the prayer of Kol Nidre, such as in a courtroom when one is dealing with judges, prosecutors, plaintiffs, and attorneys, as well as in any other honor, contingent, trust-dependent situation, because such devotees essentially have a self-issued license for lying, bearing false witness, and ignoring obligations. Thus, the door is wide open for duplicity, deceit, and betrayal. However, adherents of this practice are nevertheless dependent upon its general unknownness for profiting from its application. Masons, also known to inhabit courtrooms, have a similar dishonor of oaths, in parentheses by the same name, that is called into action for assisting and protecting fellow Masons in legal matters. In parentheses, Masonic Handbook, page 183. The Jewish Day of Atonement, Yom Kippur, as revealed in a comparative article on Islam, Christianity, and Judaism, appearing in the September 24th, 2001 edition of the Los Angeles Times, entitled Articles of the Faiths. Jews make amends and ask forgiveness, in parentheses, for the purpose of restoring relations, only with other Jews, i.e., by being reconciled with each other. Jews are reconciled with God. Law merchant, a system of customary law that developed in Europe during the Middle Ages and regulated the dealings of mariners and merchants in all the commercial countries of the world until the 17th century. Many of the law merchants' principles came to be incorporated into the common law, which in turn formed the basis of the Uniform Commercial Code, also termed Commercial Code, Lex Mercatoria, Black's Law, 7th edition. Law of Nations, a system of rules and principles established among nations and intended for the regulation of their mutual intercourse, otherwise called international law. Black's Law, 1st edition. Law of Nature, see Natural Law. Law of the Flag, see Flag, Law of the Land, Due Process of Law. Legal fiction, something assumed in law to be fact, irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields vs. Fairbanks North Star Borough, 818 P. 2D 658, 1999. Merriam-Webster's Dictionary of Law, 1996. A presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage, fictions arise from the law, and not law from fictions. The real-life dictionary of the law. A legal fiction is an assumption that something that is, in parentheses, or may be, false or non-existent, is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Oren's Dictionary of Law. Assume, to take up or to take responsibility for, to receive, to undertake. 2. To pretend. 3. To accept without proof. Oren's Dictionary of the Law. Assumption, formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, in parentheses, often a house. Per the dictionary, a fiction is something created by the imagination. In the field of law, judges have used their imagination to develop an artifice that allows them to call the truth a lie, and a lie the truth. This particular type of fiction is termed a legal fiction because it is fabricated within the legal profession. Essentially, it is the doctrine of pretending. Judges operate their court based on its let's pretend, and do so with the license, but without the inconvenience of having to inform you of what they have decided to pretend. Judges live in an artificial world based on pretense, lies, and deceit, and are professional dissemblers. A legal fiction is an assumption of purported fact without having shown the fact to be true / valid, i.e., an acceptance with no proof. If one does not wish to be the victim of such chicanery, one must forever be on guard to challenge / rebut a judge's arbitrary presumptions and assumptions, such as the all caps trade name. Also, there is a widespread misconception that a corporation is a legal fiction. A corporation is not a legal fiction, rather, it is a legal fact, but a fictitious entity nevertheless. Dissemble, to conceal or disguise the true nature of, in parentheses, intentions, feelings, etc., so as to deceive. To conceal one's true nature, intentions, etc. Act hypocritically. Legal name, a person's full name as recognized in law, consisting of a first name, usually given at birth or at baptism or christening, and a last name, usually a family name. Note, one's legal name is the name of the legal person recognized in law. The only names recognized in law are those of artificial persons and are written in capital letters. Your straw man's trade name is your true name corrupted into an all capital letters format. Recognized in law equals existing by force of, or in contemplation of. Law equals legal name equals juristic name equals juristic person equals artificial person. Levy, the imposition of a fine or tax, the fine or tax so imposed. 2. The enlistment of soldiers into the military, the soldiers so enlisted. 3. The legally sanctioned seizure and sale of property, the money obtained from such a sale. Verb 1. To impose or assess, in parentheses, a fine or tax, by legal authority. 2. To enlist for service in the military. 3. To declare or wage a war. 4. To take or seize property in execution of a judgment. Black's Law, 7th edition. License. In international law, permission granted by a belligerent state to its own subjects, or to the subjects of the enemy, to carry on a trade interdicted by war. In governmental regulation, authority to do some act or carry on some trade or business. in its nature lawful but prohibited by statute, except with the permission of the civil authority or which would otherwise be unlawful. Bouvier's 8th edition. When the power is exercised by municipal corporations, a license is the requirement by the municipality of the payment of a certain sum by a person for the privilege of pursuing his profession or calling, whether harmful or innocent, for the general purpose of producing a reliable source of revenue. Bouvier's 8th edition. A license fee is a tax. Bouvier's 8th edition. In the law of contracts, a permission granted by a competent authority, conferring the right to do some act with, or which, without such authorization, would be illegal, or would be a trespass or tort. Also, the written evidence of such permission, Black's Law, 1st edition. A permit granted by an appropriate governmental body, generally for a consideration to a person, firm, or corporation to pursue some occupation or to carry on some business subject to regulation under the police power. A license is not a contract between the state and the licensee, but is a mere personal permit. Black's Law, 6th edition. A revocable permission to commit some act that would otherwise be unlawful. Black's Law, 7th edition. See and compare to marquee, mark of the beast. Note, government has, via licensing, statutorily outlawed working and exchanging with others, i.e., the process of surviving, except as a privilege. Privileges can be denied, suspended, and revoked. Licenses are issued only in the name of the artificial person trade name. When one applies for a driver's license, one is doing so in the name of the straw man. And one is also affirming / attesting that the straw man is a driver, in parentheses, a special commercial status, involved in the transportation of persons or property for hire or compensation, an occupation that is a subject of regulation under the police power. Police seek to enforce / maintain person control. Lien. A qualified right of property which a creditor has in or over specific property of his debtor, as security for the debt or charge or the performance of some act. Black's Law, 1st edition. A claim, encumbrance, or charge on the property for payment of some debt, obligation, or duty. Black's Law, 6th edition. A fine imposed pursuant to the provisions of subchapter C of Chapter 227 of this title, and is a lien in favor of the United States. Post-sentence administration 18 U.S.C. Statute 3613, Chapter 229. A charge, hold, or claim upon the property of another as security for some debt or charge. The term connotes the right the law gives to have a debt satisfied out of the property to which it attaches, if necessary by the sale of the property. Barron's 3rd edition. A charge or security or encumbrance upon property. Black's Law, 4th edition. Lien creditor. A lien creditor means any of the following. 1. A creditor that has acquired a lien on the property involved by attachment, levy, or the like. 2. An assignee for benefit of creditors from the time of assignment. 3. A trustee in bankruptcy from the date of the filing of the petition. And 4. A receiver in equity from the time of appointment. B. Lien creditor does not include a creditor who, by filing a notice with the Secretary of State, has acquired only an attachment or judgment lien on personal property, or both. UCC 9-102, Section A, Section 52. Limited liability. Liability restricted by law or contract, especially the liability of a company's owners for nothing more than the capital they have invested in the business. Limited liability is a fabrication and a fraud. No statute of limitations and no limited liability exists in commerce as per the maxims of law. Once a fraud, always a fraud. And a thing void in the beginning does not become valid by lapse of time. A limited liability person is 1. A creature of contract, required to be insured and bonded, bound to and limited by the contractual terms and conditions of the insurance policy and bond created or creating, defining, and underwriting the person's office. 2. Obligated to prove solvency to participate in any public forum and or jurisdiction by providing to any adverse party upon demand a copy of the insurance policy and bond ray said person's office prior to any court proceeding. And 3. Defined by the insurance policy and bond ray the contractual terms and conditions of said person's office, scope of authority, basis of functioning, identity, rank, liability, and solvency. The principles of equality under the law and the integrity of contracts demand that all public officials alleging legal authority to use deadly force exercise scrupulous integrity in the enforcement of the law, said official's administrator, in compliance with contracts referencing and defining oath of office, job description, and the insurance policy and bond that define, limit, and underwrite said official's office. Live birth. Live birth means the complete expulsion or extraction from its mother of a product of human conception, irrespective of the duration of the pregnancy, which after such expulsion or extraction breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. Heartbeats are to be distinguished from transient cardiac contractions. Respirations are to be distinguished from fleeting respiratory efforts or gasps. Model State Vital Statistics Act and Regulations 1992 revision. U.S. Department of Health and Human Services. Note, per above, you are a product of human conception, i.e., goods. Location of debtor. A. Place of business. In this section, place of business means a place where a debtor conducts its affairs. B. Debtor's location. General rules. Except as otherwise provided in this section, the following rules determine a debtor's location. 1. A debtor who is an individual is located at the individual's principal residence. 2. A debtor that is an organization and has only one place of business is located at its place of business. 3. A debtor that is an organization and has more than one place of business is located at its chief executive office. C. Limitation of applicability of subsection B. Subdivision B applies only if a debtor's residence, place of business, or chief executive office, as applicable, is located in a jurisdiction whose law generally requires information concerning the existence of a non-possessory security interest to be made generally available in a filing, recording, or registration system as a condition or result of the security interest obtaining priority over the rights of a lien creditor with respect to the collateral. If subsection B does not apply, the debtor is located in the District of Columbia. UCC 9-307. Maker. Maker means a person who signs or is identified in a note as a person undertaking to pay. UCC 3-103, Section 5. The person who creates or executes a note, that is, issues it, and in signing the instrument makes the promise of payment contained therein. One who signs a check, in this context, synonymous with drawer. Black's Law, 6th edition. Man, a human being. This definition includes not only the adult male sex of the human species, but woman and children. Examples of offenses against man. Some are more immediately against the king, others more immediately against the subject. Hawk, P.C., Book 1, C2, S1. Offenses against the life of man come under the general name of homicide, which in our law signifies the killing of a man by a man. ID, Book 1, C, 8, S, 2. 2. In a more confined sense, man means a person of the male sex, and sometimes it signifies a male of the human species above the age of puberty. Vide repi. It is considered in the civil or Roman law that although man and person are synonymous in grammar, they had a different exception in law. All persons were men, but all men, for example, slaves, were not persons, but things. Vide bar. On the Stat 216, Bouvier's 6th edition. Maritime, pertaining to navigable waters, i.e., to the sea, ocean, Great Lakes, navigable rivers, or the navigation or commerce thereof. Black's Law, 6th edition. Maritime jurisdiction. Jurisdiction over maritime causes is granted to the federal district courts. Procedure in maritime actions is governed by the federal rules of civil procedure and supplement admiralty rules. Maritime law. That system of law which particularly relates to commerce and navigation, to business transacted at sea or relating to navigation, to ships and shipping, to seamen, to the transportation of persons and property by sea, and to Mariani affairs generally. Black's Law, 4th edition. That which the Congress has enacted, or the federal courts, sitting in admiralty, or in the exercise of their maritime jurisdiction, have declared and would apply substantively in the United States. It is federal law, and jurisdiction to administer it is vested in the federal courts, though not to the entire exclusion of the courts of the states. Black's Law, 6th edition. Mark, a license to make reprisals. See letter of marquee. F and W. 1. A symbol of impression or feature on something, usually to identify it or distinguish it from something else. 2. Trademark. 1. 3. Service mark. Black's Law, 7th edition. Compare marque, letters of marque, mark of the beast, service mark, and trademark. Mark of the beast, and that no man might buy or sell save he that had the mark, or the name of the beast, or the number of his name. Revelation 13:17, New Testament. Note, the word mark is synonymous with marquee, and both words have the same etymology. A common definition of the two is a license of reprisal. The definition of license in Black's Law, 1st edition, is, in international law, trade or commerce, permission granted by a belligerent state to its own subjects, or to the subjects of the enemy, to carry on a trade interdicted by war. As we have seen in the Admonitory Act of March 9, 1933, to the Trading with the Enemy Act of October 6, 1917, citizens of the United States were legally classified as enemies of their own government. To do business with its new enemy The U.S. government thereafter instituted wholesale licensing and issued marks /marques or licenses to the subjects of the enemy to carry on a trade interdicted by war, thus enabling American men and women to buy or sell or otherwise engage in trading with the enemy, despite being at war. The chosen masters consider you nothing more than an animal, a beast, see Gentile, to be birthed and bred, herded and harvested, and sold and slaughtered as they see fit. For you, as a beast, to be identified and validated and permitted to buy or sell. In today's industrial society, you must have a special mark, without which you are not allowed to participate. It is interesting that the word mark is also a synonym for the terms service mark and trademark. The special marks used to identify and distinguish the services of a certain provider and products of a certain manufacturer or seller. Marquee or mark, M-A-R-Q-U-E, a letter of reprisal on an enemy, as at sea in wartime, chiefly in the phrase letter of marquee. Maternity Act of 1921. In 1921, the Federal Maternity Act created birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law to improve maternal and infant mortality, for protecting the health of mothers and infants, and for other purposes. One of those other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in the overseeing of its operations and expenditures. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. Maxims of commerce. Commerce is antecedent to and more fundamental to society than courts or legal systems, and exists and functions without respect to courts or legal systems, but not vice versa. Commercial law, the non-statutory variety, as presented below in Maxims 1 through 10, is the economic extension of natural law into man's social world and is universal in nature. The foundational, invariant, necessary, and sufficient principles or maxims of commerce are 1. A workman is worthy of his hire. Exodus 20:15, Leviticus 19:13, Matthew 10:10, Luke 10:7, 2 Timothy 2:6. Legal maxim. It is against equity for free men not to have the free disposal of their own property. 2. All are equal under the law, God's law, moral and natural law. Exodus 21:23 through 25. Leviticus chapter 24, verses 17 through 21. Deuteronomy chapter 1, verse 17. Also Deuteronomy chapter 19, verse 21. Matthew chapter 22, verse 36 through 40. Luke chapter 10, verse 17. Colossians chapter 3, verse 25. Legal maxims. Nobody is above the law. Commerce by the law of nations ought to be common and not to be converted into a monopoly and the private gain of only a few. 3. In commerce, truth is sovereign. Exodus chapter 20, verse 16. Psalms chapter 117, verse 2. John chapter 8, verse 32. 2 Corinthians chapter 13, verse 8. Legal maxim, to lie is to go against the mind. Oriental proverb, of all that is good, Sublimity is supreme. 4. Truth is expressed by means of an affidavit. Leviticus chapter 5, verse 4 through 5. Leviticus chapter 6, verse 3 through 5. Leviticus chapter 19, verse 11 through 13. Numbers chapter 30, verse 2. Matthew chapter 5, verse 33. James chapter 5, verse 12. An unrebutted affidavit stands as the truth in commerce. 1 Peter chapter 1, verse 25. Hebrews chapter 6, verse 13 through 15. Legal maxim: he who does not deny, admits. 6. An unrebutted affidavit becomes the judgment in commerce. Hebrews chapter 6, verse 16 through 17. Any proceeding in court, tribunal, or arbitration forum consists of a contest, or duel, of commercial affidavits wherein the points remaining unrebutted and the end stand as the truth, and the matters to which the judgment of the law is applied. 7. A matter must be expressed to be resolved. Hebrews chapter 4, verse 16. Philippians chapter 4, verse 6. Ephesians chapter 6, verse 19 through 21. Legal maxim: he who fails to assert his rights has none. 8. He who leaves the field of battle first loses by default. Book of Job, Matthew chapter 10, verse 22. Legal maxim: he who does not repel a wrong when he can occasions it. 9. Sacrifice is the measure of credibility. One who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and right to claim authority. Acts 7. Life/death of Stephen. Legal maxim: he who bears the burden ought also to derive the benefit. And 10. A lien or claim can be satisfied only through rebuttal by counter-affidavit, point for point, resolution by jury, or payment. Genesis, verse 2 and 3, Matthew 4. Revelation, legal maxim: if the plaintiff does not prove his case, the defendant is absolved. Because truth is sovereign in commerce, and everyone is responsible for propagating the truth in all speaking, writing, and acting. All commercial processes function via affidavit, certified and sworn on each affiant's commercial liability as true, correct, and complete, attesting under oath the validity, relevance, and veracity of all matters stated and likewise demanded, usually in written matters such as on an IRS Form 1040, 8300, etc., voter registration application, driver's license application, notary form for document certification, application for a Treasury Direct account, and on nearly every document that those who run the system desire anyone to sign in a commercially binding matter. Signature is required under penalty of perjury, true, correct, and complete. In a court setting, however, testimony, in parentheses, oral commercial affidavit, is stated in the judicial equivalent by being sworn to be the truth, the whole truth, and nothing but the truth, so help me God, as well as the need for asserting all matters under solemn oath of personal, commercial, financial, and legal liability for the validity of each and every statement, participant must provide material evidence, i.e., ledgering / bookkeeping, substantiating that each fact or entry is true, valid, relevant, and verifiable. Without said acceptance of liability and facts provided to support one's assertions, no credibility is established, inasmuch as commerce existed before and can continue to exist irrespective of courts and legal systems, but not vice versa. Commerce is a more fundamental aspect of life than courts and legal systems. Medium of exchange. A substance used to transfer energy from one source to another. American Heritage Dictionary. Mission. A definite task assigned to an individual or unit of the armed forces. Apparently, Department of the Treasury, IRS, BATF, CEC, etc., and other quasi-governmental and governmental agencies are de facto military units because they are, or they each, operate off a prescribed mission. Mixed war. Mixed war is war carried on between a nation on one side and private individuals on the other. WNP, Volume 27. Note: mixed war occurs whenever the government of a nation is an enemy of and at war against its own people. The most insidious and perfidious type of mixed war exists when the government acts against the people under guise of protecting the people's rights and upholding the nation's most cherished values and ideals. In such case, government officials are wolves in sheep's clothing, occupying positions of prestige and power with the support of the people, while treasonously betraying that trust. This is an ideal competence game whereby charlatan criminals can engage in piracy on an ongoing basis under color of law and be tolerated or even treated as heroes by their victims.